Welcome to our marathon session on everything about business law. Whether you are a first-year law student or a business student taking law, this long podcast contains everything you need to know in one place. We start by explaining how a business is run. We cover forms of business, limited liability, how to set up a company, finances and accounts. We then shift focus to transactions. We cover sale of goods, agency, marketing, consumer rights. We then move on to troubleshooting business problems, talking about insolvency, dispute resolution, employment law, and CSR. Finally, we address money issues. We explain financial markets, the banker-customer relationship, payment systems, and multinationals. Thank you for being on this journey with me.
Let's try and have a bit of a discussion about what the company is and how it differs from other ways of doing business. Now, imagine this. Let's say that we've got two good friends. Let's call them Yorgos and George. They're both inventors, and they come up with an innovative toilet flush that uses less water than usual. As you can see, I've thought this through really carefully. So it is environmentally friendly. So Yorgos and George, they've made their prototype flush. They tested it. It flushes. They think it fits in with all these ideas about being environmentally sustainable. They think there might be a market for this. They're trying to lobby Greta to go to the UN and talk about toilets and flushes and things. So they think they're going to do great. They've hooked up with a manufacturer who can produce those toilet flushes, and they're thinking about bringing this to market. So they're super excited about this. Now, can they just do this? You don't need a particular license to engage in business with something. This is not something that people are going to eat. This isn't something that has industrial application. So far as I can tell, it isn't something that requires permission for you to be able to sell to people. Food stuff might be a little bit weird because then you need to be careful. But if it's just a candle, a lot of people make candles. Anybody here makes candles? For fun? It's a hobby, apparently, for people with no friends. Right, so I could sell them. I could walk around with the thing in front of the university and say, who would like to buy my nice candles? Or I can, in the front of my house, I can try and sell them. Now, whether this requires permission from the council to put a stall in front of your house, I'm not sure, okay? But you could sell them on eBay. There's nothing preventing you from listing something on eBay for sale. It could be anything. You can just do this. You don't need licenses from the government. You don't need permissions. You don't need to adopt a particular type of business organization that is preset and has a particular recognition in the law. You can just do it. So our friends here, Yorgos and George, could very simply list their toilet flushes on eBay, or they can list them on Amazon Marketplace or on Gumtree or something, right? Any of these platforms that you've got that you can advertise your stuff online and allow the facility for people to pay, and then you just send it to them. This is great. What happens is they're doing this in their own personal capacity. We could argue that they're doing this as sole traders. Who's a sole trader? Somebody who engages in business on their own, by themselves, without doing it through some other mechanism. It's the simple way to do stuff. It could be that, your parents have a corner shop. The corner shop has a name, so it's recognizable, or they've got a kebab shop or something. It doesn't need to be adopting a particular form of business mode to operate. You can just do it yourself. And if the customer doesn't like the product and then wants a refund, then you discuss this directly with them. If the customer uses the product and suffers some sort of damage because the toilet flush doesn't work and kind of floods their bathroom or something, then they might come after you, either in contract because you sold them something that is not that is in violation of the Consumer Rights Act, or in tort if you cause damage to something else, and then you will be personally responsible for what you've done, because if you've given them something that has caused them harm, then that creates a personal responsibility for you. So this is all fine, okay, and it's all normal. And if you find yourselves engaging in any sort of business or commercial activity in those terms, you will be a sole trader. Yorgos and George, the guys with the toilet flush, they're together. They're not together in that sense. Don't get any ideas, but they came up with the thing together. What does this mean? If they're operating as sole traders, how does the fact that they're a unit represent itself to the outside world? Are they a unit? If somebody has any problem, will they be asking them both? Do they have to split the cost if something goes wrong? Or is one of them responsible to the exclusion of the other? How could you tell? So their business, if you want to call it that, in relation to people externally, requires sort of information. Also themselves. What happens if Yorgos wants to produce the toilet flushes in China, but George wants to produce them in Britain? And they cannot agree with each other about what is the way to do. How are they going to get over that? What if they disagree about how the money that they put into the business is separated? What if they disagree about how do you extract the value of what they're doing and how they share the profits? What if Yorgos says, yes, okay, we worked on setting up the website and you really haven't done anything, and I think my contribution is more valuable than yours, therefore I should get more money out of it. Once you start getting groups of people trying to do something, this creates complexity, both in relation to external people they're dealing with and between themselves. So then you might start thinking about something more legal, something more set to govern their relationship. One, they can still operate as sole traders. They can have an agreement right between them. But once they start formalizing what they do, then we might start thinking of them as a partnership and not as people who are doing things individually. So a partnership is precisely a way to organize the relations of people when there's more than one carrying out a common business. It is to organize the relationships between them and also to tell us something about how the rest of the world should approach them. So when you go through your material, you're going to see quite a lot of discussion of what partnerships are and what how they're supposed to run and what does it mean for people. What it basically means is that the partnership is a unit in the eyes of the rest of the world. So if I'm dealing with a partnership, then I'm dealing with them as a community. I'm not dealing with individual people. So if I order my toilet flushes from this partnership and my toilet flush doesn't work and it floods my house, then I'm going to be suing the partnership. Either of them, whichever has the money, is responsible to compensate me. Out of their own money, yes, but it's either one or the other or both of them. I don't care. So Yorgos cannot say, hang on, we're doing this business together, but it was George that made the specs and the specs were wrong that they sent to the manufacturer and that's why it's leaking. Therefore, it's not my fault, it's his. I don't care. I'm the customer. So for me, they're a unit. If we recognize them as a partnership, and partnership is something that is recognized a matter of law. So you are a partnership as a matter of fact. It's because of how you run your business. You don't need to go and say, I would like to register a partnership, please, and get a sign that says I'm a partnership. The law will recognize you as a partnership if this is a reflection of what you've been doing. It means something for me as a client going after them. They're responsible, either both of them or individually responsible to compensate me for the loss. But the partnership also says something about how they run between themselves. It says that they have equal responsibility for management. They've got equal expectation to share in the profits. One cannot seek to exclude the other out of a partnership. They're co-responsible, but they also benefit in a common way out of what's happening. And all this is expressly stated in the law. So it's not Yorgos telling George, this is what I want to do, so this is how I understand the idea of a partnership. There's a lot of law behind it. There's a statute in the Partnerships Act, and there's also quite a lot of case law that has developed to deal with various instances of problems that have come up. If your business is run as a sole trader, your basic understanding of the world is through the law of contract, contractual relationships or tort that's got specific consequences. If you are a community of people that have been recognized as a partnership, then your relationship with the world is understood both in terms of contract and tort, but also through the law that is specifically about partnerships. And you can either run alone as a sole trader, or you can run together with somebody else as a partnership. Doesn't this cover pretty much all eventualities? So where do the companies come in? Companies come in as they came in at some point as a new idea to take collaborative elements of a partnership a step further. This wasn't necessarily obvious what a company should be like and what are the consequences of having a company, but it developed through legislative activity, yes, but also through case law. One of the things that we're going to come back to quite frequently is the idea of Salomon and Salomon, which is from the end of the 19th century. They legislated the idea of a company. They said groups of people that come together now, instead of doing it as a partnership that was well established, they should have the opportunity to do it through this mechanism that we're going to call a company. And this company is going to be a novel way to run this business because it's going to be an entity with certain distinct characteristics. So we're no longer talking about a community of people coming together to pursue some business activity, but we're going to create this highlight institution through which they're going to run this. Sounded like a great idea, but the actual content of it wasn't very clear till we came to this case. Basically, what happened here is that it went a little bit wrong because the person who set up a company, they thought, okay, we have now a new form of business organization. Why don't we try it out? They set it up. They transferred the business they were running before through this new structure. At some point, the business got into trouble and it went bankrupt. Right? We don't use the word bankruptcy in the UK. We use the word insolvency, but you get what I mean. They've gone insolvent. And when people came to collect their money, the company told them, I'm sorry, I ran out of money, so I cannot repay everybody. And the people who were owed the money, they kind of went, hang on a second. Mr. Solomon here, that I've been doing business with all these years, he's still all right. He's sitting in his house. He's got like kind of bags of money under the bed. So I don't see what the problem is. They go to court and they say, hang on a second, this guy, bags of money and all, sets up this business. Subsequently, the business gets into trouble. The business goes bust. Okay, maybe the business doesn't have enough money to pay back everybody. Why don't we take the money from that guy? It's his business. So the court has the opportunity to explore what actually this new form of business organization means. And what they come up with is with two key concepts that have been kind of chasing after us since then. They came up with clarifying, this was present in the law, but they clarified the idea of separate corporate personality, meaning that when you set up a business through a company, not only you've created a structure that is more recognizable, this structure is actually alive in the same way that you created a doll and then it's come alive. The court says the same thing happens with a company, hopefully with less kind of monstrous consequences. So the company is alive. In the eyes of the law, the company is a totally separate person. So we no longer talk about the people who put it together, its initial subscribers or supporters or shareholders or whatever you want to call them. We're talking about something entirely new that is alive on its own. And because it's a new thing and it's alive on its own, if you have trouble with it, then you need to deal with that thing. Separate corporate personality is the key idea. And the second key idea is the idea of limited liability. What does that mean? What is limited? It means that the money of this new creature is its own money. So not only it's got its own separate personality, it's got capacity, it can do stuff in its own name, you can have contracts that are signed by X company. You don't need the name of a person to, of course, a person physically represents them, but the company itself that engages into those contracts. And the money belongs to the company. If the company gets into trouble, you cannot go after the people who support it. You cannot go after its shareholders, that are the people who own the bits of the company. You cannot go after them. You cannot go after the banks that gave them loans. You cannot go after other people who have participated. You cannot go after its employees. You cannot go after its bosses. This sounds wrong, doesn't it? Basic idea. Separate personality, you're dealing with a different creature. Limited liability, the money of the creature is the money of the creature. You cannot go after people who are associated with it, either as shareholders or as bosses or whatever. The people who were suing Solomon there were left unsatisfied. And even though the whole thing looked like a scam, because the guy was still there, his money was intact, but the business had switched over to the company, it looked terrible, and it confused the court as well, because the court at first instance wasn't sure that the rules should be interpreted in that way. But it got all the way till the end, and the final decision of the court was that, no, we've set up this new structure, and this is how it works. And some of the stuff that we explore now throughout the first term is actually whether this is a good idea. Because the idea of creating these separate structures and creating those barriers to liability could be good, could be bad. If a company fails, it's bad most of the time. But the consequence for our friends Yorgos and George are that if they're dealing as sole traders, anything that goes wrong comes back to them. If they're dealing as partners, anything that goes wrong comes back to them. There is no separation between the personal assets, the personal money, and the business activity. It's all one and the same. But if they set up a company, then suddenly they have a set of distinct roles in relation to that company. That company is a different creature. If something goes well and the company becomes wealthy, there are ways in which they can participate in that wealth, and well done to them. But if the company goes wrong, then there's a stopgap. So there's a protection that they cannot come after their personal wealth. And this is attractive. It is attractive because if you want to run a business, maybe you want that assurance, you want that separation between your personal assets and your business assets. It makes people more likely to invest in businesses if they know that what they stand to lose is the value of their investment, but they don't stand to lose their share. Whether this is better for the people doing deals with them is another issue. However, the emphasis at the time that they put that stuff together was to encourage activity, was to encourage people participating, investing more, and creating some level of insurance against this. Now, all this, I'm not saying that we should kind of swallow this as an excellent idea. All this is debatable. Whether this is a good mechanism and a good system that has got beneficial consequences down the line is debatable. The particular mechanisms of it are subject to debate. The overall structure is also subject to debate. English law is a capitalist law. English law is built in order to facilitate a capitalist system that is market-oriented and is property and contract law based. You need to understand the law within that framework. It could be that you disagree with aspects of it. It could be that you disagree with the entire structure of it. But you need to recognize it for what it is. And with every system which way is organized, there is always the opportunity for some injustice or some things going wrong. And whether you support the system or not depends on your personal values, of your understanding of where the risks are and what are you most trying to protect. We're assuming throughout our classes and throughout our presentations that people are engaging in business and they're engaging with the idea of companies in order to make money. We presuppose a profit motive. This is not necessarily true for everybody, because you could have charities, for instance, Yorgos and George, that made their water-saving, environmentally friendly, Greta-pleasing toilet flush, might have been doing this because they want to save the world, or because they want to contribute to environmental sustainability and they don't seek to make a profit out of it. In which case, maybe they want to make it available to the market in a way that gets it widely introduced, but they only selling it at cost price. There's a variety of things that they could do. If we're thinking about non-profit motives, we're going to see other structures, you're going to read about them in your books, that are built for that purpose. Even if you're not trying to make a profit, you still have a group of people coming together to do something. You still have outside clients or people that you're dealing with, so you need to understand your relationship externally, but you also need to understand your relationships internally. The profit motive or not can be determined on the type of corporation that you choose, but not all corporations are profit motive. For example, you have what we call community interest companies. What are those? These are structures that help people organize even though they don't have a profit motive. Why would you have a community interest company? Because you have a block of flats that you're trying to organize. So in a block of flats or in a large estate, there are lots of people. Some people rent, some people have bought the properties, but there are communal places that you need to take care of. How are you going to generate the money to pay for repairs and maintenance in the building? How are you going to deal with all the contractors? A simple way to do it would be to set up one of those companies. It's not out there to sell anything or make money. It's there to organize stuff. So when you hire plumbers, something wrong, or the gardeners, it is that company that contracts with them. These relationships are clear and they've got clear governance structures, so all the people in the estate can participate in an appropriate way in what's going on. It reduces opportunities for arguments and all of that stuff. So it's a great idea. If you got something that has a charitable purpose, that you're meant to help some other people by engaging in something, it could be that you're not setting up a company at all, but you're running a charity. And charities have got, like partnerships, different legislative bases, different case law, different information about how they work and how they engage both within and without. Be aware that these things exist, things that are for non-profit organizational purposes or things that are for charitable purposes, but our emphasis is profit-making activities. So we will not spend a lot of time talking about non-profit objectives. We're talking about profit-making either through sole traders or partnerships or companies. When we get to the companies themselves, you have probably noticed that there are various signifiers. Very often that you will hear that you're dealing with Plumbers Ltd. Or you're dealing with Vodafone PLC. The fact that you've set up a company doesn't mean that they're all the same, but there are different creatures within the label of company. What we're mostly dealing with is a private limited company. What does that mean? It means that it's a company that has got the separate personality, that it benefits from limited liability, but the people involved in it, the owners, are set at the beginning. It's not very easy to sell a bit of this company to somebody else. It's the way that it's been set up at the beginning and it's meant to stay there. The majority of companies begin their life as a private limited company. When a company grows and brings in more people and attracts more investment, it could become a public limited company. So it's not obligatory that you start small and then grow up. It could be that you set up at the beginning as public, but usually this is what happens. A public limited company benefits from limited liability. It has separate personality, but it's got a fluctuating number of members. So the people who own it can change on a daily basis. It does not have to be in a stock market, but most of the time, private limited companies are entered into the stock market. The idea behind this is to encourage investment to facilitate people becoming part of corporate structures. The idea of limited liability and the corporate veil. It's the sort of thing that is fundamental to company law. So hopefully everybody comes out of these classes with an understanding and appreciation of the purpose and function of limited liability. These two cases, for instance, BTB and Prest, are both from 2013, and they again try to understand and interpret the meaning of limited liability and its consequences. How come something that is settled back in the 19th century keeps coming back to us now and people are still arguing? It probably suggests that it is not as settled as we think. The overarching theme in all of this discussion is the idea that the shareholders of the company are protected by limited liability. The agents of the company, the decision makers, when the decision makers do stuff that are wrong, then the company gets in trouble. Maybe they themselves get in trouble. Directors themselves can personally get in trouble for doing stuff wrong, both in a civil and criminal sense. The people who run the show is not the people behind it. The people behind it are the owners of the company. They're the shareholders. These guys, if we're talking about a limited liability company, are protected by what we call the veil of incorporation. So there's the stuff that the company does here, and then there's a curtain, and behind the curtain is the shareholders going, we don't care, nothing's going to happen to us. Coming back to the idea of lifting the corporate veil. What if you know that the company is nasty? Why would they do nasty? They're nasty people. Or it could be that they think maximizes value for their shareholders. It could be that they're not naturally in consequences for people around them, but they're just thinking, we save money by doing it this way. And if we're saving money, the cash flow for our shareholders, which is great. So then our shareholders get more money, they're happy, everybody's happy. They can remove the directors, so you could lose your job as a manager if the shareholders are not happy. So you do have an interest in keeping them sweet. What if, in an attempt to protect yourself, you try to game a little bit all this stuff about limited liability? What happens if you have a subsidiary, it's a big multinational corporation, and you've got a subsidiary somewhere that is engaging in something dangerous that could generate some liability. And what you're trying to do is you're trying to take advantage of the idea of incorporating separately in different places and protecting your shareholders from any resulting liability. Subsidiary that is nasty, asbestos, right? You know what asbestos is? It's a dangerous chemical. It used to be used for fireproofing because it doesn't burn, which is if you live in a block of flats. And they were using this a lot since the 1950s, 60s. It was all over the place. Problem with asbestos is that it causes cancer. It's highly bad for you. So you kind of inhale it and stuff. You have a multinational that's got a mining operation in South Africa that's generating the asbestos. They've got an American subsidiary that is using this asbestos to put in buildings and all of that stuff for insulation. It turns out that a lot of the workers that were working in the American bit of the company, they got sick because of the material. The company kind of knew that asbestos is not good for you at the time that these people got sick. The American workers, they sued the company in the States saying, dude, you had us working all these years without protective equipment and all that stuff, and now we've all got cancer, so now you have to compensate us for the effects on our health. The company goes, no, we didn't. No, we don't care. They take them to court. The company loses. The court says, well, you knew that this is bad. These people have suffered the consequences. It's your fault. It's your negligence. Therefore, you need to compensate them. The American company goes, fine. Look in their pockets. Oh, we don't have any money. Where's all the money? Well, all the money has gone back to our shareholder. Our shareholder is the British company here. The Americans go, oh, right. Okay, then. So you guys are all in on it because you got the parent company sitting there in London really nicely, tall hats and umbrellas and all that stuff. The bad stuff is getting sucked out of South Africa, sent to the States where it's poisoning people, but all the money gets sucked back into the American parent who's the shareholder. So we're going to come after you guys. So they come and they begin their actions here in London. The case comes in the form of, it's gone through a lot of courts in a lot of things, but the relevant one for us, Adams versus Cape Industries, right? It's a case from the 1990s. It comes up to that court, and the court has to examine the extent to which limited liability can help to protect people that are engaging in nasty stuff in these circumstances. So the claimants, they go and say, look, this isn't right. This guy's economic unit, it is a multinational corporation integrated. So what it does is dig stuff up one end, sell that stuff the other end, move the money, shift around from here to there to kind of maximize various tax efficiencies and kind of hide other limited liability. But for what it's worth, for everybody else, this is one company that does one thing across the planet. So it does sound a little bit terrible if you allow them to hide the money here. The liability is generated in another jurisdiction, but all the money is sitting here. And when the people come and claim, you go, oh, sorry, these bits over there don't have any money. So even though you guys are right and you guys won the case, you're not going to get anything. All the money sitting here with the shareholders. So one argument is that this economic unit. The second argument is that this is a scam. This is one of these transfer scams where you leave your nasty operations at one end and you have your money hidden in the other end, and you've got various jurisdictional and corporate barriers in between to hide stuff. So the claimants are also saying this is a scam. Alternatively, they said that the other companies were agents of this one. If you're telling us that limited liability and separate personality treats the American entity as completely distinct the UK entity and we cannot get from one to the other, okay, we get that. But what we're saying is that the people in the US never did business with the American company. They were doing business with the American company as an agent of the British one. So if it's an agency issue, all liability between the ultimate victim, if you want, and the principal, which is the UK entity. So another argument they tried is that of agency. Alternatively, they said it is in the interest of justice not to allow this stuff to happen. It is improper, because what message are you really giving us here? The message that you're giving is that these are mechanisms that can be used to perpetrate abuses. That this is a message to corporations that if you guys want to do well by your shareholders and if you want to maximize the money, it's how you segregate the dangerous bits from the profit-making bits. This is how you shift the money around, and this is how you hide it. So all this comes to the court and gets debated at length, and we come to this outcome. Sorry guys, but this is how it works. The here says that there are ways that you can pierce the corporate veil. You can look at what the shareholders are doing in relation to this. In this case, the shareholder was the other entity. But just do this because it looks wrong. Simply consequence of respecting the system is some injustice. So the court is saying that this is a good outcome for the American people who answer. It's saying the outcome is unjust for them. However, if there is no improper the way that the rules have been used, then there is no problem. So unfortunately, but a lot of stuff are unfortunate. So they didn't win. And that caused a bit of aggravation at the time. But what we do know now is that we have a list of specific cases in which the court will lift the corporate veil. These can be found either in case law or they can be found in statute. Some of the statutory ones are things that have to do with premature trading, for instance. If a company starts doing business before it is properly incorporated and they get the trading certificate, anything that happens up till that point is the direct responsibility of the people authorizing the action, which in this case means the directors. Wrongful trading is another statutory exemption, is that if a company is about to go bust and the directors know it's about to go bust, then their responsibility is no longer towards the shareholders, but it's towards the creditors. So they shouldn't do things that make it worse. This is a way around corporate barriers, but this is liability that attaches to the directors. The cases are about the stuff that I already mentioned. Whether somebody is acting as an agent of another corporate, when somebody's perpetrating fraud. You had a guy running everything. He was an airline pilot. He was the shareholder. He was the director of the company. He was employee. He was director. He was shareholder. He got killed in a plane crash. When they went to claim on the insurance said, no, we're not going to pay out because this guy, he was not properly insured, right? Because he was doing all these things at the same time. The court said, no. This guy had distinct roles within this. The airline company cannot kind of use the rules to kind of flip them around and then refuse to pay the guy. He was properly an employee. You got other cases. You got Guilford Motors. You've got Jones and Lipman. These are fraudulent attempts to evade the rules. In Guildford Motors, you've got somebody who had transferred assets to a company. He was due to give back the assets himself, to be seized. He transferred them to a company. So then they would say, oh, they're not mine, they belong to the company. The intent was fraudulent from the beginning, so this guy was not protected from limited liability. At Jones and Lipman, you've got similar stuff. It's attempts to use corporate structures in order to evade existing obligations. This stuff's not allowed, it's fraud. If you manage to use some of those cases to prove that the intent is fraudulent, or that really there is joint decision making, so they're all doing this stuff together, then you lose then the distinction between parent and subsidiary and all the rest. Or if you can show that one company entity agent of the other, then you can go directly after the parent. The result of Adams and Cape is unfortunate. And it looks like it's condoning inappropriate behavior, if not fraud. It wasn't fraud, but it is definitely condoning appropriate behavior, because this split of the business activities was done precisely in order to avoid this type of liability. But it stayed. This came to be reinterpreted in cases like VTB and Prest. These are cases where the court comes again and looks at this thing. It doesn't fundamentally change the answer in Adams and Cape. So the English courts in particular, they're very strict in applying the consequences of separate personality and limited liability. So this is good for you in a way, because it gives you the opportunity to discuss whether this is appropriate in terms of law, and also whether it is appropriate in terms of theory and principle or morality, or whatever you want to call it, whether this evolution of the law is where we need to be. Topic for today is company formation. So we're going to see how one can actually go out and do one of these things, set them up. You will remember our toilet-obsessed inventor friends, Yorgos and George. Now, they both have got this idea that their toilet flush is a fantastic idea. It's going to make them very, 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 very rich. And they're thinking about how to actually go about bringing this to market, but do it with the protection of a recognized form of business organization that entitles them to both structure their relationship with each other plus their relationships with the outside world. They have, though, a series of options that are going to be a little bit confusing for them if they haven't been as lucky as you guys to take this class. You can just do the stuff. You do it. You go out, you sell it. You got like a pair of shoes you don't want, you put them on eBay. It's not the end of the world. It could be that you bought the shoes, you decorated them, and you put them on eBay. They could just do it. The problem is if, as we said, they go out and just do it, then if there's any issues of liability, if there's any debts to cover and so on, there is no separation between the business activity, their personal activity. Also, if Yorgos and George diverge in their interests, in their objectives, they start telling different things to different clients and doing deals, this might unbalance their relationship and it might make one liable for the debts of another. This might not necessarily happen if they're trading as self-employed as rather distinct entities, but if they're perceived to be a partnership, then what one does carries consequences for the other and vice versa. They might therefore choose to incorporate. Incorporating might be the more sensible or the more mature or the more thought out option here, even though I have to admit people will normally start operating as a partnership and then think about incorporating further down the line. But if Yorgos and George have been in touch with this material earlier on, they might think of actually structuring the things in a form of corporate, or taking a corporate form from the very beginning. We're having the assumption here that they're in it to make money. This is not, structured formations that are of a money-making nature. They will need to choose between an unlimited and limited company. They wouldn't really go for unlimited company because they could have achieved that by trading themselves or trading as a partnership. They probably want the additional benefit of a separation of their personal assets from their business assets. So you would expect them to go for a limited company. This limited company can be limited in two ways. One would be to limit it by shares. One would be to limit it by guarantee. If you create a company limited by shares, you can say this company consists of 100 shares of £1 each. And then Yorgos gives the company £50 and buys 50 of those shares. George gives another £50, buys the remaining shares, and they then have an equal proportion of shares. They are 50-50 shareholders in this company, and the money takes that money and puts it in its pockets, which is a separate pocket than the pockets of Yorgos and George individually. That's the whole point about the private limited company. So this then becomes capital of the company, this initial contribution of funds. They could, on the other hand, do something registered by guarantee. If you register by guarantee, you don't give the money up front, but you undertake a commitment to contribute to the company's assets at a set amount if the company goes insolvent. Now, why would you do this? You may not want to give the money up front, could be one reason. It also gives you a wider menu of options if you want to get out, because if you're a shareholder in a company and you don't want to be a shareholder anymore, you need to find somebody to transfer the shares to. In a private limited company, this implies the cooperation of the company as well. If you are a member of the company in the sense that you provide the guarantee, you can get out of it by resigning this, and it's a slightly different process. It might make things easier. On the other hand, if you have a profit, if you're setting up a profit-making enterprise, you're better off having a company limited by shares. The reason is that the shares give you an easier avenue to distribute profits, because you could either sell the shares at a higher value than the ones that you bought it if it reflects a growing, successful company, and also you get dividends out of the shares if the company is successful and decides to give money back to the shareholders. If you are a participant in a company by guarantee, then you don't earn anything because you don't participate in dividends or anything like this. If the aim of setting this up is profit making and you want a ready-made mechanism for the distribution of profits in a predictable way, I'm not saying here that the payment is predictable because you don't know if the company is going to make money or not, but the mechanism for making the distribution is predictable. Then you should be going for a limited company and a limited company by shares. Will your company be private or public? At the initial stage, it will be private. In our scenario, with the two inventors bringing their product to market and so on, the logical sequence is that they get together, they start the business, they incorporate a private limited company. If it starts growing and it becomes successful and they need outside investment, then they decide to go public. And remember that public does not necessarily mean listed in the stock market. So a company will need to become a public company that then the public at large can purchase its shares. If it wants to make the extra step, then it becomes listed in the stock market. That provides like this ready-made mechanism for participating in the buying and the selling of the shares more easily. The practical things now. What should they call it? Should they call it the best, most successful toilet experience you've ever had .ltd? Should they call it something really fancy that's gonna stand out? Probably not. Now, this is important stuff, right? Because what you call your company is very significant in terms of branding, and branding is important for marketing. The way you attract your customers, the way that you become known will have a huge influence on how you carry on your business. But this is important for the law as well. And there are checks from Companies House when you're trying to set up a company in helping you choosing an appropriate name, or if you want to see it in other ways, preventing you from choosing something that's not really going to work or it's going to create confusion. So there are a number of restrictions and controls in the choice of name. You can find those in a statutory instrument called the Company and Business Names Miscellaneous Provisions Regulations of 2009. What it basically says is that certain expressions and abbreviations you're not allowed to use. So you cannot call your company George Public Limited Company Ltd, because it ain't a public company. So you cannot use things like a designation of business format in the name because that comes afterwards by necessity to alert people as to the sort of business you have chosen. So you cannot call yourself the Great Public Limited Company Ltd. And I'm talking about these designations in English, but also in Welsh, right? So you cannot use something that will suggest a form of business organization in Welsh either. There are also controls over the characters, signs, symbols, and punctuation that you can use. So, things are understandable and also machine readable, which becomes very important these days. Equally, there are some restrictions in the Companies Act. For instance, if you look between sections 53 and 55 and also 1197, 98, there are restrictions there in saying that you cannot you cannot use anything that implies affiliation with the government or official service. You cannot call yourself Her Majesty's Toilet Flush Service. Anything that implies that you are a government body or a statutory body will be rejected. There are some trademarks that you can have that can use words like ministry and so on, but a trademark registration, right, is not the same as a company name registration. So I doubt that you would manage to set up a company that calls itself a ministry of some kind. Yeah. Also, you cannot use names that would constitute an offense or encourage people to constitute an offense. You cannot use offensive names. If you try to use certain things that are inappropriate, they will be disregarded. Also, you cannot use stuff that are very similar with something else, apart from not implying association with the government or an official institution, and not using something offensive, not saying something that implies a different form of business organization. You're also not allowed to register something that's very close to an existing company. This is not like domain name. Things are more restrictive here. If you want to call your company, like Flushes Limited, you cannot put Flushes with two S at the end, Limited, and say, yeah, this is my Flushes. There's another Flushes out there, but mine's different because it's got two S's. Because people are going to say it's too close and there's a risk of confusion. So you cannot play with capital and small letters. You cannot play with adding random letters left and right if people are likely to make the confusion between the name that you're choosing and a different name. Now, there are some exceptions. The exception could come primarily from the fact that you've operating for a long time with this name before you incorporate it, so people know who you are. If that's the case, it might allow you to incorporate with a name that otherwise would have been rejected, because again, there is no risk of confusion. The registry will refuse to take, the Companies House will refuse to take an application with the name that they object under any of those grounds. They're going to ask you to find something else. They will be particularly unhappy if you are misleading with the name about the sort of business that you're engaged in. Because we said we do not want confusion, but we also don't want you to have an original name that actually suggests that you do something else from what you're actually doing. If it is deemed that you're trying to deceive people as to the purpose of your firm by using a name that's got absolutely nothing to do with it, you might be refused. Also, you are not allowed opportunistic registrations. So you cannot go register companies with a bunch of names that you think people might want to use in the future, so then you sell them the company so then they can use that name. You're only allowed to register a company if this is a genuine attempt to actually run a company with that name. They will not allow you to reserve names. So you cannot reserve a name in the process of registration to make sure you don't lose it. No, if somebody gets it before you, that's the end. And you're also not allowed opportunistic things. Again, this is not like domain names. You can do this with domain names and then sell them to an interested party if they want to buy the name. You're not allowed to do this with companies. Should distinguish company names and business names. Business name is the name that you're known with. It is a label under which you do business, but it is not an official thing. So it could be that for years you had a corner shop or you had a kebab shop that called itself Best Kebab. A business name would be like Best Kebab, but it's not registered anywhere. It doesn't represent the name of the company. You are looser in what you can do with business names. And somebody operating as a sole trader, normally they operate under some banner, They wouldn't go like Yorgos and George, the guys who make the toilet flushes. They would probably have Yorgos and George flushes. Business name normally precedes the registration of a corporate entity. People will usually carry on the business name. They will seek to have that business name as the name of the company thereafter. There are, again, some stuff that you're not allowed to do with business names. You cannot imply association with somebody else. You cannot risk confusion and the rest. But things are a little looser. You do not need to display your business name in the same way that you would display your company name. Company names, though, are part of mandatory disclosures. For instance, you will find in both in sections of the Companies Act plus in other places, we've got, for instance, the company's trading disclosure regulations, and there are two sets in 2008 of statutory instruments that give you this. It says what sort of information about your company you need to make available to people and where you need to put it. Every company must display a sign with its registered name. It needs to have the address of the office and the location at which it carries its activities. And also, you must sign all documentation on headed paper with this information. What's the name of the company? What is the registered address? What is the company number? And on certain types of documentation, you need also to put the names of the directors. Why do we have these disclosures? Because it's important for people to be able to see who is behind the company that you're working with, right? Because a company name could be anything. And you might, if somebody comes and proposes a business deal to you, you should be able to check who is the actual person behind the company to verify that the person that you've been talking to is in fact associated with that company. These things are free to check on the Companies House website. So you can either put the name of a person and do a search with their name, or you can put the name of the company and then it will tell you where is its registered place and what are the names of the directors. Can you have something that looks like a website as a company name? Yes, you can. But again, don't make the mistake of confusing domain name registrations with company name registrations. You're trying to book a ticket, say, you give a good offer on a ticket online and it's sold by Yorgos and George travel agents. Is this just like a fake website that's going to take your money and you're never going to hear from them, or is it the real company? They need to display their company number. They will also might display that they participate in various travel agent related stuff that offer insurance and protection and so on. It is in your interest to check these things when you're doing business with somebody, to check that they actually are who they say they are. Considering so much of business happens online now or over the phone, you need to be sure that you're not talking with somebody else who's trying to scam you. If you're reckless, then you might suffer the consequences of your recklessness, in the sense that you've paid a lot of money and you didn't get what you ordered. Some of these requirements apply to overseas companies that operate in the UK. There's a basic level of information that needs to be available for all companies, including overseas companies, again, so it allows you to check who you're dealing with. And foreign companies also need to have an address in the UK from which they do business, for the primary reason that if you need to serve them court documents, you know where to send them to. What do you need in order to set up the company and to have it operating? Well, you go online, pick up an application form, fill it in, pay the fee, put together memorandum of association, articles of association, and any additional information. Now, you might need the additional information to explain your choice of name, for instance. If it looks like it's violating any of the provisions there, you might want to explain further why you're choosing a name that kind of looks like it might not be appropriate. And then this is how much it costs. This is just an illustration. These things kind of change all the time, right? But it gives you an idea. So in this country, it's relatively cheap to set it up, and you can do it pretty much on a day. So basically, the only thing you need is to have the documents prepared in advance, have your credit card, bam, you go on the website, get it done, you're up and running very, very soon, and it doesn't cost you much. 120 pounds or so. I think this includes the fees of that particular website. Now, in Germany, you can see it takes a little bit longer and costs significantly more. Now, in other jurisdictions where it doesn't take that long, it still costs a lot of money. But again, these things are subject to change. but you would normally expect it's going to cost you a significant amount of money. This has to do with capital requirements where you're setting up and so on, in addition to administrative fees. These things are fairly low in the UK. You need to be aware of these things. And this is a good way to assess how business-friendly a jurisdiction is. The lower the bureaucracy, the lower the cost, the faster it is to get something set up. It suggests that this is a friendlier business environment. Now, if you need to pay lots of money, takes a very long time, you need to visit 15 different guys with mustaches to stamp a document before you start going, less business-friendly place. And finding information about the companies, the company will receive a certificate of incorporation. From the point that it receives the certificate of incorporation, it is allowed to engage into business, and you go to the company's house website where you can get a lot of information. Now, the steps to obtain the certificate of incorporation are slightly longer for public companies, because you need also to make a more significant capital investment at the beginning. The capital thresholds are much more significant for public companies, so you need to pay that money first and then you get your certificate. In any case, the company is prohibited by law to engage in trading before they have obtained this certificate. If they do engage in trade, then the people doing it become personally liable. So you cannot hide behind the veil of incorporation if the incorporation has not happened yet, and the incorporation has not happened till you had your certificate. So if the company attempts to engage in any business, sign any contracts, then the people signing them are the ones directly responsible. The company could choose to adopt those, to ratify them, subject to, after incorporation. This is fine, but if it doesn't, then it is a personal problem for the people who were signing. If we find anything wrong with this process, what can you do? Well, the act of setting up a company is final. Because once they get the certificate and they start doing business, it would really be extremely disruptive if you came back and said, oh, hang on here, we made a mistake. We shouldn't have registered those guys because there's something wrong with the name, or there's something wrong with something else. Nobody can challenge the act of incorporation. It is only the Crown itself, it is only the judicial authorities of their own initiative that they can challenge the act of incorporation if they find that something has gone horrifically wrong and it wasn't spotted before they got the certificate. But no private individual can challenge the act of incorporation. What you do instead is that you wind down the company. It means that the company existed, carried out some actions, then it's getting dissolved. So for the time that it was actually operating, it had valid authorization to operate. So then any rights and liabilities created out of this need to be sorted out the normal way. If you undo the act of incorporation, it means the company never existed, which means that if it has signed contracts, in the meantime, you don't know what to do with them. So it is believed that the best way to deal with this, instead of undoing the act of incorporation, is to wind them down using the normal process that you're going to find, the Insolvency Act and so on. Of course, many things are subject to change, and the most important changes normally are not about changing the name, but they're about changing the type of registration. And the Act gives you that capacity. You can go from a private company to a public company. But you can also do it the other way around, right? A public company can become private. You can go from limited to unlimited, but also the other way around. And you could go all the way down. You could be a public company in the stock market, delist from the stock market, then go from public being private, and then go from private being unlimited. But a lot of people do this, from public to private. If you're a public company, you've got a lot of shareholders and you do not necessarily control the general meeting and you don't control the voting. So if you want to carry out an extreme restructuring, then it might make sense to take the company from public private. You buy the shares from all the shareholders and you hold them yourself. Once it's private, decision making is a lot more streamlined and the intentions of the shareholders and the management are much more aligned. You take the guts out of the company, you do whatever you want to do, reframe it into something else. Once you're done, relaunch it as public and get investment. This happens usually by private equity takeovers. right? Private equity firms have got a lot of available cash. They identify public companies with a problematic profile or problematic operations. Get a substantial share, then use this to control the management, then use this to take the company from public to private hands, they structure the hell out of it, and when it looks like it's got better chances of being profitable, then they put it back as a public company and invite investment. It normally doesn't work well for the company in the long run because in the process of those changes, the company tends to get a lot of debt. It's all this discussion about debt, leveraged buyouts, and so on. But this ability to re-register from one type of company to the other exists in the law and it is often used. You've got some cases here that give you illustrations of how to deal with problematic incorporations. Our register of companies was about, I'm doing a registration of this lady there. This was a pornography business. They registered something that looked like it was meant to carry out the inappropriate business of that nature. And then they went, we registered the company here in order to carry out this thing, and this is not very nice, so what we should do? And it gives you an opportunity to look at the process where the Crown itself takes initiative to deregister a company. So this is an example of hitting something bad. You've authorized the company to do something that really is not supposed to be happening. So that way, you should just not wait for the company to engage in operations and then dissolve it. So it means you want your hands clean of this, so this company never existed to begin with. So this is a good illustration about how you do this. Today we're going to talk about company disclosures and then a little bit about financial statements and the financial documentation that the company produces. What is the main way that the law counterbalances the effects of limited liability and the protection that is offered to shareholders? The main counterbalance is disclosure. So you get to tell people that potentially want to do business with you. You get to reveal a lot of things. If you're a company, you reveal a lot of things about your finances, about your plans, about your organization. So people can then make up their minds as to whether they want to do business with you. On the one hand, you've got this protection from the insiders, but the outsiders get a lot of info. Perhaps if the case was not that, you would not need as much information going out, and that's what you have in partnerships, for instance. Partnerships that do not benefit from limited liability, you don't know a lot about them, but you do know that they cannot tell you that the partnership has run out of money when the partners are personally responsible for making contributions if that happens. Knowledge comes a responsibility, perhaps. Knowing how a company is doing and whether it is solvent or not is something that ought to be communicable through the information that is publicly available. The problem is that people are not necessarily familiar with this type of documentation, so they cannot quite easily understand what these documents are supposed to mean. Yeah? So what we're gonna do, apart from introducing generally what is contained in these disclosures, we're gonna have a quick look at the sort of spreadsheets and stuff that the companies are giving out. Familiarizes you a little bit with the way this information is presented, so you can have a look at it and determine for yourselves company is still solvent or not. As I said, we already know that there's mandatory publicity requirements for companies, and they're a central feature of the organization of company law. Obviously, the bigger the company, the more information you need to give out. And by big, I mean, are we talking about a company, a private limited company, or are we talking about the public limited company? Because of the higher exposure that the public company has and the potential fluctuating shareholding, then it obviously needs to give higher amounts of information to people who might want to do business with it or want holders. So a company that is public will publish a lot more information than a company who is a private limited company. Now, if that public company gets into the stock market, because you need to remember this distinction, you can be a public company, it's not obligated to be listed in a stock market, but if you are also listed in the stock market, then you need to give additional information about yourself, and this is going to be contained in the listing rules. a large amount of information in a highly kind of stylized way that needs to come out, informing potential purchasers of these shares in a stock market about what the company is and what it does. The information is not only intended to say something to potential shareholders, it's also intended to say something to the existing shareholders, because existing members of the company ought to have mechanisms in determining whether their company is doing well or not. Find this out, I guess, if the company is paying dividends. So if the company has done very well and is very profitable, it's going to pay a higher amount. The lack of dividends doesn't necessarily mean that the company is not doing well. It just means that the company is reinvesting. A process for communication of this information from the company to the outside world, but also from the directors, existing shareholders as well. The directors, therefore, are obligated on an annual basis to produce this information. And this information comes alongside the annual accounts that the directors have to put together, which explain the financial position of the company. The documents that the directors will put together explaining both the finances, but also explaining corporate strategy and a little bit about the plans for the future of the company and how they see everything going. And these are usually presented for the bigger companies that need to have an annual general meeting. This documentation alongside the accounts are presented at the annual general meeting. You will find information about these disclosure requirements in section 381 of the Companies Act. But all companies, as it says in section 386, are obligated to keep records sufficient to show and explain the transactions, to disclose with reasonable accuracy the financial position of the company. And this is something that is also done to comply with international accounting standards, meaning that this documentation is not only to be understood by insiders or people in this jurisdiction, it's meant to be presented in a way that communicates across borders. So investors that are actually not here can understand and can have faith in the company's giving about in an attempt to describe its financial position. So not only the directors are under an obligation by law to produce these things, but they also need to kind of address it, a narrative explanation of what they've been doing with this entire year and what they intend to do in the future. And this comes in the form of a director's report. This director's report is a statement that comes with the accounts, and it is a statutory requirement here, backed by criminal sanction. So if you look at section 415, the directors have to produce the documents, and if they don't produce them, they will end up committing a criminal offense. That's frequently keep telling you that taking the job as a director isn't something that you do for fun. It is something that can have serious consequences, both of the civil and nature, if you fail to have these returns that you need to have on an annual basis. If we're talking about public companies, alongside the director's report, we're also going to have a director's remuneration report that explains how the board, because these are professional managers that get paid more money, this explains how their remuneration is calculated, how much they get paid and why. And you also have, within this director's report, you've got a list of everybody who's a director and a list of the main activities in the course of the year. Plus, it will usually contain some information as to how much dividend is to be paid, which is probably what interests the shareholders the most. And you also have something that used to be called the business review, but now it's called the strategic review. That is the forward-looking document about where they intend to take the company in the future and what they intend to do. Now, all of these things are not a matter of best practice, they're a matter of legal obligation. So they need to put them there. Inaccuracies and mistakes in these reports, they're a breach of the director's duties and can lead to liability of the directors to the company. In some cases, for example, if the information is inaccurate due to fraud, liability of third parties and outsiders. Information about this can be found on section 463, which says what will be the liability for false and misleading statements in the reports. Now, what is important here to understand is that this is mostly understood from an internal point of view as a violation. So it kind of fits in with all the stuff that we've done about directors' duties. It is not easy to have an external person who decided to invest in the company on account of these statements to sue the company for having made the wrong investment. There isn't a direct link of liability for any errors or inaccuracies here to the investing public in general. It gets a little bit worse for the financial information that's in the audit documents that need to be checked by an auditor. They need to be checked by an accountant and validated. Now, all of things, the auditor's report and all the reports of the directors that I mentioned, they're all submitted to the registry. The thing about the auditors is that the auditors are meant to be independent of the company. So the company will hire them. They hire like a bunch of accountants to check what they've been doing. But their duty is not to the company that hired them. Their duty is to the registrar. So they need to make sure that this information is, in fact, independently checked. In bigger corporations that we've got non-executive directors, part of the non-executive director role is to check how the reports are getting audited and whether the information is accurate and how it reflects back to the job that the directors are doing. There will be criminal liability for negligent accounts. There will be criminal liability on the auditors as well for negligent accounts. And it's interesting to note that even though the company itself is not liable for the content of the statements to outsiders, unless of course there is fraud, the auditors will be. So the auditor that has validated the financial information might incur liability to the outside public, while the company will not. I'm not saying here that anybody who looks at audited accounts and then buys shares and ends up to have a bad deal is going to claim against the company or the directors, but they will be able to have a claim against the auditors if the auditors have validated wrong information, not having done their own due diligence, not independently. Perhaps the worst consequences are on the auditors, which in a way it's fine because the auditors are hired to be an external referee of this process. Right? The only way that you can go after the company directors or the company itself for financial loss, for investment decisions that you made on the basis of all this documentation, is if there is a direct duty of care. So if a special relationship has been is in existence between the company directors and an outside person who becomes an investor, and that relationship creates a duty of care, and if that duty of care is violated, then you have a personal cause of action. But the core of this is it's a tort action, right? If you have that manifests in tort. And if duty of care is violated, then you have a tort action against whoever has violated that duty. Best case to see about this is the case called Caparo Industries versus Dickman from 1990. Your options are, if you have invested in a company and it turns out that the documentation of the company is not have invested in it if you had seen the accurate information, what you need to ask yourself is, why did you make the decision to invest? Were you invited in? Did you have discussions with the directors, with company insiders that convinced you to do it? So then you're thinking about potentially a duty of care that's been violated. Or you could be thinking about, if the audited, would you have a claim against the auditors if they haven't done their job properly? If you don't have those, then things become a little bit more fuzzy. So then your position as an outsider is not very well protected, but perhaps if you've become an insider in the company, then maybe you can identify breaches of directors' duties, and then you can pursue the directors internally. But again, remember the distinction between personal harm and harm done to the company. If you're already an insider and you're pursuing a breach of directors' duties, any money that you generate is going to be money that goes back to compensate the company for loss suffered by the company, not to individual investors for making decisions. The idea of financial records and documents, there needs to be an agreed way to look at financial information, so then we can compare the experiences of different companies. And this is not something that's obvious. It's not obvious to you because in your everyday life you don't deal with this type of documentation, but also it's not obvious because it's not really that well publicized. Usually you rely on second-hand impression, the profitability or success or sustainability of a company. You don't look at the documents yourself. So if you're interested in buying shares somewhere, most people will look at what is the what does the press say about this particular company, whether it's good or not, or whether it's doing well, or whether the board has got great ideas. They will not look at the numbers themselves. So if you're thinking about, I don't know, everybody's saying that Tesla is the thing of the future. So if you're thinking of buying some shares in Tesla, it's much more likely that what's going to help you make up your mind is what is said, as opposed to you downloading and reading the financial information. But somebody at some point needs to be able to read this financial information. And in order to read it and understand it, each company cannot be putting together its accounts in whichever way it wants. So there are accounting standards that not only are they consistent for all companies within a jurisdiction, they're also consistent internationally. Because as I said, people need to be able to compare the financial documentation that comes out from different places. So you cannot leave this entirely to national law to determine, and then you need somebody to translate the documentation from one jurisdiction and what it means for another one. It is much easier if everybody complies with international accounting standards, and then the documentation is instantly recognizable by everybody. And this is in fact what is happening here. You have international accounting standards that are determined independently. They're not created by a state authority. They're created by the accounting profession itself, that governments adopt and incorporate it in their national law. So the governments will create their own standards. They will accept what is out there as best practice by the industry, and then implement obligation in national law to comply with that standard when they're putting together the statements. If we don't have ways to assess financial performance, then we don't have a functioning economy. And financial performance is not to be taken for granted, especially in an environment like the one we've got now, that things keep going out of business every second of the day. Now, you remember the business with Patisserie Valérie, that they went bust last year? You know what happened to these guys? They really had no clue what the numbers were, because there was fraud internally in the production of the financial information. So the person who was the chief finance officer was actually cooking the numbers. Not only the external people didn't know what's the status of the company, nobody knew what was going on, because all the numbers were fake, and the numbers were fake going back 10 years. So what happened is, at some point somebody noticed and thought, hang on, there's something wrong, let's look at what's happened. They started to look at the genuine accounts. They realized there's a big disparity between what the company has been publicizing and in fact what's going on inside. And then they start working backwards, and they realize that everything was made up going really back, right? And the financial guy got arrested and so on. It was like a big hoo-ha. The consequence of all of this is that you don't know if the numbers are fake. You don't know if the business is solvent or not. Why? Because businesses are not an issue of how much money do you have in the till at the moment. It's not even how much money you've got in the bank account at the moment. It is about how much debt do you have, and how much debt do you need to service, and how can you roll over those debts. Because all these businesses, everything that you see around you, has got enormous amounts of debt, including this institution. This place has got enormous amounts of debt. So whether we know that Westminster is solvent and whether it's going to exist by the time you graduate or not is not determined by how much money they've got in the current account. It's determined by how much debt they have, and whether the people who gave them the loans are willing to extend those loans in the future. The issue here is that for businesses that, like most of them, rather heavily indebted, if people start getting worried about whether your accounts are real or not, they're not going to renew the loan. So either they're going to call in the loan and they say you need to repay us now, or when the loan comes to its end, instead of extending it, they're going to say we would like to be. If a lot of these things come to be paid at the same time, then clearly the company is not going to have enough money in the bank accounts, and that's when you go bust. So this is what's happening here. This is what happened with Patisserie Valérie, but that was an accounting fraud here. So it's slightly different. What happened with Thomas Cook was the unwillingness of the people who had given them the loans to continue to renew those loans and to give them more and more time and more and more time. They just generally got spooked about the chances of the company and they want it to be repaid. And if everybody wants to time, obviously you cannot satisfy everybody. So how is all this information recorded? All the will produce type stuff that then they put on the websites and the financial press is talking about it. As I said, it's necessary that you produce this information and you make it public because there are lots of users of this information. You have to do it to comply with legal requirements, either in the statutes or in perhaps the rules of the stock exchange. You need to give information to your shareholders. You need to give information to your stakeholders. The managers need to know what they're doing depending on how much money is available. You need to also plan your business activity depending on what your financial performance is. So these things are crucial for the board of directors and everybody in any way associated with the company to figure out what they're doing. The concept of accounts, you will have an annual report that's published that shows you things like this. So if you're used to looking at that, it will immediately give you an idea as to whether these guys are making a profit or not. Or making a loss is also part of the business, right? It's not necessary that the business that has made a loss in any particular year is going to go under. It could be that they can sustain that loss because they've got enough money in the reserves, or it looks like they made a loss because they purchased a lot of great investments which are going to make them grow bigger in the future. So what matters for you is not whether they made a profit or not in this particular year. What matters is the whole structure of their money. And it looks something like this. You have an increasing complexity of financial information that the companies are giving out. The easiest thing to look at is the profit and loss statement and the balance sheet of the company. Now, the profit and loss statement will tell you very quickly what the turnover is, like how much money has passed through the company, right? It will tell you what's had. So if they're selling, if we have the company that makes the toilet flushes, if they sold £100,000 worth of flushes, but then in order to get them, they needed to pay £50,000 in the factory in China that made them. Okay, so the total money that they generated by selling them is 100,000, but they don't actually have 100,000 in the bank because they needed to pay 50,000 of that in order to get the items to begin with. But this profit and loss statement or expenditure statement gives you a very quick impression of what's happening in your company. So it'll give you an impression of whether you have a profit at this initial level or not. If you're selling toilet flushes and you're selling each one for £10, right? And you've sold 10,000 of those. Your turnover is £100,000 worth of toilet flushes. Now, the cost of sales, as I said, is the cost of buying the items in order to sell them. So, assuming that each one costs you £5 to produce in this factory in China, you needed to pay £5 for each one of the 10,000 that you got. Then you spend 50,000 in getting them in. So your gross profit is calculated by deducting this expenditure, this cost, from your overall turnover. Therefore, you've got 50. But that's not only that, right? There's more stuff. It gets more complicated because obviously you have additional costs. It's not only how much you sell the product and how much you bought it for. There's going to be cost of transport. You have office costs. Maybe you have marketing and advertising costs. Maybe you need to hire some people, so there are some employees' wages. You need to pay electricity for your stores. You need to pay all sorts of bills. Maybe there are consumables. There's a variety of things. So your account gets a little bit more complicated if you are including all these things to figure out how much money you're actually making if you include all your overheads. So if you include your overheads, then you get something that is more nuanced. Not only you've got the turnover, you have the gross of profit, but you've got all these things that you're going to deduct from the gross profit. So what you will end up then is building a balance sheet. But the balance sheet is a tricky document because it looks like, so this is like a more complicated version of your profit and loss statement, but the balance sheet looks something like this, which initially doesn't make any sense at all, because it's got two columns. Things of value that you have in your company represent both the money that you pay, the money that people pay you, the money that you pay out, but also with the money that you pay out, you get something. So simultaneously, if you purchase the goods in order to sell them, you pay money to the Chinese factory to make them for you, but then once you've got them, you got them, and they've got certain value. So it's not like this money disappeared, right? It's not like your rent disappears. But buy a camping tent, you paid money to buy the camping tent, but now you've got a camping tent that's worth something. That's why you end up with this double-side bookkeeping, because on the one side, it's got all the things that go out, and on these things that you purchased with the money that went out, that left you with a valuable resource. So it wouldn't be accurate to assess the financial health of your company simply by looking at how much money you've got in your current bank account and how much money went out, because perhaps with the money that goes out, you're going to sell afterwards, so they represent some value. So what you do, on the one side, you've got all the money that is going out, and on the other side, you've got all the money that is going in. The idea of the double bookkeeping is the attempt to express on a piece of paper then the asset you have attained. So what do we have? So all these things are going to be represented now in your balance sheet. So when your accountant looks at it, he's going to be able to figure out whether there's enough stuff of value in there to leave you with a viable, alive business. You've got assets. These are the things that the business owns. And there are fixed assets. Maybe you own a building, maybe you've got cars, maybe you've got equipment, right? These are your fixed assets. Current assets are things that are turning around a little bit more quickly, because perhaps the building that you own, you're going to have for a long time, or the cars that you have, they're not that easy to sell. But it could be that your current assets could be materials that are waiting to be turned into some product that you're going to sell. Or it could be that products that you have that you're going to sell immediately. It could be that there are shares or financial investments. Right? You've also got all the people that owe you money. So this needs to be represented somewhere, because all the people that you sold stuff this month, maybe they're going to pay you at the end of the month. So some stuff went out, but you've got the incoming money. Next, so all these are the stuff that you've got. Some of them are things that you've got immediately that are coming in, things that you can sell really quickly if you have to, and things that you can sell a little bit longer term. Next to this, you've got your own obligations. You need to pay money to the Chinese factory. You need to pay money to all these people that sent you the goods, that you got them, but you haven't paid them yet. You have to pay your bills. You have to pay your employees' wages. You have to pay your taxes. You have to pay all sorts of things. You need to service the debt. It could be that you have loans that you're repaying. The total amount of the loans needs to be represented in your balance sheet somehow, and also the cost of those repayments. So you have then a long line of things that are liabilities, and a long line of things that are assets. And you get to a situation that you produce a more complicated document. How do you know if you're solvent? So you've managed to put everything down on these documents. You've managed to represent the money in your bank account, the stuff that you've got that are worth money, the stuff that everybody owes you and you're going to get in the future. And then next to it, you've got all the payments that you need to make, all the stuff that you need to service, stuff that are going out, perhaps things that you need to get additionally that you haven't gotten yet. All of that is represented in these two broad categories. You're solvent if you've got the ability to pay your debts when they are due. A company that is solvent has enough working capital, meaning has enough current assets, to be able to service its liabilities that are current. You need to now, you've represented everything in your balance sheet and in those documents, but what determines your solvency is not the entire picture. but it is how your current assets match against the current liabilities. Because the structure of the law is such that if somebody comes and asks for their money today, be able to pay them back. And if that person is left unsatisfied, then if it is above a certain amount, the Insolvency Act gives them the right to go to the court and ask that you are put in an insolvency procedure because you owe them money and you haven't paid. Companies and businesses that are going bust are not businesses that are not rich, that they don't have stuff. They're businesses that have a mismatch between the current liabilities and the current assets. If you find that your current assets are lower than your current liabilities, you run the risk of not being able to respond if somebody comes and asks you for money. So if you're Thomas Cook, for instance, you knew that this is a very complicated balance sheet. You know that you're a wealthy company. You've got a lot of stuff, right? You've got a lot of planes. You've got a lot of rights. You've got the airports. All of these are worth money. So it's not a company without value. There's a lot of value. There are a lot in assets. The problem is that if most of your assets are long-term, you cannot realize them immediately. If you want to sell your landing spots at Heathrow, it's not something that you can sell in a day. But your liabilities are immediate. A lot of people turn up and ask for come out and ask for their money right away, then you're in trouble. So either you have a situation that's slowly deteriorating because you find your current assets are lowering and your current liabilities are increasing, and you can see this coming and you're trying to find ways to respond, or something bad has happened. It could be that something bad has happened externally to you. It could be that your bank gets spooked because of the overall economic environment and wants to take back its loan because the bank itself is suffering some crisis and comes and says, look guys, I know that we said loan, but we're not gonna, so we're gonna have to have it back now. Please give us back £50 million by Monday. And you suddenly, something that was a long-term problem becomes a current liability and you cannot match it. And then if you cannot pay, then they can put you into that process. Normally what happens, if you see it coming, you try to work something out or to push back the liabilities as far as possible. If you have failed to do this because the current board is not capable, or they're not doing it properly, or they don't recognize the extent of the problem, and somebody begins the process, one of your unsatisfied creditors goes and begins the process, they put you first into administration. Administration means that they recognize that you have a viability problem. The board gets replaced by a team appointed by your creditors, and they try and sort it out. Maybe there is value in the company that your balance sheet can be rejigged in order to satisfy everybody. The company did not want to do it because they thought it was a bad idea for their business, a bad idea for their strategy. But if a new board is put in place by the creditors, now they're serving the interests of the creditors. They managed to do this, sell some of the assets a little bit more quickly than anticipated, then they can plug the hole, balance the scales again, and the company can survive. So some companies actually go into administration and come out of it as existing entities. If that's not possible, then the administration moves into the stage of liquidation, when the company is broken up and then the assets are distributed in different ways. And that's when you get the discussion in the press as to is there a viable part of the business that they're trying to maintain or not. The company does not survive in its current form, but it could be that some of the recognizable kind of business expressions of it survive in the same way that Thomas Cook bought by another brand, so the stores are still going to be there, the employees are still going to be there for a while. The business has not survived, but part of the business activities. So that's the key issue about solvency, and that's the idea of this double entry bookkeeping. Helps you get a dynamic view because it's a snapshot in time. These things change every day, but at least if you look at it today, you should be able to generate numbers that say, here's the long-term picture, but here is the short-term picture. Here is how current liabilities stack up against current assets. So if you want to book yourself a holiday and you're wondering about whether this business selling you this holiday is safe or not, maybe you can look at this documentation because it's available, and you can have some view of how risky they are. If the current liabilities and current assets are really matched together, then maybe they're not very safe because a little bit of a shock might put them under. If there's a safe distance between the liabilities and the assets, it's better. Now, the long-term liabilities and long-term assets is relevant to you if you just want to buy a ticket to go on holiday in a month's time. But if you want to become a shareholder, then that balance on that macro level will still be important to you. Do you want to be involved in this company? Does it look like this company is going to have a future? These are the beginnings of a very complicated set of documents, but luckily you guys are not accountants, so you don't have to go through all this of the complexity of all the aspects of the financial information, and I'm not an accountant either, so I wouldn't be able to explain it to you. But I think what this does is that it works as a good opening to the discussions we're going to have as to insolvency. So you can see this class as a snapshot into the company disclosures and the nature of the financial information that the company is meant to give. And that is a broad framework within which then we understand insolvency. Because on that, when we start talking about insolvency, we are just at the point that somebody comes and says, I haven't been paid, therefore I'm starting this process. But having done this class, hopefully you've got an understanding of how somebody ends up in the position that they've left. And the tragedy of it is that you could be owed a small amount of money. I mean, the amount of money that you need to be owed in order to process it's like £750 or something like that. So it does sound silly, but you could put Apple out of business if you've ordered a new iPad and you go there and they say, sorry, we don't have it for you, and we won't be able to refund you for a few days because we're suffering some problem with our current account. You are entitled to go and put them into that process. The next major things that are going to go bust in during this year, you'll be able to look at the financial statements and then go, exactly, it's like we saw in the lecture, these guys run for. If you have a deal with somebody, if you have a contract with somebody, how do you know what is in it? How do you determine what it is that you have to do? You can go downstairs to the cafeteria, you sit there, you point at the coffee you want, the lady there makes it, passes it over, you tap your card on the machine, off you go. Did you have a contract with Costa Cafe created through all this process? Yeah, you did, right? So, you didn't really say anything. However, there's a transaction. You got, say, your cappuccino and you paid money for it and they gave it to you and all the rest. So there's definitely something going on there. Now, if you wanted the cappuccino, coconut milk, let's say that all goes and says, the coconut cappuccino. The lady gives him a soya cappuccino, but he drinks it anyway. Then he gets sick because he's allergic to soya. Would he be able to go and sue Costa Cafe for getting sick? Or would he be able to say request a refund? Let's perhaps not take it to the whole being sick business, but could he go and request a refund and say, hang on a second, I wanted that one, you gave me that one? Yeah, he would, right? Because if we're saying that this is a contract and the expressly stated terms of the contract were coconut cappuccino, and he did not get a coconut cappuccino, he got a soya cappuccino, then obviously what he was promised is not what was delivered. This is a breach of contract. And then you fix that breach of contract in a variety of ways. One of the most obvious here in this scenario would be to get a refund. However, if he didn't really say anything, there are no express terms of the contract, then how do you know what's in it? So what's there to say that a coconut cappuccino contains coffee at all. It could be that they call it that, but it's got something else inside, right? It could be that it's not coffee, it's something else that tastes similar. Any other thing that you would expect to have, but it's not really there. So if you haven't expressly stated what you want when you're negotiating with the other party or when you're ordering from the other party, how do you know if you've got any expectations? And then if you're disappointed because these expectations are not met, how do you know if you have a right to go against them, to go after them? So if nothing has been said. So there are two sources in which a contract is populated with information. One is express terms, right? I mean, I'm going to buy a mouse and I say I would like an optical mouse rather than the one with a wheel, the one with a ball underneath, right? If you thought you were getting an optical, this was not expressly stated and you got something else, then the question is, what led you to believe that you're getting something that doesn't match what they gave you? So very often there are implied terms that come into the contracts. So if you don't have express terms to populate this deal, then you have the implied terms. And these implied terms, I hope that you learned about this when you were doing contract. Implied terms can come from a variety of sources. Either because you've done this before, right? You go every day and you order the same thing. So you explain to them what you wanted the first couple of times, but then they know what you have and they give it to you. So if I was the sort of person who had taste and I was going to Costa Cafe downstairs and getting the same cappuccino every day, if I did this every day, then the lady probably knows me, and when I'm approaching, she probably has it ready for me and I don't need to say anything. Yeah? That would be nice. It's like an American movie. Yeah? It doesn't happen here. Here, even if you go every day and you tell them what your name is, they still don't have a clue who you are. So if implied terms could come from prior usage, prior experience between the two parties and so on. Or, most likely, if we're talking about the sale of goods, which is the primary example here, they come from the law. It could be that they come from case law because something came up as a problem, it was discussed in the court, and the court said, for every contract of this type, to make the contract operational, we imply certain terms into this type of contract, or they come most usually by statute. So from the stuff that concerns you guys, most of the implied terms of significance to you, they come from statute. So if I've got the example of train tickets and stuff. This is exceptional. I don't know if you buy train tickets very often. I don't know if it's gotten any better lately, but it's like the world's most complicated multiple choice test. Yeah. So you just want the ticket to go somewhere, yeah? It will present you with 600 different options in prices that have thousands of pounds in between them, and then you have to sit there and wonder about it. But anyhow, once you got used to that, so these are various cases that have to do with express terms of the contract. As an example, they contain all the cases that you probably learned about in contract law when you go to buy your ticket and there's information written on the machine, whether that becomes part of your contract or not, right? Because there's a process in incorporating terms into the contract. And the implied terms, these are some examples of cases that they went through that process. The court thought that for this type to be operational, we need to imply certain terms in it. But they come from the statute, right? Now, you go Apple store down there, yeah, and you get in and you're thinking, I'm gonna waste some money today. And you buy yourself a new laptop, yeah? You bring it home, you turn it on, after a while, it doesn't work. You bring it back to the shop and you say it doesn't work. If they say, well, you lost out, sorry about that, but there's nothing you can do. Every batch has a bad one. You were the lucky one to get the bad one, so now, would you think that that's wrong? So you would expect that they're gonna take it and fix it considering you just bought it, right? Why? Did they tell you? There could be reasons why. It could be that they told you it comes with a 1-year warranty, so if it develops any faults or any problems, you can bring it back and we'll fix it for you or change it with another one. It could be that they expressly told you this. It could be that they said you can change your mind about the purchase without any reason at all. It doesn't need to be faulty. You can just change your mind. You've got 1 month. You've got 1 month in which you can, if you kept all the boxes and stuff, you can bring it back for a full refund. So it could be that they told you this. It could be that they didn't tell you this, but they advertised this. It's on signs around the shop, or they gave you a document, or it's written with your receipt, but that caused some issues. But let's say that it's present on the receipt, it's present on something that is inside the box when you open it. Very often you got warranty information inside the box, etc. But if it did not have any of those, so if your right to return it or have it fixed or having corrected, or if perhaps to change your mind, was not communicated to you, then why do you have such an expectation? Because then if you're not relying on express terms in your contract, and in order to rely on express terms in the contract, you need to go through the process that says this was communicated to me in a way that made it part of the contract. So therefore, I've got those rights and I can rely on them. If you don't have this, then you have statutory provision. For example, now, I mean, it used to be the Sale of Goods Act, but for consumer transactions now you've got the Consumer Rights Act. The Consumer Rights Act gives you the right to bring something back if it's faulty. They give you the right to bring it back if it doesn't match its description. If you thought you were getting a computer with a high definition screen and the one you've got does not, then this is not what you thought you were buying, so you can bring it back. If it is faulty somehow, you can bring it back. This isn't a warranty. This is a right given to you by the Consumer Rights Act and your expectations as a consumer. It's a gift to you by the legislator. In fact, it isn't. It's a gift to you by the Europeans who came up with that stuff that then became English law, but anyhow. What about the right to return? You guys probably have an expectation that if you change your mind about something, you can return it. Right? And it happens very often. And I bet you would be shocked if you bought something from a shop, you decided you don't like it, or you just found it at a better price and you want to get it from someplace else, you brought it back and they said, sorry, we don't take returns. They don't have to take returns because returns on demand are not a statutory right. Things being faulty, not matching their description, not being good enough are a statutory right. Returns at will are not. So unless this is an express term in your contract, you do not have the right to return something because you change your mind. The law operates ways in specific circumstances. If you buy something and you wanna, as I said, if it's faulty, it's a statutory right. If you just wanna return it, it's a contractual right that needs to be expressly mentioned as a term in the contract. You buy from Amazon, you can send the stuff back. You buy from somebody else, they might not give you that opportunity. You buy from eBay, it's very interesting. If you buy from eBay, whether you got the returns or not is clearly noted. Not everybody offers returns. But crucially, not everybody who sells on eBay is a shop. Because I could put my phone on eBay, you buy it from me. If it doesn't match what I said it is, if I said it's a Samsung and it's a Motorola, then obviously there's a problem. But if it matches its description, but then it breaks a week after, there's nothing you can do. I did not offer you any warranty, and I'm not taking any returns, meaning that the loss is on you. And because I'm not a shop, statutory implied terms do not come and help you, because all these rights from the statute apply when somebody is operating in the course of business. It's not my business to sell my old phone on eBay. So you need to, a part of what we do is to just get used to navigating these things, because people are usually good at remembering what the rule is, but they're less good in remembering the circumstances in which the rule applies. And people are in for a shock. And this hits you guys when some random website online, then you try and change it, and then you realize they don't have returns. Or you on eBay from a private person, so then there are no implied terms whatsoever. Yeah? And then you're stuck with something you didn't want. So all of that stuff kind of helps you navigate things that should be part of your personal experience, or at least they kind of link up with what's going on. Today we're going to talk about a concept that becomes very important and is quite a key to understanding how business operates, which is the idea of agency. Have you guys heard about agency before? So we're going to talk about what agency is, how it links up with the idea of organization in business, especially various types of marketing networks, the role that they play within this, the different forms that it takes, and then what an agent is supposed to do, where they get their authority, what are the boundaries in what they do, and what do you get out of being an agent for somebody. So we're talking about the nature, the types of agents, the duties and rights of the agent, and then what is the key legal information that supports all of this. So after you've gone through this class, hopefully you will know something about agency, so it will make some of the transactions that you get into as you're walking around the place a little bit more easy to understand. There are many things that look like agency, but might not necessarily be, and the language here is a little bit confusing because you get a lot of different things that are relevant to the way that somebody does business, to the way in which they bring their products to market and how they distribute and how they approach their customers that might sound similar to agency but are not necessarily agency relationships. In a nutshell, what is it? An agent is a representative of somebody else. But the key to the relationship is the contractual basis of it. You've learned in the law of contract that when people are negotiating a deal with each other, then you go through all these stages that, the kind of formulaic presentation of it is the idea of offer and acceptance and consideration and intention to create legal relations and all of that stuff. So if all these legal terms or legal requirements are ticked, then you end up in the end with having a contract between two people. And you've also probably heard about the doctrine of privity. Have you guys heard about the doctrine of privity? Say me and this lady here are having a contract together that you'll pay me 50 quid and I will write your essay for you, so you don't have to tire yourself. And then you don't pay me. I've given you the essay, you submitted it, you succeeded not being spotted for plagiarism, well done to you. But you haven't paid me. So then I go to your house and tell your mom, cough up, your kid owes me. Is your mom obligated to pay me? Alternatively, you pay me 50 quid to fix the bike. I do fix the bike, give it back to you. You don't pay me. I turn up at the house and say, hey, I tell your mom, look, your kid owes me 50 for having fixed your bike. Is your mom obligated to give it to me? That should not strike you guys as an unfamiliar concept. Rights and obligations out of a contract attached to the people who are within the contract. How do you know if somebody is party to a contract? Basically, it's consideration. The people who provide consideration are the people who are within the contract. The doctrine of privity is the idea that it's only people within the contract who've got rights and obligations arising out of the contract. So you cannot go to a third party, not part of this contract, and ask them to do stuff on the basis of the contract. If you need to determine how do I know if I'm in a contract, if you're providing consideration, you're in a contract. Meaning that if you're making a promise to the other party that you will do something or provide something that they consider to be of value. Issue that arises with agency is that the agent is an intermediary, is somebody else. When you go into the Apple shop because you want to waste some of your money and you're talking to some dude there in the shop and you order phone, you obviously have not ordered the phone from the dude in the shop, right? Because that could be some random dude that's just sitting there. You order your phone from Apple, the company, who runs the store, assuming that you went to the official store. Right? In any type of deal that you do, you walk into the Vodafone shop and you want a new contract for a mobile phone. Obviously, the deal that you want to have is not with the person who just happened to be in the store at the time. You want your contract to be with Vodafone. But you're talking to the person in there. So the person in there has got some involvement, is acting in some capacity, but they do not become part of the contract. So that person in there, most likely, is acting as an agent of somebody else. So the idea of agency is that you have a representative that brings a contract together between the customer and somebody else that they're representing, and that somebody else is called the principal. So when you're walking into any store and you're talking to the employee in there, you're not trying to do a contractual deal with that particular person you're talking to. You don't want that. You want to do a deal with the shop, with the business that is running this shop. So the person that you're talking to is an agent as an employee. They are an agent of the principal being whoever is running the store. So the person in the Apple store with the tight trousers and the stupid haircut is not there in their personal capacity. They're employees of the store and they're representing Apple. The person in the Vodafone store is not there in their personal capacity. They're representing Vodafone. Or if they aren't, then they need to let you know. So the contract that you're going to have is not with that person. The contract is with the principal. So the idea behind agency then, if you need to kind of nail this down, is that an agent is a person recognized by law as having the power to affect the legal rights of somebody else. So they are authorized to do this. They are authorized to create a contractual relationship between you and the other party. Agency is a relationship, obviously, that has links to the law of contract. Most usually we perceive it in kind of sales situations. Most likely when you're obtaining services, if you're trying to get a new mobile phone contract or broadband or whatever it is, or some sort of subscription service, right? You're going through an agent. Totality of this relationship isn't only reflected in the law of contract, but it's got some other elements as well that make it special. Agency is at its base a fiduciary relationship. You've ever heard of the term fiduciary? In law, you have relationships with people. Why? Either they're based on contract or they're based on something else, right? So usually you have legal obligations that arise out of contract or legal obligations that arise out of tort because you have a duty of care, for instance, that's been breached. But some legal relations, or they're defined by the law of equity. You ever heard of equity? The law of equity, in case you don't remember what it is a separate stream of legal provisions, and it has a separate legal history to the common law. The common law comes from what the courts were deciding on the basis of publicized and available rules. However, because the strict application of the rules sometimes led to injustice, you always had the option. You had the option of going to the king and saying, look, this ain't right. This isn't a fair outcome. Can you do something about this? And the king would go, yeah, right, whatever, fine. This happened again and again and again, and it started to develop a sort of consistent jurisprudence of its own. So the law of equity then became like these kind of ad hoc decisions of the king eventually became a body of law on their own. So the law of equity then creates all of these principles that are primarily concerned about achieving fair outcomes when you're dealing with the application of the rules. At some point, the courts were entitled to look at the two together. So the law of equity and the common law came together, and now they're led by the courts in the same way. They're recognized as different streams of jurisprudence, but they're still equally used at the same time. Now, if you're calling something a fiduciary relationship, it means that this is a relationship that is defined by trust and confidence of the people that are coming together in a way that transcends contractual relationships. Now, contractual relationships are, we agreed to do X, Y, Z, right? And this is the totality of our relationship. Beyond that, I don't care about you. So if our deal is, I fix your bike, you pay me £50, that's it. From the moment I fix your bike, I don't care what you're doing with life. But if our relationship is defined by the law of equity, then it means that I might have further obligations towards you. Maybe I should be interested not only that you got back the bike repaired, but also that you use it safely. That I've got an interest in your well-being, in your future, in the way that you behave towards what I gave you, and so on. So if you're saying that the agency relationship and the link between the principal and the agent is not purely one of having done a deal, but it is a fiduciary relationship. This means that you have higher expectations of agents in what they do. So the agent is not only supposed to do what the principal has authorized them to do, sell iPhones, do mobile phone contracts or whatever it is, but they are supposed to care about the business of the principal. So they have a responsibility that whatever they do promotes the success of the business of the principal, and they need to be aware of things that might be within technically the remit, but it wouldn't be a great idea for the shop if they did this, so they need to be aware of that. If you're talking about fiduciary relationships, if you're talking about the relationships of trust and confidence, it means that you've got this higher expectation who's being the agent to take care of your interests, take care of your business. Why do you need to employ an agent? It could be that very simply you need to get access to the customers, and there's no other way to do that. Many stuff happen online now in the sense that you can interact directly with the business, which is perfectly fine. If the business has got a website that is all automated, if the business is selling you car insurance, for instance, right, and you go on the website automatically generates a quote and gives you an option to purchase. If you go and purchase at that time, no human person is involved. Everything works on the basis of preset rules. It's like if somebody puts in this data, offer them this product at this price, and if this person accepts, it's done. Even the paperwork itself is generated automatically. It's emailed to you. That's it. You never have to talk to anybody. If that's the sort of business that you're in, then you don't really engage. You don't need an agent. The business can engage with the customers straight away. But it could be that you need the interaction of people in order to guide the customer, explain the product, explain the options. Maybe this is the sort of business that people like to see somebody that they're not happy to do automatically, right? And that's why you need a human intervention. And that human intervention creates the necessity to buying stuff on their own. You probably don't want to see people. Buying simple services like signing on to a new mobile phone contract or even various types of insurance products, maybe you don't need to see people. But if you're doing something else like renting a house, then you probably need to go see it. So you probably need somebody to take you there to see it. Or you probably need to send an estate agent to explain what it is that you're getting into. Or maybe the principal who instructed the estate agent has given them this brief. You do need the human intervention for certain stuff. The principal, who's the landlord, probably has instructed the agent, talk to the people. So the principal could have instructed the agent to say, I want you to meet with prospective tenants to make sure that they're okay people, that they don't look like bums and wreck the place, right? So it could be that the desire to have an intermediary, a human intermediary, comes from the customer, or it's coming from the principal. It could be that the product is too complex, and people cannot be trusted to pick automatically. They cannot pick automatically because it needs to be customized. They just don't want to do it because it feels too risky, and you need to be able to talk to somebody. More complex types of insurance products, then perhaps there's no office that you can go to, but you can ring them up and talk about this to make sure that you're getting the right thing for you. Or investment products, for instance. Nobody is going to buy investment products and put their money into something through a purely automated system, because they will need to discuss, if we're talking about higher amounts of money, they're going to do with your money. So all of that explains why there's a business need to have agents in certain circumstances or not. But these things are dynamic. I mean, the ideas change. People used to go to a travel agent. And people used to go to travel agents, check what's available, and then book it themselves. Now everybody books everything online. I think that seemed risky to do on your own in the past, now is common practice. So maybe in a few years' time, you're going to be able to rent an apartment without even seeing it, because you're going to be able to do a 3D simulation and see the thing really nicely, and everything's going to happen online, and it's much cheaper to do it that way. So everybody will be happy to do that, but we're not there yet. Okay, fine. So we've discussed the core of the idea of what it means to have an agent. We've discussed what the contracts are meant to be about and who becomes part of this contractual relationship, meaning not the agent, but the customer and the principal. And we've discussed rationale for this. So why happening, and why is there a need for an agent, and what do they do? One of the important things to nail down is the idea that the principal will be liable for the actions of the agent. Because obviously, if the agent is not part of the contractual relationship, then the contract is created between the principal and the customer. And whatever is in that contract, the principal is obligated to perform. Because so far as you're concerned, you have a valid contract with the business, whatever the entity is. So you don't care if the agent negotiating this with you has made a mistake. Yeah? Now, for some of the more complex stuff, maybe the principal needs to double check and give authorization for whatever has been agreed by the agent. But if the deal is different, that the agent has full authorization to complete the deal, if the agent has made a mistake, then they can back to you. Meaning that if the person in the Vodafone shop has made a mistake and is actually giving you a phone for a price that they're not allowed to give because they got confused or whatever, then if you have a valid contract, that's it. The principal cannot come back and say, oh, sorry, this person didn't know what they were doing, or they confused, or they pressed the wrong button on the computer. He's going to be obligated to say, right, now we have a contract, so if I don't want this anymore, I need to check whatever options for cancellation or termination exist within the contract. But they cannot deny the existence of the contract. So this is important for you guys to remember, that the principals will be liable for the acts and omissions of their agent. For things that fall within the agent's authority to do, sometimes even for things that are outside the agent's authority to do, the principal becomes responsible. Sometimes it is obvious that somebody is an agent because their title or their job description or how they represent themselves will make it clear to the customer that they're an agent. So if you walk into a shop and somebody is clearly an employee of the shop or has a label that says customer representative, then you know that you can talk to them about doing a deal with whatever this shop is selling. Other people have got the function of agents as part of their job description, even though they don't turn up in an outfit that identifies them as salespeople for a shop. For instance, company directors by default are the agents of the company. So if you're named as a company director on the information, every company has got its information about who is running it publicly available. So if you check, in X company, who is the director, and you get a name there, if you're dealing with that person, then that person represents the company and you don't have to worry about it. Equally, if you're in a partnership, each partner of the partnership automatically is an agent for all the other partners. Employees will normally be agents of the business if they're in a marketing or sales or something that involves them interacting with the clients. But the mere fact that you're an employee does not automatically make you an agent. So I am an employee of the University of Westminster. This doesn't mean that I can walk down to Tesco's and order sandwiches for everybody on behalf of the university, because I don't have authority to make purchase decisions on behalf of the university. If my authority is not obvious and I do something on behalf of somebody else and there is no reason why they would assume that I'm representing somebody else, then whatever contract has been made is between me and the person that I'm dealing with. So it's important for you to distinguish areas when somebody identifies themselves as an agent of somebody else and then the customer knows that there's a principal with whom they're going to have the contract. Situations where somebody does not really identify themselves in that way, but it's obvious that they're there on behalf of somebody else, like a company director or a partner or a purchasing manager in a business or whatever. And situations where somebody is linked with entity, but then it isn't immediately clear that they've got the authority to represent. I cannot, as an employer, I cannot buy stuff and charge them to the university. But if the university is tasking me with a particular thing, so we're having an event here and we run out of crisps, and the head of school gives me a credit card and says, run down to Tesco and get us some more crisps. When I go there and I present the school credit card, then the way in which I'm paying is going to demonstrate that I'm not buying for myself, I'm buying for somebody else. But there needs to be an additional step that communicates to the other party that I am acting on behalf of somebody else. Otherwise, if it's not obvious, if there's no link, or if there's nothing to suggest that, the danger is that the contract that I'm creating is going to be just between me and the shop. So if for some reason I don't pay or I do something wrong and I'm after somebody, they're going to have to come after me. There are situations where you have a non-obvious, an agency relationship that is not revealed. So you're dealing with somebody, you're the customer, you think that that person is the person who's going to provide the service. It turns out they're an agent for somebody else. But what happens in these cases, so that the customer is not disadvantaged, then both the person who's the agent and the person that they represent, without saying, they both become co-responsible for delivering the service. So if I'm dealing with somebody and I book the service for my car, and when I turn up there, it's actually somebody else, or the garage belongs to somebody else, not the person that I was talking to, and I'm like, oh, what's going on here? I didn't think I had a booking with you guys. Both the agent who did not disclose the relationship and the new person, they both become liable for me to do what we had agreed, right? So in a way, it spreads the responsibility to more people, but in a way that it does not disadvantage the customer. If we go back to this idea of who has authority and who is allowed to present themselves as agents and be recognized as such, your options are actual authority or usual authority. Actual authority is I'm wearing a t-shirt that says I'm an Apple salesman in the Apple store. Usual authority is I don't wear the t-shirt, but I'm there. I'm the person sitting behind the counter. You've done business with me before. You recognize me as working for somebody else. Apparent or ostensible authority is the idea that I am not wearing the t-shirt. You haven't done business with me before, but the circumstances are such that they give the impression that I'm allowed to do this. One of the dangers with this is that it could be that you recognize somebody as having the authority to bind somebody else, but you don't know the limits of that authority. If the limits of the authority are not clear, then again, the emphasis in the law is to protect the customer. So the business is not going to say, oh, hang on a second, this person was authorized to do contracts with you up till that level, but contracts are not going to respect the higher contract because they breached their authority. So as far as you're concerned, you didn't know. So this person was recognized as a representative. You don't know the details. That's why I told you earlier, you can be dealing with an agent and the principal becomes responsible for the actions of the agent, for the things that are directly authorized to do, and sometimes for things going beyond that. But it's a matter of assessing the circumstances and figuring out where to draw the line. Something that's completely random and completely unrelated to the business of the principal, then you cannot pass this on to the principal. But for things that kind of look within matching the flow of what the person is doing, then all these obligations are going to flow up to the principal. But what exactly are the duties of the agent, right? Assuming that somebody comes here and says, would you guys like to become representatives of one of the publishers, so then you can push the textbooks to the rest of the students, right? Would you like to act as an agent for the university press and take orders from them and give the textbooks to your fellow students? What are the duties that you will assume if you accept to act in that position of an agent? The first and primary duty is the idea of having a duty of care and skill. An agent owes the duty to the principal to exercise reasonable care and skill in performing the duties. This has various expressions, both in the law of contract and in the law of tort. But the idea is that you are not negligent or reckless in the performance of your duties. Meaning that you do a contract to students and they have ordered from you, right? When you're delivering the books, you have to, it's part of your job to make sure that you give them what they asked for. You don't give them the wrong copy, or you don't give them the wrong edition, or you haven't left them out in the rain to get all wet. You see, you have to perform as you would perform employees about the level at which you're meant to do your work. The same thing applies if you are an agent. I already mentioned that some aspects of how we understand your obligations are the things that come under the label of fiduciary duties. Now, this is equity. You have an equitable obligation to protect the principal from abuses. Not only you need to respect your contractual obligations, but also you need to take care of your agent's interests. If it looks like, for instance, that the customer is not right, there's something wrong about them, they don't look like they're gonna pay, or they look like they're running a scam, it is part of your job not to do the deal with that customer, or to take protective measures, for example, to protect the principal from suffering. A lot of what comes into this kind of fairly vague definition of fiduciary duties and equitable obligations might be new to you guys, especially because you haven't spent a lot of time doing that stuff. So when you come across these concepts of what the fiduciary duties are in the textbook, you need to read it a little bit more carefully, because this is likely to be more new to you than the other stuff that you've seen. Some of the other duties are more obvious. The agent is not supposed to find conflicting duties. So if you accept to be an agent for Oxford University Press, and you also accept to be an agent for Pearson, and they both make these textbooks on the same subjects, that they're competing for the same market, are you going to buy your textbook from one brand or the other brand? If you are an agent of both brands at the same time, which one are you going to push when you're trying to sell it to people? So the fact that you have a conflict of interest there, or you have obligations that by necessity don't match, means that you're not doing as an agent. Yeah? You cannot simply be promoting to the same people two competing products. The one that they choose is okay, but the one that they haven't chosen, you're in breach of your duties to your principal. The agent is not allowed to be in a position of conflicting duties, and also they're not allowed to make a secret profit or to accept bribes. So you cannot go to the person at the Vodafone shop, cannot tell you, look, these are the options if you want the new iPhone, right? But if you slip me a 50, I'm gonna put on the computer that you're getting, so I give you the iPhone anyway, nobody's gonna know. That's not right, because in that case, the agent is accepting either a secret profit out of the deal or is accepting a bribe, and they are doing this for their personal interest in violation of the interests of their principal. If the shop was doing this, then obviously not doing a good deal for the brand, the business that they're representing, they're doing a good deal for themselves. So this is not allowed. And you also have a duty to account. So whatever money the agent gets, whatever jobs the agent gets, needs to give an accurate information and accurate representation about this to the principal. So the principal knows how the business is running through this agent. And finally, unless specifically authorized to do this, the agent is not allowed to delegate to other people. So university hiring you to be the agent is probably because they like you for some reason, right? Or you got particular skills or connection. They didn't hire you for you to sit at home and then hire somebody else to go do the job while you never show up. Unless they specifically told you, yes, you're allowed to recruit other people to work for you, then you have an obligation to do the whatever the work is yourself. What are the rights of the agent? Well, if you become an agent for somebody, you're probably not doing it for the glory, but you're doing it for the money. If you accept to work as somebody's agent, you're doing it because you actually are trying to make a living. So the primary right of the agent is to receive payment for the work that they've done. And in order to receive payment, it needs to be specific in the deal that they've got with their principal. What do they need to do in order to get that payment? And they need to be given the opportunity to earn, if they're earning a commission, they need to be given the opportunity to earn that commission. So if you are, people in the Apple store are getting commissions on sales that they make, and that's the deal. The deal is you're on minimum wage, but then you get 2% on every iPhone that you sell. You might think, yeah, all right, that's not a bad deal. But if they stick you in the warehouse, so you never get out to meet any people, then you don't have the chance to make any payments. Therefore, you're not given the opportunity to earn your commission. That would be wrong. That would be a violation of your duties. So if you're hired in order to represent some product, first of all, you need to have access to the clients. You need to be given the opportunity. Where are the clients? Are there numbers you can call? How do you get this information? So you need to have the chance to do this. And this is not kind of good business practice. It is an obligation on the part of the principal to allow you to do this. Now, of course, if you're doing random stuff and you're acting outside the bounds of your authority, then you lose your right to earn a commission. So if you suddenly start selling iPhones at half the price at the random discount that you came up with, and then you turn up and say, oh, I'm so happy I sold hundreds of them, then this is you not doing your job properly, so you have lost your right to earn a commission then. All of that stuff, these rights and these expectations, are expressed in a series of legal documents. A piece of legislation that deals with the rights of agents is this, the Commercial Agents Regulations of 93, statutory document where it contains, in summary, all of these things that you would expect to get as an agent, what you need to do, but also what you expect to get. A lot of that stuff before this legislation were present in the common law, so all these are not new. However, they've been solidified in a statute which is easy to understand. Source of the information, the rights of agents are more secure now after the passage of this legislation than they were in the past when we were only reliant on the common law. Plus, this creates some additional rights about compensation that you have when the relationship is terminated, because one of the problems that you've got with agencies is that it's rather fluid, right? So what happens if you get the agency job, and before you've even had the chance to start, they call you and say, we don't want you to do it anymore. Or if you've started approaching people, you spent money left and right, you're running around here, you're buying coffees for all the students to get to know them so you can kind of start chatting about the textbooks. And while you're doing this, OUP calls you and says, we don't want you anymore. What if all the expenses? What if you're in the middle of doing the deals and then you're cut off? So you would have some expectation of some level of compensation if that happens. This is not quite employment, right? You don't have employment. If you had employment law rights, it would be easier. You don't, because you're not an employee if you're an agent. Not necessarily, right? But still, there needs to be some protection for you when they want to kick you out. Again, that stuff is in the Commercial Agents Regulations, and this goes rights that you used to have in the common law, so this makes things a bit better. Today's class is on marketing arrangements. You can use this as a bridge with some of the other material that we've done, right? And it brings stuff together in linking various aspects of the module, in helping you to understand how people will go into business and how they will take an existing product and trying to sell it here and there, and what are the legal connotations of doing this, and what are the legal mechanisms and frameworks that will allow somebody to do this. So what we will talk about, we've already discussed agency, right? And agency is the key way of sort of getting yourself some help to break into a new market or bring your products to somebody else. Now, so since we already talked about agency, we will talk more about distribution and some other things like franchising and so on, so you get an idea of the types of legal relationships involved in those. There are a variety of avenues that one can bring goods to market that we have seen in the past. Let's perhaps take a little bit of time to go through them. Let's try a little bit of time to go through them and see if we can define them adequately. Now, we know what is an agent, right? An agent is a third party that introduces new customers to the business. So the job of the agent is to go out there, liaise with the customers, and bring them into contact with, say if we're talking about a manufacturer that's trying to bring some stuff to market, bring them into contact with the business and try and get the deals done. And the important thing about an agency relationship is that the resulting contract is between the customer and the principal. The resulting contract in an agency agreement is going to be between the agent, right, and the principal. The agent is not part of the contractual relationship themselves. But what about other stuff, right? We get a lot of material on distribution and distributors. Now, what does a distributor do? A distributor buys the goods from the business and then makes them available to the customers themselves. The distributor gets title to those goods. An agent would not get title to the goods. The agent is just a conduit, but the distributor breaks up the contractual relationships. So, you're a shop that sells Apple computers. You buy them from Apple, you attain title to the goods, you have them in your warehouse, then you sell them on to customers. The ultimate customer then has a contract with you. They might have like a warranty, something provided by Apple, but this gives them rights through other mechanisms in the law. It does not give them a contractual right because they've got privity of contract. So in a distribution relationship, you have to do two jumps to get from, say, the manufacturer to the ultimate consumer. One contract with the distributor, a second contract with the customer. In agency, the person in the middle does not participate. So you jump directly from the manufacturer, if you want, to the customer. So there are other things that come within this. We've got things that are known as commission agents, for instance. There are some opportunities within this where the customer will contract directly with the agent. It reminds you some of the things that we have done with undisclosed agencies and so on. So you can mix the types of relationships. So sometimes if you get a title that seems a bit unfamiliar, like a commission agent or something, you need to look at the detail of the contractual relationship and how it's structured before you figure out who is contracting with whom. If you see the word consignment to do with goods, it means that the goods are sent by the business to this person called the consignee. Now, these are usually coming with options to buy the goods, but they're not a direct transaction of sale. If you see stuff like direct selling, for instance, it could be that the customer buys directly from the manufacturer, right? If you go to, how do you get yourself your Apple computers, right? You either got them from a distributor, right, or an authorized retailer or something like this that is not Apple itself, or you could go into the Apple shop down there. I mean, what the Apple shop down there on Regent Street, it kind of looks like it's directly Apple. It doesn't look like it's a separate distributor, right? Thousands of people in there looking at things that all look identical and all being completely amazed that they're looking the identical things because it's a new version of the identical thing they already have at home. Yeah, but it's very popular with the tourists. I think that's an Apple-owned store. So when you buy direct from the company. But what about franchising, right? What's this idea of franchising? Franchising is a much more complex relationship, and perhaps it's worth talking about this in a moment because I've got a separate slide. Maybe we should start with the distribution, right? Now, distribution is the most common way in which, if we're thinking about marketing relationships, right? How do you get to sell your stuff to the ultimate customer? Distribution is the most common way to get this stuff done. But you've got, depending on the details of the contract, you've got different types of a distribution relationship. Right? We have, for instance, what we call exclusive distribution. If you have an exclusive distribution, the only person that you can get these goods from is the distributor. Nobody else can do it, not even the supplier. So if you've got the manufacturer would not be able to sell directly to the ultimate consumer if they've signed something that is an exclusive distribution relationship. Why? Why would you do this? It could be that you need to incentivize the distributor to try very hard to promote and market your goods. And in order to do this, you do not want the distributor to face competition. If somebody was able to buy their goods directly from the manufacturer, buy them from an authorized retailer, buy them from resellers all over the place, buy them at the supermarket, then the value of this distribution agreement is going to be much less. So this works well for things that already have an established market. So if you're selling, Samsung mobile phones or iPhones, everybody sells them, people search widely for the best deal and so on. It's not a problem because there's a lot of demand. But if you're bringing a new phone to the market, or you're a new brand that people don't know, maybe you want one person to be responsible for doing it. So they know that if they do the job properly, they market it appropriately, they advertise it well, then they take all the benefit of all the sales because everything has to pass through them. And you see this on occasion. New products that are coming up, that especially in high technology items, you might be able only to get them in one place. This is to protect the profit margins of the distributor. And that's why you might give somebody an exclusive distribution agreement, which means that you wouldn't even be able to buy them if you went to the manufacturer directly. So I can't remember now. There was a point you couldn't get the Motorola phones. You couldn't get them anywhere other than particular distributors. So it might be that this is a type of relationship. Sometimes you hear that you can only get this product on Amazon, for instance. Nobody else carries it. It is because they've got an exclusive deal. And I'm not talking about the whole range of products of a manufacturer. It could be a particular thing that they launch a new phone and they say this new phone is only available on the O2 shop or on Vodafone, right? Again, this is part of an exclusive distribution agreement to channel all the custom to a particular place. Now, if you have, you could have something else that is called a selective distribution. Now, a selective distribution means that you control how the distributor makes their goods available to the public. Why would you want to do this? Why shouldn't you leave your distributor free to sell to whomever? Why restrict the type of customer? It could be that you're trying to maintain the integrity of the brand, right? If you're selling designer sunglasses, maybe you don't want your designer sunglasses to end up at Lidl, right? Or at the corner shop somewhere. Maybe you want to make sure that the person responsible for distribution in the UK only makes them available to opticians or whatever, shops that look fancy. Yeah. So it might not necessarily be a matter of price, but it might very well be a matter of perception. You want to buy Ray-Ban glasses. In Greece, you can buy things that say Ray-Ban on them from, a guy on the street who's sitting on the pavement, or the kiosk, or the shop, or the opticians, and they range from €5 to 500. But everybody wears them and they all look the same. Some of them might not be genuine, but it tells you something about maintaining the integrity of the brand and the perception of the brand. If here you can get specific types of glasses and you can only get them from the more expensive shops in the high street, if you see people wearing them, you're thinking, all right, this is more likely a genuine item, this is something more valuable, so there's an incentive for me to go and spend a lot of money to get one. Yeah. So you've got these things. Agency we've already discussed. Now there could be deals that include stuff like exclusive purchasing, for instance. This is an obligation of the distributor to buy all their goods from the supplier. Why would you do this again? Because it binds the supplier and the distributor together in a sort of unique relationship. If you are Boots, for instance, and you're selling Ray-Ban glasses, if you have an exclusive purchasing agreement, it means that Boots will only buy Ray-Ban glasses from the manufacturer directly. They cannot source them from other places. They might be able to get them cheaper from other places, but a deal like this ensures the income for the manufacturer of the glasses. Yeah, and then Boots is going to get some perks or some benefits for doing this and denying themselves the opportunity to buy them in the secondary market. Other types of distribution agreements, we've got non-exclusive distribution. It could be that you appoint a number of distributors, so you lose the benefits of this unique relationship that we mentioned before. But if you have a product that sells very well, you want to give a lot of people the opportunity to buy it, so you might need to have more than one distributor.
expensive but commonplace electronics, like all these Apple stuff that you've got, you can buy them everywhere. What you have is a non-exclusive distribution chain. Exclusive supply is a situation where the supplier to a distributor. Normally you will have a combination of an exclusive supply agreement and what we saw up here as an exclusive distribution, so it binds the two together very closely. Sole distribution is a type of thing where the manufacturer or the supplier can also sell themselves. Let's see a little case study as to and think about what would be the appropriate selection of a relationship, right? Now, you're going to meet a client. The client is a sewing company, right? So you've got your meeting, and the director of the thing tells you that they've got new product lines. He wants your advice as a lawyer who has studied business law on what would be the appropriate marketing arrangement. Yeah, what is the best way to get their things to market and expand as much as possible. So the company wants to sell its famous cloth. They want to sell it into smaller pieces to make available for people to use at home. They think that they want to sell this to upmarket retail stores in a variety of countries. So they're thinking about big shops like Liberty's in London and so on. They also have a range of limited edition silk and wool fabrics that are very nice. And they want to make this available for fashion designers, right? And they're thinking particularly about fashion houses like Italian fashion houses and so on. But of course, they've got a little bit of a problem getting this to the Italians directly, even though they think there might be a market there, because they don't speak to anybody down there. So they think there might be demand, but they don't actually have the contacts. So if they ask your advice on how to bring these things to market and how to make it available, if you think about all the stuff that we've seen, some stuff sort of jump out as more appropriate, right? Now, for the first situation where they're selling the high quality cloth for people to buy and use at home, they want to maintain the integrity of the brand, so they want it to be sold at upmarket retail stores, right? But they're not particularly picky, and it's not the sort of product that you need to provide lots of aftercare or to provide explanations as to its use and so on. It's cloth, people buy it, they use it at home, they don't have to come back to you for any assistance. It's not like an electronic thing when you need to provide support perhaps if there are problems. So they probably don't want the cloth just to be sold to everybody and people can pick it up in in the corner shops, etc. But on the other hand, they don't want to be very involved once the cloth gets sold. So they could think of some sort of distribution agreement. It does not need to be. It does not necessarily need to be exclusive, right? Because you can have more than one stores in London. You can have it in Harrods. You can have it in Liberty's. You can have it in. What else do we have? What's the one on Oxford Street? The big one. Selfridges, yeah. So these are still nice big stores that people will go and because they've got the perception that they're getting quality. So you could go, for instance, for a selective distribution thing like we see here, right? That allows you to go into particular stores. It could perhaps limit the stores to sell retail, so the stores do not pass it on to somebody who then makes it available at someplace else that's not controlled. And I think this could work well for them. Yeah. Now for the Italian thing, it's slightly different because since they don't know anybody, they will have trouble identifying where to sell the stuff to begin with. So it's not necessarily control of what happens with the product once you've sold it. It's figuring out how and when to sell it and to whom to sell it to. So I think an agency might work better for them in the second case. If you get an Italian agent that is in the business, can can go, bring you into contact with the people that you want to sell the products to, establish a relationship, but then the resulting contracts are going to be between Nordic Sewing and the Italian fashion house, and because they're contracted together and they're in contact together, they can develop this relationship. It could be then that the designers tell them, could you guys produce something more for us, something different? We were thinking about this and that, so they can develop more product lines and they have more stuff to sell arising out of the relationship between the two. So if you want a more intimate relationship, a better connection, and you're not afraid of having the contract directly with them, then that could be a good way to sort of break into a new market and create all those links that you need. Of course, the downside is that if you're contracting directly with these people through an agent, the liability is yours. So if something goes wrong with the fabric, then they're gonna come back to you. Or the moments of the contract, you're directly liable. You might have concerns about the law that applies. Maybe you're not familiar with Italian law and so on. But the closeness of the relationship and the opportunities that this gives needs to be counterbalanced against the risks of having direct liability arising of direct contractual relationships with people abroad. The benefit of the distribution would be that once you sell it to them, you don't care what happens with the ultimate consumer. So long as you meet legislative requirements that the products are safe and so on, then it's not your problem. Now, were you to draft a distribution agreement, or to sort of interpret the terms and conditions that are in a distribution agreement, you would be looking at things like these here. You will normally have, you have all that stuff that you've got in a contract generally. That's the first 2 points, but you would have information as to whether you need to appoint any particular agents, right? So if this is a distribution agreement that contains within it, it could be called a distribution agreement, but it contains within it an agency relationship, yeah? So it could be that somebody acts in both capacities, as an agent for certain types of deals and as a distributor for other types of deals. So these are all the things that you need to consider here. Are you just selling things on, which will make a much simpler contract, or are you selling some of the things and then the other things the person is supposed to act as an agent to pass them on to the market? So if you're thinking of an agency relationship, then you need all the information about the appointment of the agent, the rights and liabilities, the principal's rights and liabilities, and all the things that we had seen when we did our agency provision. And what you will be thinking throughout this is the extent to which you are happy to assume contractual liability directly with people down the line, or which will happen through the agency, or you would like to break things down to create an artificial block, if you want, between the contract, to break the contract between you and the distributor, and then the distributor will have a follow-on contract with the other. Franchising is rather different, and there are a few things that are unique about franchising that we need to be aware of. Franchising is not a single contract, it's not a single relationship. Franchising works out of a bundle of contractual relationships. It's a whole bunch of things that come together in order to achieve something. Now, many of the things that you see here operate as franchises. The idea is that somebody opens a store that looks exactly the same, like a wider chain of stores. But this store is owned by the person. It's not owned by the chain. So you see a lot of McDonald's restaurants, a lot of Subways, Pizza Huts, and so on. They're franchises, right? You could have some that are owned directly by the company, but the chances are that most of them are run by individual people. So how is that going to work exactly? I'm thinking I can open a cafeteria around here, and I'm thinking that I could, call it Yannis Cafe and make great coffee and, sell it to the students here, and that's gonna be fine. But maybe, the tourist trade passing through, it feels uncomfortable going in a local coffee shop that, you know, it might look nice, but they don't know what it is. Maybe they don't know the quality of the coffee. They don't know the people who are in there. So there might be a benefit for me in using a sort of brand that exists that people will recognize, right? You go to a foreign country that you've never been before, everything looks a bit unfamiliar, but you're thinking, oh, okay, I can have something to eat there, I'm not going to get myself poisoned or, you know, ripped off or whatever. Or actually, you know you're getting ripped off, but you know how. Okay. So if I were to open a Starbucks, then I could do the same business with you guys, because I'm next door, so you could come and get the coffee from me, but also tourists passing through Regent Street would see, there's a Starbucks there, let's go eat and get the free internet or whatever. Now, what I'm getting is that I have the shop's mine, the list is in my name, and I call the stuff. But how do I get it to look like Starbucks? I'm going to be like a distributor of Starbucks stuff in a way. So I'm not an employee of Starbucks. I'm going to be working in my name, and you know, the invoices and stuff, they're all gonna be in my name. But what I do is that I buy from them the opportunity and the ability to use their branding. So they will sell me an information pack about what I need to do. They will sell me all the stuff that I need to put in the shop to make it look like all the other shops, so it's consistent with the brand. They will train me and my staff on how to do stuff. They will sell the equipment that I need in order to make the coffees. So I will get a package that contains a series of material things, the things that need to be in the shop and the machines, and I will get the training, right, as an employee development thing, but I will also get a lot of intellectual property covered stuff. Their logos, all their trademarks, their designs, all of these things. So these are intellectual properties, right? They are creations of the mind that are protected and they've got their own legal expression. And this is not something that you can use without the other person's provision. I cannot make myself look like Starbucks and call it Starbucks, right? So this is not going to work. They're going to come and sue me. And there are various mechanisms in the law that will allow them to do this, because these things are protected, right? They're their intellectual property. So I will only be able to make it look and work like Starbucks if I have a deal with them. So they are giving me use of their intellectual property. They're providing with material goods. They're providing me with training and other information. And I will also probably have an exclusive deal with them that I buy my consumables from them. So they sell me the actual coffee, the coffee beans that I need to make the coffee, and all the other knickknacks that they sell in the shop. Yeah. And as a result, I can either pay them, so the financial arrangements are varied. I could either pay them a flat fee every month. I need to pay them something up front, but then I could pay them either a flat fee every month, or I pay them a percentage of my profits. And so long as this is going on, I can use their things, right? And I have to buy all these things from them, but I also need to give them a cut of my profits. This is what they get, and what I win, a recognizable shop that might be more attractive for people to come around. It might be a lot cheaper for me to run the shop without the franchise, clearly, right? Because if I don't have to buy the coffee from Starbucks, I can select from wherever, so I can get the cheapest price, or I can probably or whatever it is. But then I'm not allowed to have something that kind of looks like Starbucks, even though you get a lot of stuff that kind of look like chains. But if they come after you and say that you're trying to deceive the public by giving the impression that you have a McDonald's or a Starbucks or something, you get in trouble. But it's not necessarily an easy thing to run a franchise, because it is very expensive to maintain the right to use all these things. Now, the legal connotation of this that gets a little bit uncomfortable is that you might get stuck if actually the company has so much control over you that you're not really running a franchise in your own name, but you're an employee of the company. And companies have been trying to exploit this not to give people the rights of that they would have as employees and the protections that they would have as employees that we saw in our class last week and we explored in the tutorial, by trying to pretend that they're running a franchise. So the law and, there's both tax implications here, both the revenue and the courts have been very careful about trying to distinguish between what would be an independent contractor running a franchise or something like that, right? Or somebody working in their own name, and somebody who is effectively an employee but they're not given the title of employee to evade either national insurance contributions or employment rights or whatever. Yeah? So I've got a couple of cases here that you guys can follow up and see the tests that the courts are using to distinguish between the two. And because the idea of a franchise is a rather attractive idea, unfortunately it has a lot of abuse linked to it, and there are all these kind of evil pyramid schemes. Do you know what that is? What is a pyramid scheme? That I will hire you to sell mobile phone covers, right? And I'll give you, this is a great deal, you're gonna make a lot of money, right? You buy them from me at £1 each, and I'll pay you, you can sell them for £10. And if you introduce another person to do this and pay me, £1 each for a box of cases, I'll give you £50 bonus. So basically what happens here is that everybody comes and buys a suitcase full of mobile phone covers by introducing their friends, so they get an initial payment, right? And then everybody ends up with all these suitcases of stuff they cannot sell, and at some point I run off instead of making any additional payments that you have to do, and you're all left with a bag of useless iPhone covers. Yeah. So usually this works in financial stuff, that you make an investment, you give me £1,000, I say in a month I give you £2,000. Right? I do this for a few months till it becomes known and everybody goes, wow, my God, man, this is such a great deal. You should give this guy your money. Look, it works. I got my money back. I'm rich now. And once I've collected a lot of money, at some point I bugger off. Yeah? So some of the franchise stuff have been known to lead to these types of abuses, especially when we're talking about types of distribution relationships or employment-like relationships that are the sort of work from home stuff. You see ads all the time that say you can make a fortune working from home. No, you cannot. Yeah? Probably the person asking you to do it is going to make a fortune by you trying to do it. Yeah? And here's some information about the intellectual property rights that come with a franchise agreement, and this is the very important reason why you cannot simply get away with it by running your own version of Starbucks, and why you cannot get the things to look like something that people recognize, therefore they come and buy it from you. And intellectual property has got many expressions. There's the protection of sort of artistic production or authorship that comes with copyright, right? You've got the protection of logos and things that you recognize that are used in advertising and promotion and so on, that is protected by trademarks. And you've also got the protection of inventions, of physical stuff or chemical stuff or whatever, that, for instance, this is patented, the three-headed shaver from Philips, and protection, the patent is there to protect things like industrial designs and inventions and so on, things that are in the physical domain. So intellectual property helps protect both creations of the mind that have got like a virtual expression, but also things that are physically available. And it's considered important because if you do not protect this adequately, it takes away people's incentive to engage in research and innovation, because then they cannot profit from the things that they do. Yeah? You guys are all familiar with intellectual property? Yeah, that doesn't stop you from downloading all that music and all those films, does it? Netflix, you pay the license to use it. But I bet there are some people in here who don't use Netflix but download. Who's looking guilty? Yes. And I love you get the signs that if you download things illegally, you're helping fund terrorism. Yeah, I thought selling all the oil helps fund terrorism, but hey.
The Consumer Rights Act 2015. This lecture discusses the Consumer Rights Act 2015 and the areas of the module it influences. We start with some background to the creation of the Act and continue with an overview of its main provisions, highlighting its departures from previous legislation students of contract law will be familiar with. This is followed by a section consisting of a practical summary of the information. The lecture finishes with a short discussion of a relevant problem question. Background. We start with a presentation of some background to the creation of the Act. There had been a wide academic debate on the need to reform consumer protection provisions in English law, specifically on the issue of the treatment of unfair terms. For example, it was widely acknowledged that there was a significant overlap between rules over exclusion and limitation clauses contained in the Unfair Contract Terms Act of 1977 and the Unfair Terms in Consumer Contracts Regulations of 1999. In addition, the Unfair Contract Terms Act is a complex statute, making it difficult to understand, particularly for the non-lawyer reader. Also, parts of the unfair terms in consumer contracts regulations are expressed in language which is alien to English readers, lawyers and non-lawyers alike. There is also the fact that the earlier legislation, in often concentrating on protection for consumers, ignored the fact that small business contractors may well be in just as disadvantageous a position as regards bargaining power as the individual consumer. Concerns about these issues led to the Department of Trade, as it then was, asking the Law Commission and the Scottish Law Commission in 2001 to review the legislation. That review was completed and the results and recommendations, together with a draft bill, were published in the Law Commission's 2005 report on unfair contract terms. The following are the main points to emerge from the 2005 recommendations. Both the Unfair Contract Terms Act and the regulations should be replaced by a new unified Unfair Contract Terms Act. Only the natural persons should be regarded as consumers, and then only when acting for purposes unrelated to any business in which they run. This, by the way, would have the effect of reversing the decision in R&B Customs Brokers versus UDT from 1987. Certain terms which were effective to exclude liability by virtue of the Unfair Contract Terms Act, for example under Section 2.1, should continue to be ineffective. Most terms in consumer contracts, whether or not negotiated, should be subject to a test of reasonableness, with a key exception relating to core terms, for example the price. Even these needed to be transparent and in line with the consumer's reasonable expectations in order to be valid. The test of reasonableness to be applied should be whether the clause was a fair and reasonable one to include in the contract. Factors to be considered in making an assessment should include whether the clause is transparent, its substance and effect, and the circumstances in existence at the time it was made. Lack of transparency could in itself render a clause unfair. Guidelines for reasonableness, such as those contained in Schedule 2 to the Unfair Contract Terms Act, should be included in the new Act. The contra proferente should be given statutory force in consumer contracts. You will remember that the rule means that limitation and exclusion clauses are interpreted against the person trying to rely on them. An indicative list, broadly similar to that included in the regulations, should be part of the new Act. Examples of unfair clauses would be included in the explanatory notes published with the Act. The burden of proof of fairness and reasonableness in consumer contracts would rest on the party seeking to rely on the clause. In business-to-business contracts, exclusion and limitation clauses, but not other terms, which are contained in written standard terms, would continue to be subject to fair and reasonableness test. This is similar to Section 3 of the Unfair Contract Terms Act 1977. The effect of Sections 2.1 and 2.2 of the Unfair Contract Terms Act would also be preserved. The burden of proof would again rest on the party seeking to rely on the clause. The requirement of reasonableness imposed on attempts to exclude liability for the statutory implied terms as to description, quality, and fitness for purpose in relation to business contracts would no longer apply. If such exclusions are contained in written standard terms, however, they would continue to be caught by the replacement of Section 3 of the Unfair Contract Terms Act. A new category of contract, small business contracts, would be created. This would involve a business contractor that has 9 or fewer employees. In small business contracts with a value of less than £500,000, any terms other than, for example, core terms that have been put forward as part of the other party's written standard terms would be subject to the test of fairness and reasonableness. The burden of proof, however, would here rest on the party challenging the term. There were, of course, other, more detailed provisions in the Law Commission's proposals, but the above points highlight the main changes which in 2005 the Law Commission proposed from the existing position. If enacted, these proposals would also have had the effect of leading to greater clarity. In particular, it would have been helpful for there to be one piece of legislation dealing with this area rather than two. In 2006, the government indicated that, subject to a regulatory impact assessment, the Law Commission's recommendations. However, steps were not taken to implement the Law Commission's full proposals, and this was initially to some extent attributable to the negotiations surrounding an EU draft Consumer Rights Directive, which at one stage included detailed provisions on unfair terms. However, in 2012, the Department for Business Innovation and Skills requested the Law Commission, particularly in light of the case of the Office of Fair Trading versus multinationals in 2009, to update, in relation to consumer contracts, their 2005 report. In July 2012, the Law Commission published an issued paper, and in March 2013 published their advice to the Department for Business Innovation and Skills. In June 2013, the government published a draft Consumer Rights Bill, Part 2 of which dealt with unfair terms. On the 23rd of January 2014, a Consumer Rights Bill was introduced. The two headline revisions to existing legislation introduced into the bill were as follows. One involved consumer remedies for faulty goods, and the other unfair terms in consumer contracts. Consumer remedies for faulty goods. UK consumers have a legal right to reject faulty goods. This means a right to a refund within a reasonable time. By contrast, under the European Consumer Sales Directive, consumers' first recourse is to repair or replacement. In the bill, it was recommended that the right to reject should be retained in the UK as a short-term remedy of the first instance. It was recommended that in normal circumstances, a consumer should have 30 days to return faulty goods and receive a refund, with limited flexibility for special circumstances such as perishable goods or goods with both parties know they will not be used for some time. Unfair terms in consumer contracts. Price comparison websites put increasing pressure on traders to offer low while making profits from other charges. Since 1994, under an EU directive, the courts had the power to assess fairness of terms in consumer contracts but may not look at the amount of the price. In 2009, the issue of what constitutes the price came to the fore in litigation. This is the Office of Fair Trading versus multinationals case mentioned earlier. The case involved bank charges for unauthorized overdrafts. The Court of Appeal thought that the bank charges could be assessed for fairness, while the Supreme Court thought that they could not. In the bill, it was recommended that the courts should not interfere with prices which are transparent and prominent, but where charges are tucked into small print, the courts should have the power to assess them for fairness. These recommendations are to be found in Part 2 of the Consumer Rights Bill 2014. We now move on to consider the provisions of the new Act. The Consumer Rights Act in October 2015. Its aim is to consolidate and clarify consumer rights. It does not affect business-to-business contracts, for which the provisions of the Sale of Goods Act 1979, Supply of Goods and Services Act 1982, and the Unfair Contract Terms Act 1977 remain in force. However, where the contract is made between a business or trader and a consumer, the law in relation to implied terms and exclusion clauses will undergo fundamental changes to the existing legislation. This includes the Unfair Terms in Consumer Contracts Regulations of 1999 and the Consumer Protection Distance Selling Regulation. In Part 1, the Act covers goods, in Chapter 2, digital goods, in Chapter 3, and the supply of services, in Chapter 4. For each, it sets out a blacklist of implied terms and the relevant rules on mandated remedies. Also, there is information on how attempts to exempt and limit liability will be assessed. The provisions of the Act will be familiar to those who have studied contract law and the incorporation of implied terms into contracts. There are no radical departures from prior legislation, and it is better to think of the Act as a consolidating statute, clarifying and augmenting existing protections for consumers, rather than building a brand new regime. For contracts to which the Act applies, implied terms derived from earlier legislation will cease to apply to consumer sales. These are sales where the buyer is an individual, not buying in the course of business, and the seller is a trader, meaning a person acting for purposes relating to their trade or profession. For example, Sections 9, 10, and 11 require goods to be of satisfactory quality to be fit for their particular purpose and to match their description, reflecting provisions in the Sale of Goods Act. Sections 13 and 14 cover the sale of goods by samples or models seen before purchase. This, for example, covers the situation where a consumer sees a product on display and then purchases a boxed item without further inspection. More specifically, the sections of the Consumer Rights Act generally repeat the wording of the equivalent Sale of Goods Act section, so that the substantive protection given to buyers in consumer contracts is essentially the same as that under the Sale of Goods Act. The Consumer Rights Act does not refer to implied terms, but states that the contract is to be treated as including the relevant term, which in effect amounts to the same thing. There are, however, two additional sections under the Sale of Goods Act provisions. First, under Section 15 of the Consumer Rights Act, if installation of goods by or on behalf of the trader forms part of the contract for their supply, an incorrect installation will mean that the goods will be treated as not conforming to the contract. Second, under Section 16 of the Act, if the contract for the supply of goods includes digital content, then if the digital content does not conform to the contract, the goods will be treated as not conforming to the contract. Finally, it should be noted that the Consumer Rights Act refers throughout to the supply of goods. This means that it's not only sale, but all other contracts under which goods are supplied, such as hire purchase, hire, or work and materials. For example, in a contract to build a garage, the bricks and other materials will be supplied for the purposes of the Consumer Rights Act. The Sale of Goods Act deals only with sale, and other contracts under which goods are supplied are dealt with by similar implied terms set out in the Supply of Goods and Services Act of 1982. Subsequent sections set out rights to possession and ownership and the remedies available to consumers. Especially important are the rights set out in Section 20. In Section 31, there are terms which cannot be excluded or restricted. This is known as the blacklist. The language is updated somewhat with the old Sale of Goods Act references to condition and warranty gone, but the short-term right to reject remains. However, after 30 days, replacing the more flexible concept of acceptance under the Sale of Goods Act, this is replaced by a right to repair and replacement as the primary remedy. Only if there are no adequate arrangements for repair and on replacement will the right to reject remain. Perhaps the greatest innovation can be found in Chapter 3, which covers digital goods which are now given equal to physical goods. This chapter follows similar issues as in Chapter 2. Remedies here include consequential damage, for instance to software and hardware, although one needs to keep in mind evidential problems in proving such losses. Chapter 4 relates to the supply of services and reflects the provisions of the Supply of Goods and Services Act. An important section will be Section 49, covering the requirements to act with reasonable care and skill, reinforcing the ability to hold service providers to account for negligent liability under the contract. This is linked to Section 57 and the limits to exclude liability there. Contracts for services, important pre-contractual statements are now implied into the contract in Section 50. In Part 2, the Act provides a general safety net to prevent unfair terms, reflecting unfair terms in consumer contracts regulations provisions and contained in Schedule 2, which are outside the blacklist in Part 1. Section 63 of Part 2 has a list of terms which may or must be regarded as unfair. This will need to be read in conjunction with Section 64, which has a list of terms which cannot be assessed for fairness. In its treatment of what we call unfair terms, the Act moves closer to the European standards of fairness as opposed to using the Unfair Contract Terms Act language of reasonableness. For example, the reasonableness test from the Unfair Contract Terms Act is replaced by fairness, including for negligence, which makes it much more in line with the regulations. Certain key prohibitions, like the Unfair Contract Terms Act ban on attempts to exclude liability for death or personal injury, remain. General definitions are set out in Section 2 of Part 1. A trader, as we saw earlier, is a person acting for purposes relating to the person's trade, business, craft. A consumer is an individual acting for purposes wholly or mainly outside the individual's trade, business, craft, or profession. A person is not necessarily a consumer. All this means that the business is defined much more in line with the principles of the Unfair Terms and Consumer Contracts regulations. So a business acting outside its normal course of business cannot fall within this, but would need to rely on the existing legislation under the Unfair Contract Terms Act. This is important because it means that corporate entities cannot be regarded as consumers. This was a much criticized aspect of the regulations, which remains largely unchanged. The definition of goods leads to some important distinctions in the law of consumer protection. Goods under the Act are any tangible movable items, which includes utilities if and only if they are in a limited volume or set quantity. This will make important changes to the protection of consumer rights. It will mean that there are two schemes operating now to different types of contracts. There is a vast amount of law in relation to consumer law, and we see an increasing distinction between commercial contracts and consumer contracts. This reflects an increasingly paternalistic approach to vulnerable contracts, with the contract remaining for commercial contracts. This is a long-term trend in European law which has hugely influenced the Consumer Rights Act. It remains to be seen whether it will be reversed, arguably to the detriment of consumers, in the post-Brexit revamp of English law. So far, we have presented some background to the process of law reform that led to the creation of the Consumer Rights Act 2015. We also saw a brief breakdown of the sections of the Act and presented its main aspects. The following section of the lecture offers a practical view of what the new Consumer Rights. This part of the lecture summarizes the information provided earlier, focusing on clarifying what the Act means practically for consumers currently going about their daily activities. The emphasis is on the experience of the customer when dealing with faulty goods or inadequate services. As we saw above, as was the case with the Sale of Goods Act, under the Consumer Rights Act, all products must be of satisfactory quality, fit for purpose, and as described. The rules also include digital content in this definition. So all products, physical or digital, must meet the standards as explained in the discussion that follows. We will now discuss what is the meaning of the various quality criteria. Satisfactory quality means that goods should not be faulty or damaged when received. The consumer should consider whether a reasonable person would consider the goods in question of satisfactory quality. For example, bargain products won't be held to as high standards as luxury goods. Fit for purpose, on the other hand, means that the goods should be fit for the purpose they are supplied for, as well as any specific purpose made known to the retailer before he was agreed to buy the goods. As described means that the goods supplied must match any description given or any models or samples shown at the time of purchase. For example, if you buy a new printer, there is an expectation that it will work for longer than a few months without needing repair. If you buy a professional printer, the expectation might be that it would work for a few years. If you want your printer to handle large volumes of paper and to do double-sided printing, and this was part of the description of the product, then it is a requirement that it does that. This means that if you specifically asked for large volumes of paper, a printer that can handle everyday use of a few pages but not more will not conform to your agreement. Also, the printer needs to do everything the sample in the shop was shown to do, even if a function is considered relatively minor. If the item you bought does not conform to the contract, who should a claim be made against? If a purchase doesn't satisfy any one of the criteria outlined above, the customer will have a claim under the Act. When making a claim under the Act, there are several possible ways of resolving the issue depending on the circumstances and on what the consumer wants to have done to remedy the situation. It is important to remember that rights under the Act are against the retailer, the company that sold you the product, with which the computer has a direct contractual relationship, not the manufacturer. There may be additional rights arising out of warranties offered by the manufacturer or in tort law which are not covered by this legislation. The warranty notice from the manufacturer of your printer, to use the earlier example, will give you therefore additional rights, including perhaps service abroad, but this does not take away your rights under the Act to approach the shop you brought. What one can claim depends on how much time has passed since you made the purchase. Under the Act, the consumer has a legal right to reject the goods that are of unsatisfactory quality, unfit for purpose, or not as described and get a full refund as long as you do this within 30 days from the date of purchase. After 30 days, the legal requirement to a full refund if the item develops a fault is lost, although some sellers may offer an extended refund period. This will be an express term, not implied by the Act, of the contract of sale in that instance. Express terms are found in the terms and conditions of sale of every specific retailer. Incorporation of express terms is covered in the syllabus of your contract law module. Also remember that no fault returns, if for instance you change your mind about the product, are express terms including in some, but not all, contracts of sale. You may be disappointed therefore if you change your mind about your printer and wanted a different one and the shop refuses a discretionary refund or change, but this will not be a violation of your statutory rights. A right to a refund doesn't apply to purely digital products, however, music, games, or applications bought as downloads. A digital product can, however, be repaired or replaced if it develops a fault. If this isn't possible or is unsuccessful, the consumer will have the right to receive a price reduction. The 30-day time limit is shorter for perishable goods, where the period will be determined by how long it is reasonable to have expected the goods to last. For example, yogurt would be expected to last until its use-by date as long as it's stored correctly. If a claim is brought outside the 30-day right to reject, the consumer has to give the retailer one opportunity to repair or replace the goods or digital content which are of unsatisfactory quality, unfit for purpose, or not as described. One can ask the retailer to repair or replace faulty goods, but they can normally choose whichever would be cheapest or easier for them to do. If the attempt at a repair or replacement is unsuccessful, the consumer can then claim a refund or a price reduction if they wish to keep the product. An entitlement to a full or partial refund instead of a repair or replacement arises in the following circumstance. Or replacement is disproportionate to the value of the goods or digital content. A repair or replacement is impossible. A repair or replacement would cause the consumer significant inconvenience. The repair would take an unreasonably long amount of time. If a repair or replacement is not possible, or the attempt at repair fails, or the first replacement also turns out to be defective, the consumer in those cases has a further right to receive a refund up to 100% of the price they paid, or to reject the goods for a full refund. If the consumer doesn't want a refund and still wants to keep the product or have it repaired or replaced, they have the right to request the retailer to make further attempts at repair or replacement. Why would one prefer a partial refund to a return or replacement? If, for example, you bought a new study desk which arrives flat packed, you would probably spend a lot of time assembling it and you would need it done in order to use it. If you discover that one of the drawers of the desk is misaligned and cannot be assembled properly, you may not feel like disassembling the whole desk in order to send it back. In these circumstances, you would prefer a replacement of the drawer, or perhaps to keep the drawer, if you manage to repair it yourself, and request a partial refund for your trouble. If fault is discovered within the first 6 months from purchase, it is presumed to have been there since the time of purchase, unless the retailer can prove otherwise. During this time, it's up to the retailer to prove that the fault wasn't there at the point of purchase. If an attempt at repair or replacement has failed, the consumer has the right to reject the goods for a full refund or price reduction. If they wish to keep the product, no deductions can be made from a refund in the first 6 months following an unsuccessful attempt or at repair or replacement. The only exception to this rule is motor vehicles, where reasonable reduction may be made for the use of the vehicle after the first 30 days in question. They can request inappropriate price reduction. After the first 6 months, the burden shifts to the consumer to prove that the product was faulty at the time of delivery. In practice, this may require some form of expert report, opinion, or evidence of similar problems across the product range. The statute of limitations on civil claims is 6 years to take a claim to the small claims court for faulty goods in England, Wales, and Northern Ireland, and 5 years in Scotland. For goods that have a digital element, such as a smart TV or digital content supplied in a physical form, there is a 30-day right to return and get a refund. This right applies if any of the product, including the digital content, for example the software on a smart home appliance, doesn't work properly or develops a fault. The Act defines digital content as data which are produced and supplied in digital form. Just like goods, digital content must be of satisfactory quality, fit for a particular purpose, as described by the seller. If the digital content does not conform to these criteria, there is a right to a repair or replacement of the digital content purchased. If a repair or replacement isn't possible or doesn't fix the problem, the consumer is entitled to ask for a price reduction, which can be up to 100% of the cost of the digital content. The retailer will have to offer compensation if any device or other digital content the consumer owns is damaged as a result of digital content downloaded. This applies where the damage would not have occurred had reasonable care and skill been exercised in the provision of the digital content, even if that content was provided free of charge. This covers any digital content paid for, whether that's with money, a gift card, or credits, and free digital content supplied with goods for which a price was paid. For example, this could be a digital program one needs to download in order to watch a paid-for online streaming service. Also included is free digital content not usually available for free unless the goods, services, or digital content it's supplied with are purchased. For instance, this could be a smart TV, or any other product with digital content pre-installed, paid. The above provisions could cover the situation where your device is damaged by a faulty upgrade, which is automatically downloaded and installed. Watch out, however, for disclaimers and limitation clauses during the download or installation process that may attempt to limit liability for any resulting faults. The retailer is responsible for goods until they are in the customer's physical possession or in the possession of someone appointed by the consumer to accept them. This means that retailers are liable for the service provided by the couriers they employ, while the delivery firm is not liable itself. The retailer is responsible therefore for the goods until they are delivered and in the possession of the customer. This means that there is no need to purchase additional delivery insurance where that is on offer if the seller is shipping from within the UK. There is a default delivery period of 30 days during which the retailer needs to deliver unless a longer period has been agreed. If the retailer fails to deliver within the 30 days or on the date that has been agreed, the consumer can select from the following. If the delivery is later than agreed and it was essential that it was delivered on time, then one has the right to terminate the purchase and get a full refund. If the delivery isn't time essential but another reasonable delivery time can be agreed, the consumer is also within their rights to cancel the order for a full refund. We now move on to consider services. For the supply of a service, the Act as we saw provides that the term service covers a wide variety of large and small-scale work carried out in the home or elsewhere. Services can be provided alone or they may be provided with goods, for example the fitting of a new boiler. Examples of services provided without goods include dry cleaning, entertainment, work done by professionals such as solicitors, estate agents and accountants, building work or home improvements. Examples of services provided with goods include repairs to goods where parts are replaced, such as car repairs, fitted kitchens or bathrooms, home improvements involving building and decorating work, and double glazing. In all the above examples, the service contract is governed by the Consumer Rights Act, which means that the consumer can use this as protection should anything go wrong. The rules mean that all contracts for services must ensure the following: the trader must perform the service with reasonable care and skill. Information which is oral or written is binding where the consumer relies on it. Where the price is not agreed beforehand, the service must be provided for a reasonable price. Unless a particular time scale for performing the service is set out or agreed, the service must be carried out in a reasonable time frame. If the service provided doesn't satisfy criteria, the customer will be entitled to the following remedies under the Act. The trader should either redo the element of the service which is inadequate or perform the whole service again at no extra cost, within a reasonable time and without causing significant inconvenience. Or, in circumstances where the repeat performance is impossible or can't be done within a reasonable time or without causing significant inconvenience, the consumer can claim a price reduction. Depending on how severe the failings are, this could be up to 100% of the cost, and the trader should offer a refund within 14 days of agreeing that the consumer is entitled to a refund. Finally, we turn to what the changes in the Consumer Rights Act mean practically for the treatment of unfair contract terms. Rights under the Consumer Rights Act make it easier to challenge hidden fees and charges. The key terms of a contract, including price, may be assessed for fairness unless they are both prominent and transparent. Terms which are not fair are not automatically binding on the consumer, but one may still rely on them if one chooses to do so. Some examples of terms that may be unfair under the Consumer Rights Act include fees and charges hidden in the small print, a term that tries to limit the consumer's legal rights, excessive early termination charges. A term is unfair if, contrary to the requirement of good faith, causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. The fairness test, therefore, includes the following main elements: significant imbalance to the detriment of the consumer and good faith. It must, however, be emphasized that the overall requirement is a unitary one. The question is whether a term is unfair. The elements of the test are recognized as being capable of overlapping with each other in their application to any particular set of relevant facts. A rigid approach to assessing fairness involving an artificial exercise broken into separate parts is not appropriate. Significant imbalance is concerned with the parties' rights and obligations under the contract. The requirement is met if a term is so weighted in favor of a business that it tilts the rights and obligations under the contract significantly in its favor, for instance by granting the trader undue discretion or imposing a disadvantageous burden on the consumer. Examples of the types of terms where an unfair imbalance is likely to arise include those that have the effect of restricting or excluding the customer's normal legal rights to seek damages where the trader is at fault, constraining the consumer from seeking the legal remedies to which their rights give rise, for instance, compelling the consumer to take a dispute to arbitration, and imposing on the consumer additional obligations or risks which are not envisaged by law or unreasonably go beyond anything needed to protect the legitimate interests of the trader, for instance, imposing excessive financial sanctions on the consumer for breaching the contract. It is important to remember that a term or notice that is unfair is not legally binding on consumers. This does not prevent consumers from relying on them if they wish. The Act enables consumers to challenge wording if they consider it unfair and do not wish for it to be relied upon against them. If they make such a challenge and the trader refuses to accept that the wording is unfair, they may wish to consider whether they have a legal case for taking matters further with a view to seeking to resist an apparently unfair demand or to insist that the trader acts in a particular way. Before taking any steps that will or may involve resisting or taking legal proceedings, consumers should always seek legal advice. We have seen some background to the creation of the Act, the details of the statutory provisions, and an explanation on practical consequences for consumers. We will now apply this knowledge to a scenario that involves a common real-life situation and consider how it could be resolved under the new legislation. We will consider the situation of John. John has just bought a new laptop from electrical retailer Frictions. The laptop comes with a Doors operating system pre-installed and was sold with a notice that said "Free upgrade to Doors 10 available." John turned on the new laptop as he returned home and went through the setup process. All was well, and John proceeded to upload his holiday pics from his camera to the laptop, deleting them from the camera's memory in the process. Within the first hour of operation, the laptop displayed a message saying, "Do you wish to upgrade to Doors 10 for free?" John agreed and watched while the laptop downloaded and installed the new version of the operating system. After the installation was complete, the laptop malfunctioned and all personal data stored on the disk was lost, including John's pictures. John took the laptop back to Frictions, but they refused to help as the problem was caused, they said, by software installation from a third party. John contacted FrustraSoft, which makes the Doors operating system, to no avail. John has come to you for advice. The purchase of the laptop comes under the Act, as under Section 5 this was a sales contract between a trader and a consumer. There is no debate here that Frictions is a trader and John is a consumer under Section 2. The problem is not with the hardware aspects of the product, but with digital content, which is covered by Chapter 3 of the Act. The issue here, digital content, the updates to the operating system, give rights to John against the retailer Frictions and additionally, or perhaps instead, to the maker of the software, namely FrustraSoft. One could argue that under Section 33, the operating system, including the upgrade mentioned specifically by the retailer, is for digital content to the consumer, first, supplied free with goods or services or other digital content for which the consumer pays a price, and second, not generally available to consumers unless they have paid a price for it or for goods or services or other digital content. Clearly, Frictions, together with FrustraSoft, wishes customers to select products carrying its operating system, hence the offer of the free upgrade to the latest version. In order to bring a claim against Frictions, John would need to show that the digital content was not of satisfactory quality, Section 34, which would not be very difficult to substantiate in the circumstances. On the basis of the above, note that pre-contractual statements become part of a contract with a consumer by analogy with Section 50. John would have a claim against the retailer for the consequences of the malfunctioning software subsequent to the upgrade under Sections 19 to 22 and any loss suffered, satisfying normal contract law rules on damages claims. Under Section 44, John could claim for damage done to his device and to other digital content. However, it is difficult to quantify loss for the erased pictures. Shaky legal footing were they to dismiss John, saying that they were only responsible for hardware defects with a laptop. The question then becomes, would John have an independent right against FrustraSoft? Were we to see the download of the upgrade independently of the purchase of the laptop, John could rely on Section 49 for liability and negligence for the provision of digital content that causes a defect. This is the old care and skill requirement that was found in the Supply of Goods and Services Act of 1982. One could argue that the provisions of the Consumer Rights Act, Sections 48 and 49, allow this standard to operate independently of a contract, for example as in a tort action, but John could argue for the existence of a contract with FrustraSoft directly too. Consideration in this case would rest in the selection of this particular product, carrying the possibility of the upgrade, as opposed to another one. See, for instance, the case of Shanklin Peer versus Dettel products from 1951. In conclusion, John will have a good chance of obtaining a refund or repair or replacement of his laptop and can attempt to claim additional compensation for the loss of his pictures from Frictions, primarily, and potentially FrustraSoft. The introduction of the Consumer Rights Act 2015 highlights John's rights, even though in fact it does not present a radical departure from what his position would have been under prior legislation.
After we've gone through a series of lectures discussing how things come into being and how companies are created and how they attained their separate and independent existence. And now we've gotten to the point of discussing how do these things actually die. Yeah. And I like the zombie analogy because the companies are a little bit like the undead. Right? They could theoretically live forever in a horrible decomposing state, but their horrible existence can also come to an end at some point. So what we're doing today is we're talking about the topic of corporate collapse. We see how the company finishes at most of the, not necessarily, but most of the time financially failed. And then we think about corporate collapse, perhaps in a little bit in a broader way. So we're going to understand what it means, winding up and insolvency and all these various terms that you're going to come across in your books. Now, one of the things that are different between what you do here and what you see in the movies is that the word bankruptcy that is used in American English for failure, both corporate and personal, is not used in English law. So you should not be using the term bankruptcy in English law unless you're referring to personal bankruptcy, because there's now provision for you to be declared bankrupt as a person. It means that you can no longer service your debts or whatever debts you may have. It could be kind of credit card debts or loans, or you cannot pay your rent, or you cannot do anything. So the idea of personal bankruptcy is that it puts, you kind of start at year zero in a way. It assumes that you've got nothing, all your existing debt is wiped out, and then you begin from scratch. But of course you begin from scratch with zero credit rating, meaning that nobody in their right minds would be willing to lend you any money again. So I'm guessing the only way to kind of come back after this is that you only spend the money that you earn, because you cannot get credit from anybody, or overdrafts or loans or credit cards. And once you've established yourself a little and built yourself up a bank account with some money, and then you can slowly begin to repairing your record. But it's quite significant, especially for you. You don't want to be in a situation that start your working lives with an impaired credit record, because that would be tricky getting approved for never mind mortgages, right, for the house, but for more mundane stuff, even getting checked for a rental agreement. So if you already have a few things that you do, it makes things. Of course, you count it by getting your parents to guarantee anything that you do on the assumption parents' credit record is stronger than you. Insolvency is the key term that we're going to have to deal with. So insolvency is called the procedure in which a company finishes its life in English law. Now, insolvency is part of a wider process called winding up. Winding up, if you want, is the headline route, and then insolvency is one of the outcomes. So when we're trying to close down a company, we call this winding up, and one of the avenues to have this closing is insolvency, but insolvency we're using in cases of financial failure. You could go through a process of winding up, which ends up with the company being dissolved when the company is solvent, and for different reasons. When, for instance, the members of the company decided they don't want to have it anymore and they petitioned the court to shut it down, or winding up could be offered as a solution in cases of minority shareholders, right? And we've seen this when we were talking about unfair prejudice. If one of the shareholders, especially in the kind of quasi-partnership company, are complaining that the rights have been abused somehow, one of the potential remedies that the court has available is to shut down the entire company. So if it has become so dysfunctional, then it's not continuing and it's being wound up. Winding up is the headline. Insolvency is one of the possible outcomes. Clearly, insolvency is what interests us in terms of kind of financial instability. So we're going to be talking more about that. The legal information is both in the Companies Act, but also in the Insolvency Act of 1986 and the associated insolvency. If you decided that you are shutting down a company, so you begin the process of winding up, and if the insolvency is the ultimate destination of this process of winding up for financial failure, then the way you get there is called liquidation. Liquidation is the process through which you dissolve the company, ending up in insolvency. Now, the terminology here is rather unhappy. You are probably going to find this difficult, but I think it's worth putting a bit of effort in naming things appropriately, because these terms manifest at different stages in the process. So even if you agree that the company has run out of money and is going to have to shut down, calling the thing the appropriate thing at the appropriate point will lead you to the correct provisions in your statutory material. So then when you're providing legal authority for the points that you're making, you will have the correct one. If you get these very confused, then you might end up talking about the wrong thing at the wrong time, which is going to lose you marks if you find this in an exam question. The process of dissolution of a company via insolvency is called liquidation. And we already said that we're going to try and remember not to use the term bankruptcy, because bankruptcy is for personal, not for corporate defaults. You will also come across the term administration. Administration is when you're trying to decide which bits of the business might be able to survive and which. And this is my favorite slide, because I could be adding stuff here every day, right? So there used to be an electrical retailer called Comet around the high street. You don't have this anymore. You used to have Carrie's and PC World, right? Now they're together. You used to have Dixon's, which doesn't exist anymore, only at the airport, and it is part of Carrie's PC World. But there was a time that if you went on the high street and you were looking for a new computer or a new TV, you had the option of going to Comet. You had PC World that was a little fancy, Dixon's that was not fancy but expensive, and Carrie's that was kind of somewhere in the middle. So all of these things have failed over the years, so that's gone. You remember Toys R Us, when you used to buy your toys when you were young, like last year? Toys R Us is gone. Phones for You was a mobile phone retailer like the Carphone Warehouse, plus the Carphone Warehouse is getting there in a hurry, right? So I wouldn't order very expensive phones from these guys. You had, of course, Patisserie Valerie. That's one of the more recent victims, but the brand has remained on the high street in some way or another. You had Coffee Republic. That was a chain of coffee stores, Starbucks-like. That didn't make it. JJB Sports, one of these kind of really cheap. Borders was a bookshop, gone. Habitat was an independent furniture. That went dead a long time ago, but now you still, the brand survives in Europe. So you find some Habitat branded stuff within other stores. Sea France was one of the ferry companies that was going back and forth to France. That's dead, soon to be joined by all the other ferry companies. So all of them have gone the way of the dodo. What happened to the dodo? Yeah, they ate it to death. What happens if a company gets in trouble? There's a way in which you end up in trouble. You don't wake up one morning and realize that all your customers have disappeared. This happens gradually. You can usually see it happen, and you worry about it, but you're not exactly sure what to do about it, or the things that you chose to do to address it haven't actually worked. So there's a kind of sequence that leads to failure that has to do both with external factors and internal management difficulties, or kind of fights and disagreements within the company. It could be that there are problems at management level. It could be that people either have, they cannot agree with each other on what to do, or they cannot coordinate efficiently, or are generally not particularly good at what they do, because this happens, but that's human nature. Not everybody is always excellent, and not everybody is capable in all types of jobs. There are some people that can take over a shop and run it very effectively. There are some other people that they take over the same shop in the same circumstances and they make a mess of it. Yeah, and we've all seen it, kind of examples in family and friends and so on, how this happens. It could be that there are some problems with accounting. Some people are not that capable of their accounts. All the stuff that we did last week about your balance sheets and your statements, it's easy to lose track. It's easy to get confused. In the same way that you guys in your personal lives could lose track of your personal finances and find that one month you spent significantly more than what you were hoping for. It can happen on a business level quite easily as well. But the most usual way in which you end up in trouble if you're a company is that you cannot adapt to change. Is that something was working out when you started out, it was working efficiently and sufficiently for a significant point in time, and you got to a point that it doesn't work anymore. And the ability to adapt to that change and address it usually makes the key difference between whether you have a long-term viable project or not. And this is something that you see in all walks of life, not necessarily business in that way. The fact that you've identified that something's a problem and you should do something about it doesn't necessarily translate into change, because there are many things. You've paid so much for these buildings. You hired all these people to kind of stand up and yell at other people. The whole system is built that has tremendous costs if you try and change it. So even though you see something degrading and that's not gonna last, you're thinking, well, maybe it's not going well, but it's gonna me. And some of the problems with management are very much this. Depending on the involvement that people have in a business, if their time frames are short, they might recognize that something's not working out, but they think they can outlive the change, or they're gonna be out before the change hits and everybody's made redundant. You work in a store. That was my uncle, for instance, right? He was in a retail supermarket that was doing poorly, and he was doing worse every year. But he didn't do anything to change, because he thought, by the time the whole thing's completely gone and nobody walks in the door, I'll have retired. So what's the point in me now spending like a huge amount of money and taking a risk to turn the business into something else, or looking for another job altogether? Well, it'll probably have the trajectory to take me till the end, and then I stop because I'm retiring, the thing shuts down because it's got no customers anymore. So again, but these are choices that you can get wrong. And if the timing comes wrong, you end up in a situation. Because if the job degrades way faster than you're able to get out of it, then you're in trouble. These are kind of long-term or kind of background issues that have to do with corporate failure. More immediate stuff are mistakes. Like you make an error and it's costing you so much money, it's putting you out of business. You invest in something that's horrible. You have, an electrical store and you buy a huge number of desktop PCs that you want to sell to people because you think they're great and you got them at a great price. And you think that even though people are moving into laptops and tablets and mobile devices and so on, there's still like a kind of hardcore amount of people who would like to have a traditional desktop machine. And you got it wrong, right? And nobody wants to buy that stuff. So you've made like now a tremendous investment that is just going to bring you under, and there's nothing that can be done about it. Or it could be that you're selling a correct thing, but at the wrong volume or at the wrong time or at the wrong target audience. Or you undertake a big project that you're not capable of delivering. So you've got defects that are kind of long-term and background issues. You've got mistakes that can happen. And these manifest themselves in concrete trouble that needs addressing carefully. But people don't, right? So if you got issues with your balance sheet, if you got issues with your turnover, if there's external, it could be that you've done everything right, but there are external factors, right? Everybody panics about Brexit and people stop spending money. This has got it's not your fault, right? You're selling something that a year ago everybody was crazy to buy, and now people are buying it, not because they want a different product, it's because they all got spooked and everybody's buying toilet paper and cans of beans. That is gonna cause you trouble. This manifests itself in your accounts and your financial statements and so on. Then, once you get panicked, what do you do? Very often, it's unfortunate, what happens, people try to get out of it by borrowing more money. They're thinking that the problem is temporary. So if we kind of get through the next quarter, get through the next year, then things are going to stabilize and we're going to be fine. But they're not. In order to win more time, they borrow more heavily, then the cost of servicing those loans becomes more important, then makes their financial situation get even worse. And if you're borrowing from a position of stress, then they're going to ask for more in terms of interest rates, right? Or if you're borrowing in the markets are going to ask for more. If you're selling bonds to refinance yourself, you're probably going to have to offer much more attractive terms if the market's already a little bit worried about how your business is doing. Yeah. So either you borrow more and you create trouble, or it could be that you start kind of fiddling with the accounts and trying to present a more rosy situation than what is real, and then because you're worried you might get in trouble with your creditors or your shareholders, start cooking the numbers, and you get into so much more serious trouble. But all of this, you see, does not imply bad intent. This is not like a kind of patisserie Valerie situation where there was fraud at the beginning, somebody was kind of stealing the money and trying to cook the accounts not to show it, but the business was otherwise okay. This is kind of Jane's fault really, but it's various failures at different levels to address it properly. And sometimes something cannot be helped. It could be that something, because people don't do it anymore. A friend of mine is a designer for diesel engines. It's over. They told them that there's no more investment in diesel engines because of environmental reasons. Therefore, the company is shutting down that research department. Now, the guy has got no option. He needs to try and specialize in something else, because if he says, no, this is what I'm focused on doing, it doesn't exist anymore. In the same way that if you're a software engineer and you're working on certain types of software packages that are too old and nobody's using anymore, what's the point of insisting? It's over. If we're talking about winding up as a process, there's the compulsory version that comes out of the court, of you having run out of money, but there's also the voluntary one that the company members could choose themselves to go to the court and ask for the company to be shut down. So the bit that we're talking about is the insolvency for financial failure bit. So this is non-voluntary. This happens when a creditor goes to the court and says, you owe me money, these guys owe me money and they haven't paid me. So if you want to see where this is represented in the legislation, this is represented in the legislation in section 122 of the Insolvency Act onwards. So this contains the provisions for the winding up by the court, and this whole kicks off if the company is unable to pay its debts, or if the court is of the opinion that it is just and equitable that the company is wound up. Remember, we said that this can be as a minority shareholder a remedy. Yeah? If you want voluntary winding up, then you need a special resolution by the shareholders to ask the court to shut the place down. It doesn't happen very often. Now, Section 123 of the Insolvency Act gives creditors who are owed in excess of £750 the power to go to the court and request the appointment of a liquidator if the company is unable to pay its debts. So you see how simple this is? Somebody owes you a small amount of money. It's not even £1,000, right? And you ask to be paid. The debt has become due, and the company says, "I'm not going to pay you." They're not disputing your claim, but they acknowledge your claim, but they're just saying we don't have enough money to pay you. Of course, if they're disputing your claim, that's something else. You couldn't argue that, the fridge broke, so your landlord owes you £750, and if he says no, then you go and try to put his accommodation, right? So you need to have a debt that is due. So that could be a debt that is not contested. It could be debts to the state. It could be monetary debts to banks and stuff like that. You owe your taxes or court orders that are not being paid, that kind of stuff. Yeah. So the first step in the process is the appointment of a liquidator. The liquidator takes the administration of the company's affairs and takes care of all the. What this means in terms of company law management is that the board of directors is out. Yeah. So once a company enters into this situation, the board of directors no longer exists. The management of the company passes to the administrator / liquidator, and the duty of the board when this is being set up is no longer to the shareholders, but the duty is to the creditors. And this is a duty, as we've seen when we talked earlier about section 214, the time span of this actually goes before the actual beginning of the process. So if I'm aware that the company is in trouble and is not going to survive, then their allegiance flips from the company to the creditors. So if the company is nearing failure, then there's a positive duty on the directors not to make things worse, right? But this is a situation where the directors know, because they're aware of the accounts and stuff, they know that the company is not going to survive, it's not going to be able to pay everybody. Therefore, at that point, they don't have to make a selection who they pay. But at that point, they're thinking, right, we should not do anything that makes. So if they know that the company is more likely not gonna make it, then kind of gambling on stupid stuff, or trying to find the one great product that's gonna save them, or getting a very expensive loan, or making a very expensive acquisition, this is the wrong thing to do. because what this does is that it inflates then the liabilities that the company is going to have to address, which it won't be able to if it's going to go back. So what you've got from section 214 is that then it creates a personal duty on the directors to contribute to company resources to pay off the creditors. So this we're talking about kind of exemptions from limited liability. This is not lifting the veil to go after the money of the shareholders, but it's a kind of parallel way that you can get other company insiders to contribute. So in this case, it's not the shareholders, but it's the directors, because they've done something wrong in not thinking about the interests of creditors at that point in time. It's to contribute out of their own resources the money of the company. There is that if somebody has debts that are acknowledged but not paid, then they can go to the court and ask for the appointment of the liquidator. The assets still belong to the company at that point, but it's the liquidator that controls the management. So therefore, all decisions are taken by the liquidator, and the interests they're trying to address are the interests of creditors, not the interests of shareholders. Now, for compulsory liquidations in England, you've got the official receivers, which is part of a government department that's what they do for a living. So they will be initially appointed to take over the company, and then they usually hire a professional firm to do it. So they usually hire one of the accounting firms to handle the. Now, their job of whoever is appointed liquidator, either at the initial stage with the official receiver or when an accounting firm takes over, is to secure the assets of the company and have them realized, like sold off, so they're distributed to the company's creditors. If there's anything left at the end of this process, it can go back to the shareholders, but most isn't. If we're talking about liquidation, compulsory liquidation for financial failure, what are the chances that you're going to discover like a pot of gold under the... If there was any value there, people would have known it, so they wouldn't have gotten into this trouble. How are you going to make the decisions as to whom to pay? Now, these decisions are not made unilaterally by the liquidators. They don't have the freedom to actually decide who gets the money. These are done in this order, and this order is specified in the insolvency rules. So who gets what is not a matter of choice, it's a matter of what the rules have demanded. The insolvency rules, as I said, is what goes with the Insolvency Act to give operational guidelines to the people who are carrying out these processes. Who gets paid first? The people who get paid first are the people who are considered secure creditors. Now, the expenses of the liquidators, first of all, because these guys are not working for free. So if you hire PricewaterhouseCoopers to run the liquidation, then they would expect to be paid first, not to be at the bottom after they paid off everybody else. So the expenses of the liquidation come first. And then you've got anybody who holds a fixed charge. Now, we've got a specific class further down the line here talking about security and security interests in relation to company law. So we're going to talk about this at length, but very briefly, there is a mechanism in the Companies Act that you go and you lay claim over specific assets. So you're going to, like Solomon did with when he gave the money to the company, right? So the company took a loan from Solomon in order to buy his business, and Solomon secured that loan with a charge. So a fixed charge is something that is written in the company books, so it is obvious to everybody there, it's in a public document that says, if this company goes bust, I can come in here and I can pick up the specific item, right? So then you're called a fixed charge holder because you have a charge fixed on a particular asset of the company. This is usually some sort of physical aspect, but it could also cover money liabilities and stuff like that. If it's separate bank accounts or investment products, it could cover those. After that, you've got the people who are considered preferential creditors, meaning who are those? Are the wages that you have to pay your employees and their pension fund obligations and all of that stuff. But you see, these are not at the top, right? But the people who went through the trouble because putting a fixed charge over company assets is a bureaucratic and expensive process. So the people who go through that trouble, they get rewarded by being first on the top of the list. Yeah. Then you've got all this. So you will have run out of money here on number one. So very often, companies that fail, the employees don't get paid, and very crucially, the pension funds don't get paid. That's why when a big company fails that was having its own dedicated pension fund, because they usually leave the pension fund in deficit, the pension fund fails immediately after. So not only you've lost your job, but you lost your pension entitlement as well. And what happens then is that the pension fund goes to something called the protection fund, which is a government run backup fund to try and assist all the pension funds that have failed. The problem is you're never going to get what you thought you were going to get. So you've been paying your entire life pension contributions, and because your pension fund failed, then the government's going to try and secure something for you through that protective measure, but it's never going to be as good as you thought you were going to have. But don't worry about the bosses, because the bosses are always in separate pension funds, capitalized, and they're perfectly healthy. After you paid your secure creditors, after you paid your preferential creditors, then you get the people who hold floating charges. Floating charges are they're a similar process of registering a claim on the company's books at the registry, right? But this time you don't have a claim over a specific named asset, you have a claim over a type of asset. So you're saying, if the university fails, I'm going to come in here and pick up audiovisual equipment to the value of £10,000. But you haven't spent that one in this room and that one in that room. It's just any audiovisual I can find. Because it's not, the obligation on the company to maintain that resource is less than you would have on a fixed charge. So yeah, you can have these things, but it's not as powerful, and because it's not as powerful, it ranks lower. So you could have given some people, some of the banks, for instance, fixed charges of the big stuff, and then you could have given some of your traders and your suppliers floating charges over some other stuff that are you can rip off and try and sell. Yeah? So usually a fixed charge is going to be over the building, but the floating charge is going to be over movable equipment that's within the building. But these rank low. What happens after that? You've got all your unsecured creditors. Who are the unsecured creditors? This is anybody to whom you owe money. And there isn't anything particular about these people apart from the fact that they're owed money by the company. These could be clients that have paid and have not received the goods yet. Or they're clients who bought gift vouchers. Or they're anybody who supplied things to the business and they haven't been paid. So if you were, a good example is Phones for You, right? The phone company. We had students in here at the time that they had contracts with these guys. So if you walked in there and they did a contract with, say, Vodafone, and they said, you signed today, come on Monday, you'll pick up your new phone. And you get there on Monday and they've shut because they've gone bankrupt. The Vodafone would honor the contract and they would send you the phone. So you got away with it. Yeah? But if you had gone to buy the handset, because they also sold handsets free or pay as you go sets where the box is there. If you had ordered like a nice new iPhone and you paid the deposit and you arrived on Monday, the place was shut. You were an unsecured creditor, right? So you're waiting in line along with everybody else. And the silly thing is, it could be that on the desk, there's the box with your name on it. But because it's still in the shop, it's their property, it's not yours. So even though it's identifiable and it's got your name on it, it's not yours and you couldn't have it. So anybody who's in that, so also the people who brought them the printers, or brought them the printing paper, or brought them the toilet paper, or brought them that they were getting paid at the end of the month, all these people were unsecured creditors. Because imagine the long list of people and obligations you've got higher up. By the time you get to the unsecured level, mostly you're not getting anything. That's why we tell you guys, try and get some type of insurance through us. So if you're ordering online, this mostly happens if you're ordering online and you're kind of worried whether it's going to come or not, but the principles are the same. Actually, you get more protection if you're online, but even in a shop, right? You're organizing a party for a friend of yours. This is the easy thing, it happens, yeah? You're booking a party, thing, it happens, yeah? you're booking a party for a friend of yours, and you go to the pub and you say you're gonna pay. They have like a standard fee. They're gonna charge you £400, and then in addition, everything that people drink on the day, if it goes above that amount, that's the kind of deal they normally do. And they want half of that money up front. So you pay a £200 deposit. You turn up on the day of the party, there's shut because they've gone bankrupt in the meantime. You're an unsecured creditor. So what could you do externally to protect yourself? If you had paid with a credit card, because of the provisions for credit, for the provision of credit, the Consumer Credit Act, the bank is co-responsible for delivering the service or the product as the supplier. So if the supplier has gone bye-bye, or you never got the product, then the bank will compensate you. If you paid with a credit card. If you paid with your debit card, that's why if you have a credit card, if you don't have one, get one. If you have one, every time you're spending anything in excess of £100, use the credit card. So then if something goes wrong, you go back to the bank. If you were ordering online and you paid with PayPal, PayPal is offering the same protection. Right? As a service, it's part of the service that they provide. Yeah? So then you would be compensated from PayPal. Otherwise, if you paid cash, if you paid check, or if you paid with a debit card, your bank voluntarily agrees to help you, you got no legal entitlement. So if you're an unsecured creditor, forget it, yeah? So if you're an unsecured creditor, forget it, yeah? How you can elevate yourself in that chain so you get paid by the company if it's got any money. Now, if you got any type of external insurance, that's great. But in any case, insurance is a secondary obligation. First, you need to sort it out with your provider. If you call your bank and you tell them you've got a problem with the transaction, they're going to tell you, talk to the shop what's going on. If the shop's unresponsive or they refuse to address it, then we'll raise a case with them and chase it up ourselves. But it's your obligation to chase after the shop first. So the insurance is a secondary obligation. This is a primary obligation. After the unsecured are paid, if there's anything left, then you pay any interest on that. And if after that something remains, for some unbelievable reason the company has gone bust, but suddenly somebody puts in a fantastic offer because they want to buy the retail network, because they want to use the shops and the equipment and so on, it turns out that there's enough money generated there. There's no company alive, but enough money has been generated and everybody's been paid off. Any excess is distributed back to the shareholders according to the proportion of shares that they had. But otherwise, the shareholders are dead. And this is the whole point. This links up with all the stuff that we did about limited liability. What's the benefit of limited liability? Unlimited participation on the upside, but limited loss. What's your limited loss? What you stand to lose is the amount of money you paid to purchase the shares. So if the company goes bust, shares are gone, but nobody's going to come after you to pay any additional money. What you have in situations where the company is in distress and is going through that process, but it can survive as a viable business in some reduced form, but there isn't enough money to pay everybody, what they do is that they do a debt to equity swap. So you take all the banks that have given the loans and they say, we're not going to repay the loans, but we're gonna restructure the company into a new form and we're going to use shares in the new business. So the bank no longer gets its loan money back, but is acquiring shares in the new business. So if the business then prospers, the bank has an opportunity to recoup money by selling those shares. But it's better than an outright, if the new entity fails, then you're again a shareholder, you get nothing. But that's the risk assessment that you need to make at the time if a debt to equity swap is proposed. And this has got wider connotations because now they passed legislation to prevent bailouts. Like when the banks failed in 2008, here the state them out. But then everybody realized that this isn't a great idea. So what they do now, instead of bailing them out, structured process that sucks in the people who have made loans. So normal people, like normal savers and kind of people who have got current accounts and stuff, are protected up till a certain amount. Anybody above that is considered an investor and they lose all their loans and they get instead all the loans. but they're getting shares in the new entity. And this is kind of step one. So this is called the bail-in. So instead of trying to save the business by paying off all its debts, we just cancel all its debts and suck in all the creditors, and we make them shareholders. If after that point it's still failing and it needs government assistance, then the government assistance can come in. Now, why would the government need to help them? Not always, but it could be that it's something so big that it would create such widespread trouble. So if somebody like NatWest and so on, or HSBC went under and suddenly half the people didn't have ATMs to get money from, that would be trouble, okay? So sometimes the government still needs to step in. But the way they change the process now is, so we're going to talk about the various types of dispute resolution that are available to business, and we're going to try and position the main thing that you guys are talking about, which is litigation, against other things that are available. So after this, you will hopefully have some appreciation of what we're trying, how parties in a business or commercial context can try and resolve arguments that they've got with each other in a nice, cost-effective way without actually ending up in the courts and having to hire lawyers and all the rest of it. Now, this is probably sounding a little bit weird to the majority of you, because first-year students, especially, are assaulted with all this information about courts and litigation and all of these processes. And because you hear so much of it, you get the impression, or you might be left with the impression, that the only way that you can deal with a problem is by getting legal advice and then going to a court to resolve the issue with the other party if the other party does not accept your point of view. You saw everything through case law and through this process of people having an argument and resolving it through the courts. The reality of business life, though, is nothing at all like this. The one thing that people are trying to avoid, they try to avoid going to court as much as possible. And in fact, the funny thing is that if you do end up in court, the actual process of the court looks nothing like you think it's going to look like. You think that court cases are about barristers sitting there reciting ancient cases. It's not like that at all. It looks like that to you because all the cases that you come across are Court of Appeal or Supreme Court cases, because you're trying to learn what the law is. When you're in an actual courtroom, they already know what the law is. So they're not arguing about the law, they're arguing about the facts. So everything in a court, in a normal court where a case is getting dealt with, is about establishing the facts. So nobody, this was a shock to me when I was a student and I went to sit in a few courtrooms, nobody said anything about the law. Like, everybody just assumed that everybody else knows what they're talking about, and the whole discussion was who said what to whom and who did what and in what sequence happened and all of that stuff. It was really strange to me. And it also might tell you whether this is the sort of career that you want to pursue. It could be that you see people in a courtroom representing clients and you find it very exciting. Or it could be that you realize it's got nothing to do with the stuff that you saw on TV, therefore this is probably not something that you're that attracted to. But the one important thing that we've got, though, is a really intense desire to stay as far away from the courts as humanly possible. And the reason for this is the cost. Going to a court and going through a litigation process is evidence of failure. Something has gone wrong. When you were doing contracts, you saw all these things that one party alleges that the other one has breached the contract because they did not get what they were expecting, or the quality of some service is substandard, or something has been done not according to specification, and so on. The normal way to address this would be to discuss with the other party and say, hang on a second here, we said you were going to do this for me, you produced something different, can you please fix it? If the other party says, I think I did what we said we were going to do, or there is some misunderstanding about what we were doing, then this is again something that you should be able to work through. If you get to the point that the other party says, I don't agree with you, I think I've done my job perfectly, I don't understand what your problem is, if you got any problems, sue me, and you reach that level of breakdown, then you are in a situation that you might end up in a courtroom. We are doing this in a business commercial setting. I'm not talking about tort actions where you suffer damage, then you're trying to go after the other party because, say, the neighbor wasn't taking care of their tree and it fell and it kind of ruined your car or ruined your garden, right? Or it did like a wall in your house. I'm not talking about that kind of stuff, because that stuff inevitably ends up in the courts. And I'm not talking about the consequences of criminal activity, because you can always, if somebody burglars you and you know who it is, right, then you can sue them in a civil court for compensation for the stuff that they've stolen from you. Yeah? Again, this is something that inevitably will involve the courts. But the commercial business side of things, that is mostly about contracts not being performed in the way that people were expecting. So it's about kind of a mismatch of expectations. This is something that you should be able to find other ways to address rather than the trouble of getting a lawyer, getting legal advice, getting the lawyer to represent you, ending up in a courtroom, having all the costs of paying the lawyers, paying the court, and going through a lengthy process. Now, the system here is relatively efficient in the sense that you will, if you file for an action, you will have resolution of it within a reasonable time frame. It might take a year. It's not the end of the world. Complicated cases might take more than a year, but you can see an end of the process somewhere. So if your builder has done some work that is inappropriate, then you can probably kind of handle a year to get some resolution, especially if the cost of remedial work runs in the tens of thousands of pounds. In other jurisdictions, though, where the court systems are less, if this incentive against using the courts is time in itself. So if you go a construction dispute and you want to sue your contractor and you file in court and they give you a hearing date in 3 years' time, and then you know that once you got your first hearing, then it's going to be another 3 years before you have a decision, then it renders the whole attempt to resolve this through the courts pointless. Because if you're looking at the resolution to such an issue in 6, 7, 8 years' time, by that time the contractor will probably have gone out of business, right? Or you might have gone out of business. I mean, you cannot project far. If you're talking about issues of financial compensation, you cannot wait 6, 7, 8 years. In all probability, the entity will not exist. They will have gone bankrupt, so you're doing all these things for nothing. And if you're dealing with a really dodgy contractor, there isn't much chance that they're going to be around for very long anyway. Yeah. So if the system is not efficient enough to be able to resolve the dispute in a complete way within an adequate time frame, then this is not a viable way to resolve business problems. So especially if you're talking about problems that you've got with somebody that operates abroad and involves other legal systems or courts in other jurisdictions, then you will have to think very carefully whether this is the type of dispute that you want to take to a court. Or it could be that the complexity of the dispute is such that it will take forever. So you get complex fraud cases, you get complex financial claims that take years and years and years to resolve in the courts because the task is simply too big. So working through what happened takes years. You usually come across this in terms of prosecutions. Think about the LIBOR scandal, which was a manipulation between banks in setting interest rates and so on. This was a fraud case, so this is like a criminal. There's the criminal aspect of the law. It took forever, not because the courts didn't feel like doing it, but because it was such a complex thing to do. They needed to go through so much paperwork. They needed to talk to so many witnesses. So if you've got something that is going to take forever. Now, if you have something also that the courts do not have the capacity to understand and resolve properly, then you end up in trouble. Courts are very capable of dealing with predictable types of arguments. I mean, you've got lots of construction disputes, you've got lots of kind of supplier failures, you've got lots of mismatches when products have got a problem with them. The courts I have no issues in understanding this. But if you've got a dispute about some kind of weird Bitcoin transaction, right, that has got elements of both kind of civil law and criminal law within it, and it's about financial instruments containing technologies that nobody understands, you shouldn't take for granted the capacity of the judges to understand this. If this is the sort of stuff that only a few insiders and you need expert advice, and there are very few experts that understand what this is, you shouldn't automatically assume that your standard kind of commercial law judge sitting in a court here will be able to get on top of this information. And if the judges cannot understand what's happening, then it's going to take a lot longer. We don't have juries here in civil jurisdiction, in civil cases. So if we're talking about civil cases, the concern is not, can the jury understand what's happening, right? We don't have them. So this is more a concern for other jurisdictions like the US. Here, juvenile fraud cases where the jury might have difficulty understanding what the hell's going on. So it's more the capacity of the judges to understand what's happening in order to resolve the disputes appropriately. So all these reasons give you a fair summary of why you might want to stay away from the courts. Issues of cost, issues of complexity, issues of availability of the courts. All of these will be whether you want to solve if this is not solve it. And most of the time, people are really worried about legal, because if you end up in court for complex, you need legal advice, and legal advice. We've established why litigation might not necessarily be the best way to fix problems. So if you go with that, what else do you have? We've got all these things that come under the big label of alternative dispute resolution. Why alternative? Because it's not litigation, right? So on the one side you've got litigation, right? So on the one side you've got litigation, and on the other side you've got everything else. Everything else comes under this label of alternative. Now there are lots of those, and maybe some of those you may have actually used yourselves. There's a whole that start from simple and cheap, and then they progressively become more complex and more involved and perhaps more expensive till you get to the point that you end up in a court somewhere. From your customer interactions and your normal sort of consumer perspective, you have probably come across the idea of an ombudsman. That has to do with a particular service that you're using. You guys ever heard of the ombudsman before? It could be an ombudsman or an ombudswoman. It seems like a strange term, doesn't it? This is some sort of informal, friendly resolution service primarily geared towards consumer disputes in particular industries. For instance, booking a ticket. And as you're booking the ticket, you're booking yourself a holiday, right? You go on kind of last minute or Expedia and so on. You pick of course now nobody's traveling anywhere anymore, but you book your flight, you book your car rental, you book your hotel, you book your car rental, you book your hotel. The thing matches it all together, gives you a price. Okay? Right. You press pay. 10 minutes after, you get the confirmation there, and then email just to check. It's charged you something else. Hang on a second. What's going on here? If it gives you a price, you've all done this before, right? You've all booked something, haven't you? When it gives you a price, just here's the total price, and then put in your credit card details or whatever, that's it, right? You shouldn't be That's it, right? You shouldn't be charged anything else. Now, what is the legal reason why you shouldn't be charged anything else? Is that according to the Consumer Rights Act, if you're making an electronic transaction online, the final page before you put in your payment information is required by law to be the total price with any additional charges. If there's anything flexible about this, it needs to be clearly laid out. Sometimes there is something flexible about this. It could be if you do your mobile phone contract, for instance, the contract might contain a term that has got variation. Of terms, which might include variation of prices, and it does happen, right? However, the price that it gives you there and then needs to be clearly presented to the customer. So if you're getting a new contract and it's £20 a month, right? It might contain a very month, but when you clicked on 20, you get in 20. So today, you should receive a confirmation that says you got a contract that says £20 a month. If the confirmation says 40, we have a problem, and this is against the Consumer Rights Act. The rights that you've got under the Consumer Rights Act are to cancel this transaction, or for the company to give you what is transaction, or for the company to give you what it is. That's your selection. Right? Now, that's the law, that's the legal background. But the reality of the matter is, you were trying to engage in some transaction and you got something that appears to be an error. You call the company right away and you say, you send me a different price. If they say, no, I'm sorry, that's the price meant be, I don't know what it is that you saw, right? But the price for this product, and now it's a non-refundable ticket, so now you booked the whole thing, there's nothing we can do about it. And if you tell them, no, and if you tell them, no, because that's not what you showed me, this is not what I got charged at the back, and this is a problem for you because this is a violation of my rights, and I want you to do something about it. If they say, no, we think you got this wrong, we cannot help you any further, that's it. Theoretically, you can go to the small claims court and file a claim right away. Right, and say that I've been. Let's not worry about how you prove it, right? If you're, if it happened to you before, like it's happened to me on a few occasions, you'd probably. It's a good idea to take a screenshot of the payment page before you actually put your payment information in, right? So that's always a good thing to do, or kind of print a PDF of the last thing that they've got before you need to pay for it. That way you can prove it. But let's not worry about issues of proof at the moment. The thing is, you thought you were doing something. There was nothing wrong with what you were doing. They made some sort of mistake in their computer system and something else. You've been charged something else. You can go to the small claims court, but this is going to be anxious for you because you're going to be thinking, have I understood this correctly? Right? Do I need to talk to a lawyer or not? If I go to the court, am I obligated to have a lawyer? I don't know. You're not actually. And I'm going to have to pay something in order to file in the court. And what happens if I misunderstood all this? So not only now I've got a holiday that I'm paying more than I bargained for, but I've also paid like £100 to the court to file the action. And who the hell knows how else it's going to cause? It's going to cause you anxiety, right? Or it's going to cause you some level of kind of doing research to figure out how to access this part of the court if you haven't done it. One of the things that we're less good at in law, if you're doing an undergraduate law degree, is that we know about the practicalities of it. We attempt to teach you things about the substance of the rules, but we don't teach you the mechanics of accessing it. Meaning that everybody graduates here with a law degree, nobody has a clue how to file in court. That's the kind of stuff that you do when you go do the LPC or something like this, yeah? So we're ignorant of the mechanics. Even when something happens to us personally, and we're all people with kind of law degrees and surrounded by lawyers, nobody can help you with anything practical. That's a problem. Putting that aside, what about all this ombudsman stuff, right? Because when you're on the website of the travel agent, it says at the bottom, we're members of this, that, and the other thing. This is for complaints. This is for insurance in case we go bankrupt. This is for insurance in case the airline goes bankrupt. All this stuff, right? There are all these logos and things at the bottom that's supposed to make you feel better. So you might think, okay, if this is like an external complaint thing, why don't I go and complain and tell them what they've done to me? So that is the number one level of choosing an alternative route from going to a court in order to complain. If you go to the ombudsman services are built on an industry basis. So the travel agents have got one. The insurance companies have got the opticians have got another one. So these things facilitate complaints. Crucially, they're free to you. So you don't have to worry about it. It's a simple process. Somebody will happen. You don't need legal representation. They're the ones who are going to explain you what your legal rights. The only thing you need to do in to explain you what your legal rights. The only thing you need to do in accessing these types of services are for you to be able and to provide evidence that you've got to back up. You don't know the law, you do representation, and it's of no cost to the customer because it's funded by the industry. They will say you can access this after you've exhausted the internal complaint processes. They will do this because they don't. The pool's not clean, and they didn't like their bed at the hotel and all that stuff. But you have gone through the internal process. And the way you do this is that you call them, you told them there's a problem, they said there's nothing they can do, you ask to escalate, they again told you there's nothing you can do, then you have to tell them, according to the information you get in these, things, that I want final decision because I intend to go to the ombudsman. And then it gets pushed to somebody higher up in the management, and maybe they will have another look at it, maybe not. In my experience, the vast majority of the internal complaints process is get bored and leave us alone. So they'll say no, 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 and nobody even reads what it is that you're complaining about till you say you're going to go to the ombudsman. At that point, they're going to read what you're complaining about and still say no. Then you go to the ombudsman, submit everything, sit back and relax. In a couple of months' time, you're going to get an email by saying, I'm the person who's been appointed to look at your complaint and so on, at which point the company is going to fold and compensate you. Because if we're talking small amounts of money, you're arguing what? 50, 100 pounds. The time it takes for the company to have a proper look at it is more expensive than the value of your claim. So once the ombudsman communicates your claim to them, most of the time they'll come back and... Now, if you got a more substantial claim that runs into a few £100, then if you're right, and the ombudsman communicates that you're right, if the response from the company is inappropriate, right, the ombudsman is going to say, we find that the company has done something wrong. If the company still refuses to compensate, then you have very good grounds to take them to court. The problem with the ombudsman is that this is a conciliatory, friendly arrangement. The ombudsman has no enforcement powers over the company. So if the ombudsman finds that the company has done something wrong, and the company refuses to address this, then they cannot make them. But then you know that an external party has looked at your problem and agrees with you, and agrees that you've got the evidence to back it up, which puts you in a much better position to file in court. We'll go that way. But what I'm trying to demonstrate here is that all this actually usable stuff. This is not theoretical, right? This is actual stuff. And all right, why not try it? What you got to lose? It's free. I mean, I'm not saying that you're going to do it for harassment, right? So you need something needs. I'm telling you, it's really stuff that happens all the time. You put like a discount code, right? And then their invoice says something else. It's like, well, you should go with it. Your attitude most of the time is, yeah, fuck it, it's just £10. Why? If it's an error on their part, you should pursue it. Now, we have other things though. So the ombudsman facing stuff. What if this is a business transaction? If it's a business transaction, like an ombudsman thing is not really going to be suitable for you. What you want is a third party to sit down and discuss, to be a go-between in helping you mediate the problem, right? Because most of arguments are due to a failure in communication. And you know this from your personal lives where you're arguing with your boyfriends and girlfriends and stuff, right? It's the failure to communicate to the other party what it is that you want that causes this mismatch of expectations. Therefore, the idea is that instead of you kind of going nuts and hiring lawyers and running to the court, if you could just sit down with the other party and have an independent third party listen to you, if you try to explain your situation, not to the party with whom you're pissed off, you have a problem with your contractors, right, and you hate them, it makes it difficult to communicate what your problem is if you're in a tense personal relationship. If you've got a third party present, your attempt to explain to the third party what happened and to listen to the explanation of the other side might help you to reach a resolution. So these come under the umbrellas of adjudication or conciliation or mediation. This is a very well-established system of having a third independent party to sit down and assist two sides that are arguing over something. The crucial thing about this works for consumer issues, but mostly suitable for commercial business issues. The important thing is that this is a process where the people are reaching a negotiated settlement, meaning that the third party has got no enforcement powers. So if they agree to disagree, then there's nothing they can do. Or if the mediator agrees with one side and disagrees with the other, they've got no way to make the other side do anything. So all of these, ombudsman, mediation, conciliation, adjudication, are ways in assisting people to resolve the issue by themselves. And by the way, to go back to my ombudsman example, what I had in the end was a recommendation from the ombudsman as to what should happen, and then an offer from the company. The company said, we'll agree to pay you that amount. Are you okay with that to drop your complaint? So you reach a negotiated settlement as the result of all this process. If a negotiated settlement is not what you want, and you want somebody with enforcement powers that makes a decision as to who's right and who is wrong, but you don't want to go to the court, then what you got left is arbitration. Now, arbitration is a way of resolving disputes, and it leads to a why arbitration more closely resembles litigation, because it's a final decision-making process. The thing about arbitration is a final decision-making process, meaning that both parties agree to give to a third party the power to decide what to do. And this is not like, okay, I say I'm going to do what you tell me to do, and if I disagree in the end, I'm not going to do it. Because the law gives the enforcement powers of the court to the arbitration. So the people who run the arbitration, they're called the arbitral tribunal. So on the basis of the Arbitration Act of 1996, the arbitration tribunal has the same enforcement powers as the court. The court will not touch it. If you've signed an arbitration agreement that says, if we got any problem, we go to arbitration, you cannot go to the court. If you turn up at the court, the other person is going to say, no, we said we have an arbitration agreement, and the court's going to say, sorry guys, you said you were going to arbitrate, now you have to go arbitrate. And whatever outcome you've got from the arbitration, if you refuse to comply, then they're going to come, show us the decision of the tribunal, and us, the court, are going to send in the bailiffs. So you basically subcontract, if you want, the decision-making and the enforcement power of the court, and you're passing it on to the arbitral tribunal. So going to arbitration requires agreement by the parties. This agreement is either present in the original contract. There are lots of contracts that say, in case of argument, we go to arbitration, and arbitration is run by somebody over there. Or it could be that after the dispute arises, you're thinking, okay, we're not going to resolve this between us by talking to each other. We want somebody else to figure it out. How about we go to arbitration and we sign the agreement there and then? But in the whole array of alternative dispute resolution that we've got, it's important for you guys to remember the distinction between things that are talking shops or opportunities to talk in a structured way that arrive at a negotiated settlement, and the final decision-making processes like arbitration in the courts. So what we can do, and obviously all this has got very secure legislative basis. For arbitration, we've got the Arbitration Act of 96 as this most modern expression, but we've got the Alternative Dispute Resolution Directive, which is a relatively more recent legal instrument that gives legal basis to this whole universe of different ways of resolving. The topic is employment law. The stuff that we've seen so far are dealing with various aspects of the interaction between business and customer. Clearly, we've seen some aspects of the interaction that have to do between business and business, but our focus mostly has been between businesses and customers. However, if you're looking at things that are relevant to business activity, your relationship with your employees is crucial. So there aren't many businesses that reach a level of scale that do not employ people. Any sort of business of any scale will have significant employment effects, both directly in the people that work for them and in the various other people that do business with them. So employment law becomes a very significant aspect of people thinking about how they run their business and how effective their business is. And from your personal point of view, you're all going to work for somebody. I mean, okay, there's the occasional person that's got their own business, but for the most part, all of us aspire to employment. Or if we got an idea, like if you're more entrepreneurial or you're thinking about something doing for yourself, this is usually on the side of regular paid employment by somebody. So knowing what your employment rights are is crucial if you are the business, but it's also fundamental for you in understanding your own prospects and if something goes wrong or if something is unsatisfactory, to having a capacity of dealing with that. Because we're London-based and the majority of people sort of live with family, but we're all in kind of accessible locations, and considering the kind of cost of this whole thing, the majority of our students actually have got part-time jobs. We even got some students have got full-time jobs and they do their classes in the evening or they do their classes part-time. This is perfectly normal. So knowing something, if you haven't already done employment law, which you have not if you are first-year students, tells you something about the sort of treatment you should be receiving at work and whether it's fine. Because if you've never heard of that stuff, you don't know really if they ask you to do something that goes over and above what the law provides. Right, so what we do is that we have like a quick overview of the main features of English employment law, and we think about the rights and obligations that will arise out of a contract of employment, including how do we determine if you actually have a contract of employment, because it's possible that you do something and somebody pays you, but you're not really considered an employee. And then we talk a little bit about other stuff that have to do with your experience of work, like health and safety legislation and all of these things. So if we're talking about employment law, we're talking about the law which covers the relationships between employers and employees in general. It covers the way in which people work, and it covers the relationships between their workers, their management, and their representatives that could be through a recognized trade union and so on. And the state will regulate the way in which all of these relationships are put together, and the state regulates how work is carried out. And this is important both to ensure the safety and security and sort of appropriate experience of people at work, but also to deal with larger issues about giving the opportunity to make a living and dealing with issues of opportunity and equality, wealth generation, and all of that. So employment is certainly something that needs a great deal of regulatory involvement, because you cannot leave it to people to self-organize, for the very simple reason that you need to work, because if you don't work, you don't earn money. You don't earn money, you cannot live. So for you, work is essential. However, your employer might have lots of choices. So normally, there are multiple applicants for a job. If you don't get the job, this is a big deal for you. But if they don't give you the job and they give the job to somebody else, it's not a big deal for the employer. Therefore, there's a huge inequality in bargaining power. So if you left this field of law unregulated and you left it to freedom of contract, for people to put their contracts into their contracts what they want, you are really in a position of extreme weakness. And at the level that we are at, that we're normal workers, we really would have no influence. I'm not talking about big, high-flying corporate executives in a very dynamic market where they can pretty much dictate the terms, or they can influence quite significantly what's happening. If you're a big football player, okay, and everybody wants to have you, then you negotiate. You're probably more powerful than the club that wants to get you. So you put the terms and conditions that are working for you. But if you're like a random job that everybody else can do, they could just hire anybody else at any given moment. Even in places where there's scarcity, you cannot really affect. I mean, even if you're a medical doctor, that there's a need for medical doctors, still you cannot really dictate your terms and conditions of employment. Plus, there are other stuff that that come within work that they should not be up to you to resolve. Issues like, okay, we've talked about the idea of exploitation. This could be both because the terms and conditions of the contract don't take into account your interests, but it could also be that they're clearly asking you to do stuff that you shouldn't be doing at work, that are not allowed that they should not be allowed in general. Like if this area was not regulated, what's there to say that you wouldn't be working 20 hours a day, 7 days a week? The sort of stuff that you hear about developing countries when you're talking about violations of human rights in the area of work. And issues on discrimination, right? If this area is not regulated, there is a very significant potential that you might be discriminated against, in the sense that they might prefer to hire the men rather than the women. They might prefer not to hire people from ethnic minorities. They might prefer to do all sorts of things, right? And so you want not that discrimination still does not take place, but at least now you know it's wrong. And not only you know it's wrong, there are the legal tools that if you catch somebody discriminating, that you can fight against it. Imagine a situation where, that would leave you, if you are in a group that is the minority group in whatever context we're talking about, that would leave you in a much weaker position. And there are other things that have to do with work, like the entitlement to leave, the entitlement to vacation, regulation of working hours, maternity leave, paternity leave, sick pay. All of these things are fundamental in your experience. They will affect your lives very severely. They're fundamental to your experience of work. Look at what we're dealing with at the moment. If you're asked to self-quarantine, then you cannot get to work. If your employer does not accept that you work from home, or you do the sort of work that cannot be done from home, then do they have to pay you? How would you know, right? So all these rights are built into your individual contract and the law. Now, what's happening in this country, and if this happens to you and for your part-time jobs, if they ask you not to come in, there's statutory sick pay, but then whether you're going to get above statutory sick pay it depends on your employment contract. So unless there is intervention by the government to say we're extending sick pay, either at the level that's paid or at the length that it's paid, then you fall back to your employment contract, and it could be that you end up losing pay. That's even if you're on a regular contract of employment. If you are on a zero act, which means that you only get paid for the work that you've actually carried out, and they ask you not to come in, then you haven't performed the work, therefore you cannot invoice, you don't get paid. This is a very significant problem for everybody. Our people who come in, we have a lot of sessional teachers who come and teach in the hour down, and they're not in here to deliver that work, be able to pay them. There's an issue as temporary workers. Do they have the right to sick? Will the university do something on its own initiative to? Now, if you get in trouble in the context of employment, the law provides for specific mechanisms that are dealing with dispute resolution, meaning that you're not left on your own. There is a series of employment tribunals that are specifically built. There are specific types of courts that are in disputes. The reason for this is that you need specialized people who are specialized in this area of the law, so they're able to more quickly and more efficiently go and resolve these problems. So if I get into an argument with the university here that relates to my conditions of employment, or the university thinks that I've done something wrong and they want to penalize me somehow, if we cannot resolve this between us, then we will probably end up in an employment tribunal. So an employment tribunal is like a court, but it is like a specialized part of the court, and there's the employment tribunal, and then there's the employment appeals tribunal that deals as an appeals court for this area. And if what you're doing raises obviously an issue of law that is a matter of legal interpretation, then after you work your way through the tribunal and the appeals tribunal, then you go to the Court of Appeal and the Supreme Court in the end. So it integrates obviously with the normal court system. But because a lot of disputes at work, they're not about interpretations of legal rights, but they are about relationships. This is an area of the law where there's a lot of scope for alternative types of dispute resolution. So think about going to the employment tribunal as going to court. So it's the litigation option that is available to you. But most of the time, you will be able to resolve, or you're encouraged to resolve, the problem that you've got at work by discussing with your employer with the help of an independent third. ACAS, which is the Advisory Conciliation and Arbitration Service, this is built. This is done through legislation. It's governed by the Trade Union and Labor Relations Act, and it's meant to be there as a sort of mediation conciliation service for employment problems. So what they're going to do, if you get into trouble, the whole system gears you towards alternative dispute resolution, and if that fails, then you've got the issue for employment tribunals. You're not obligated to go through this process. If you think it doesn't work for you, you could go to litigation directly, but most of the time it works through this. If you heard that the senior civil servant in the Home Office that resigned because he was getting bullied by Priti Patel, this guy is going straight to an employment tribunal, because this is not an issue of like we're having some trouble that we're trying to resolve. It's not me complaining that I didn't get promoted or the university not liking my work, so we're trying to work through it. What happened there suggests a complete breakdown of relationships where the person no longer wants to be there, but he thinks that he's been dismissed and he wants compensation for that dismissal. Therefore, there's no point in going through a mediation conciliation service, because that's not the outcome that he's after. He doesn't want to remain there. What he wants is monetary compensation for being treated badly, and that's why he goes straight to the employment tribunal. Now, one of the important things to discuss a little bit is the extent to which a business will be liable to things that it does. And this is seen both in the context of employment relations and more generally. This is the only way in which it can work for corporations, because corporations are, as we've seen in our other classes, they're legal fictions. So a corporate entity has separate legal personality, but it's not really a human being, right? So it can only work through the actions of others. So the idea of vicarious liability is that you take the actions of others and then you flow up the responsibility for this in the corporate. This links up with things that we've done in the past, like the doctrine of agency. So if you're acting as an agent, you're acting as an agent on behalf of somebody else. So contractual obligations for what you do are not between the agent and the customer, they're between the customer and the principal. So the same idea operates. The agency works for contractual and stuff that you do on purpose, that the relationships you're trying to create. But for stuff that you don't do on purpose, negative consequences of stuff that happened, there's a similar mechanism. Through this doctrine of vicarious liability will flow from the actions of individuals and attach to the corporate. So if an employee is responsible for some harm that happens due to their negligence, then it's not the individual employee that's going to get in trouble, it is the business that sent them to do the work. So if somebody comes here to kind of this IT equipment and does this wrongly, and the place catches fire, then the university will not be suing the employee who was doing the wiring. They will sue the company that sent him, because in law, through these doctrines, it is the company that is responsible for the actions of employees in the performance of their jobs. So to break this chain, the company would really need to demonstrate not that the person has done something wrong and he was meant to do his job properly, so he wasn't authorized to do his job negligently, therefore it's not the company's fault. This doesn't work. So long as he's doing something that is within the context of their work, whether they do it bad or not, it's the fault of the company. The company would need to dissociate. They would need to demonstrate that the employee did something completely random, right? So you have an electrician coming to fix that. They're in here, they steal your stuff, or they assault somebody. Yeah. So obviously, kind of assaulting people where you've been sent isn't part of you being an electrician. So it seems to be quite removed. So if the company is successful in showing that what has happened and the harm has occurred from an action that's completely unrelated to the person's employment, then the liability will remain with the person who's done the wrongful act as opposed to the corporate. But for everything else, even the negligent or reckless or incompetent performance of a job, right? It is still performance of it. Becomes the problem for the corporate. Criminal obligations are dealt differently. So you heard about the idea of kind of actus reus and mens rea and all of that business. If for a criminal act you require both the physical action, but you also the mental element of intent and so on, this becomes a little bit difficult to handle when you're talking about corporate entities. So obviously an individual will have the sort of mind frame that is linked to the offense and will physically have committed the offense. So you can put the two together. If you're talking about a corporate entity, it becomes very difficult. This corporate entity had the mental elements that come to an offense. So if you can prove that the management of the company, the senior managers have authorized the commission of a criminal act, then it's fine, right? Because the board of directors is supposed to be the mind of the company. If you can locate something that looks like a mens rea at the decision of the board of the directors, you'll be able to prosecute directly. However, this doesn't work very often because people are not that stupid. People are not going to put in the minutes of a board meeting, let's take the wheels of that train and we don't care if anybody gets killed, right? So the law has developed different mechanisms for the criminal aspects of corporate liability. And in things like the Corporate Manslaughter Act, when you're trying to make corporate entities responsible for wrongful death, usually through industrial accidents and things like this, what you're looking for is not the mental element and the decision of somebody, you're looking at deficient structures of control. So you're looking at a corporation that has a culture of disinterest and safety of people. And it is this disinterest that sooner or later results in some horrible and killed. So then you can prosecute the corporation for this deficient culture as finding a mental intent or act like you would in normal criminal law. Right, let's look a little bit more closely at the idea of what goes in your contract of employment. You have a contract of employment that has got contents, right? So the sources of legal rights will be expressed terms in your contract and the implied terms that will come from general legislation. So in order what is actually expected of you, you will have a look at both your express terms and what the law implies. Now, in more formal employment, you will usually receive a document that outlines these terms and conditions. So if they hire you at Starbucks as an employee, you're going to have to sign a contract of employment. So it says in there what are your rights and obligations. If you work in retail in Primark, or you're an assistant in Primark, or you work at the tills at the supermarket, again you have a contract of employment. Where you might have employment but not a contract with the terms written down is for rather more informal stuff. There's still employment, but if I have a cleaner that comes at my house every week, we've discussed what she's going to do and how long and how much I'm going to pay her, but we don't have a document expressing this. You don't need a document. Remember that when contracts are formed without the need for formality, so you can still have a contract even if the terms and conditions are not expressed in written form. And it's possible that I've got my cleaner is my employee, but we've orally expressed the terms and conditions. But of course, if the only thing we said is you come for 3 hours every Friday and I give you £10 an hour and clean the whole house, and that's the only thing that we said, we haven't actually covered leave pay, we haven't covered national insurance contributions, we haven't covered pension, we haven't covered any of that stuff. So that will necessarily come in through the general legal obligations in the form of implied terms. One of the fundamental things that you've got as implied terms through the common law, before you even look at the statute, duty of trust and confidence, meaning that when you work as somebody's employee, you are legally obligated to have some regard to the interests of your employer. So not only you're meant to perform the work in the way that it's been described, but you also are meant to work with the benefit of the employer in mind. So if you find that you do stuff, or your employer complains that you're doing stuff that are actually undermining the business, even though you're technically carrying out the tasks, then they might have a reason to dismiss you or treat this as a breach of your contract. Things that have to do, for instance, affecting the reputation of the place. So you're working at the till, at the supermarket, you're there for the hours that you're meant to do, and you do the work that you're meant to do. But if you're sitting there and you're telling every single customer that, you bought this, you're an idiot. If you had gone to the market next door, it would be better and cheaper, and you do this consistently, then your employer could have the right to come and say that you have a duty to us to also maintain the integrity of the brand and promote the business and so on, or at least not to do anything negative about it, so they could dismiss you on those grounds. Or equally, if you tell the customer, if you slip me a $5, then I'm not gonna scan some of your stuff here, then this is also a violation of the duty, even though this is not expressly mentioned in the contract. Then this is a violation of your duty to your employer. Now, the statutory are perhaps more significant, and so much comes out of this because this is a very, very heavily regulated area of the law. For instance, the main pieces of legislation that become relevant to an employment contract are things like the Equal Pay Act. It imposes a requirement for equal pay for similar work of equal value into every contract of employment. Now, this is very funny. Yeah, it is very, very funny, because it's obviously not what's happening in reality. Yeah, because you've got all these constant complaints about differences in pay based on gender. So this is a clear violation. You don't even need additional law to tell you that discriminating on gender is illegal. Right? The fact that you got an equal pay obligation, but as it happens, you pay the men more than you pay the women for the same kind of stuff, it's a problem. It also creates issues in chains of command, because you may have noticed that at uni, we all do the same stuff, right? What you don't know is that we're all getting paid extremely differently. Meaning that the person who comes in here and runs the class and delivers the class could be anybody, and it's the same for you guys, and it's the same aspect of the work. However, some of them are going to be sessional teachers on 0 hours contracts. Some of them are going to be lecturers, some of them are going to be professors, right? The person who's on the 0 hours contract is going to clear £10,000 a year, the lecturer 30, the professor 60. They all do exactly the same stuff. Now, this is not the violation of the Equal Pay Act, but it inserts an element as to how legal prescription does not necessarily create a level playing field and does not create equal opportunities for everybody. But it would be a lot worse if you didn't have it. It would be a lot worse if you didn't have it. If you didn't have this and you hired people on the same level, so here at least we've got pay scales, right? So if they hire you as a lecturer, then it says your salary is going to be between, I don't know, like 30 and 35 or something like that. Yeah? So at least you have an expectation of where you're going to be. But if you didn't have an equal pay obligation, it could be that, yeah, we're hiring you as a lecturer, and because you're my mom's cousin, we're going to give you 50, and the other guy we hired, we're going to give 20. So it is, it is a step in the right direction. So one's the Equal Pay Act. The second is the Equality Act of 2010, which provides the right to equal treatment and not to be discriminated against. You've got the Health and Work Act of 74. You've got the Employment Rights Act from 1996. This includes things like statutory minimum notice periods, not to have unlawful deductions made from wages, the right to maternity and paternity leave. You've got the working time regulations from 1998. These limit the number of hours that can be worked in any 1 week and provide a minimum period of annual leave. You've also got the National Minimum Wage Act, also from 98. It provides a right to a minimum rate of pay. Of course, there's a difference depending on how old you are and so on, but at least you've got this. Now, all these come on top of the express terms and conditions of your contract of employment, and they give sort of meaning and definition to a lot of these terms and conditions. These things are very important. People usually don't appreciate how important these stuff are till something goes wrong. till you go and say, we think this place here mistreats one of our colleagues and they fired him. And we think that this is really bad, okay? So we're all gonna go on strike. And the university comes around and says, you're all fired. Then you realize you have a problem, yeah? Or when your employer starts randomly discriminating between people, or paying people different things, or withholding pay when they disagree with something somebody has done. Or you don't give people, you give some people less leave than others. All of these things get a bad press because the quality of journalism in this country is very low. And because people have been subjected for decades to a sort of business-focused propaganda that everything that has to do with employment rights and protections is a huge cost on the business that then is passed on to the consumer, and then you have to pay for it, and it's all unnecessary. And the second aspect of it, that it's all foreign stuff. It all comes from European directives and so on, and it's all kind of crazy bureaucracy and kind of health and safety gone mad and all this utter nonsense that you hear day in, day out. So when you've lived in this environment, you begin to think the same thing. That view is going to be quickly dispersed when they tell you they closed down units and stuff because of coronavirus. Therefore, anybody who works in a cafeteria or restaurant around London gets fired, effective immediately, because we're not going to have any clients, right? So we're going to close the place down for a few weeks, fire everybody, no compensation, no nothing, go home. And then you sort of realize, hang on a second here. Or if they tell you, we want you to work every day of the week. The university tells me, we want you to come in weekends and do open days and stuff, and we want you to have like 8 hours of teaching per day. Or they start to kind of vary your rate of pay and all of that stuff. Or they reduce your leave. Or they pay you less than minimum wage. That's when you realize that this stuff's important. Yeah? So the current trajectory of policy making here is that now that we're free from Europe, we are free to let go of all these things that are constricting business. And the majority of people are going, yeah, this is going to be great. This is going to be great till you remember that you are a worker. What you're going to have is that when all these things are stripped away and all these protections are stripped away and all these unnecessary costs are taken away from business, a couple of stuff are going to get cheaper, Your toilet paper is going to go down by 20p because they don't have to comply with all of that stuff, so they can produce a little bit cheaper. The pay of the CEO of the supermarket is going to go up 100 times because they're going to put the excess profits back into their pockets. But you are going to be working the 24/7 for less pay than before. When you view it that way, maybe you should think that my question always for students is your dad Richard Branson, the Virgin guy? If your dad's Richard Branson, all of this stuff is unnecessary. But if your dad isn't a billionaire and you're actually working as an employee yourself, maybe that stuff is more important than what the newspapers are telling you. Equally, this stuff about health and safety, right? It's all unnecessary. It's all unnecessary bureaucracy. Yeah, till you crack your head open. Okay? Because when you lose a limb or you crack your head open or you're disabled for life because you've been in an accident due to the negligence of your employer, then you're going to see things in a different way. And when that happens, if you also don't get any, you're going to see things in a different way. So the things that have to do with health and safety have become very important components of our understanding of employment relations because they take so much space in what the employer has to do. And in fact, there is a cost of compliance. And there's a huge regulatory cost attached with all these things. But it's there for a reason. It's because we'd like people to stay alive. You can construct a football stadium way cheaper than here. How many of your foreign workers are going to die in the process? Because you can pack them like animals in a bus without air conditioning to take them to the construction site, and if a few die from heat stroke, doesn't matter, you got some more coming in. They can be falling off the ledges here and there and cracking their heads open. Again, doesn't matter. Once they get kind of seriously, permanently injured, you just deport them and you get some other people in. And it's all awesome. So this works well if you're a government that has a bill to pay to build the stadium, or you're the person who's building the stadium, the construction company. But if, again, think about it. Are you the corporate executive or are you the worker? Because if you're the worker that just lost a leg and is getting deported back to Pakistan, maybe it's not a great deal for you. So this is the sort of stuff that we're trying to avoid here by having all these health and safety at work. Now, finally, we can finish off by looking at the rights that the employees have in case of dismissal, because this is quite significant, right? Not only do we need to have an understanding of what the terms and conditions of employer and what is meant to happen to you while you're carrying out the work, and the associated benefits that you've got for working and how these are calculated, but also it is very significant for you to know what happens when your work relationship ends. Now, clearly, if you leave on your own volition, that's fine. You have to respect the terms and conditions of your contract, or to negotiate your exit, and that's it. But if they ask you to go, you have a problem, right? Because the majority of us are not working for the life satisfaction we get out of it. We're working because we need to pay the rent at the end of the month. If they tell me, don't come back tomorrow, and that's it, and I don't get paid at the end of this month, I have a problem. Therefore, I would need both mechanisms and tools to protest my dismissal if I think that I've been dismissed unfairly. And I would also have some expectations as to how I'm dismissed and have to be made if they're terminating my contract of employment, perhaps for no reason, or they're exercising a right to terminate without me being at fault, and so on. So there's quite a lot of information that has to do with employment rights, that has to do with either what we call wrongful or unfair dismissal. These have got specific definitions in the law. We will get the chance to explore this in the tutorials next week. But also there are issues like redundancy payment. So when they let you go, especially if you've been working for an employer for a specific period of time, then you get something like an exit bonus, if you want to see it that way. They're terminating you, yes, but they're giving you a little bit extra than the salary that you would be making for that last month in order to help you to survive while you're out of work and you're trying to find something new. Now, redundancy payments in this country are not very generous, so you're not going to live out of this. In Europe, better, and also some of the benefits, and this is one of the fun things about the narrative here. Anybody who has actually claimed benefits or have received the redundancy payment or unemployment benefit or anything like this in Europe, they know that it's way better than the stuff here. People here, as they're ignorant of what happens in other countries, they think that here it's so great and people are coming here to claim the benefit, right? Why would you come here and get a small proportion of what you would have from the same stuff if you stayed in France or Germany or wherever? Like, you gotta be out of your mind. Or you would be coming here to take advantage of the great facilities of the NHS. Yeah, I know it's great because you don't get to spend 6 hours waiting at A&E in France to be seen. So, it's a novel experience when you're doing it here. So great. Now, the stuff that you have here are built in the law in order to help you in situations like this, but they aren't great. And in terms of redundancy payment, the provisions here are very poor. This is not to be taken as a given. If you're a worker, it means you don't have the same rights as an employee. It means that you have a more distant relationship from the person that you're doing work for. So if it comes to rights in case of dismissal or anything like this, then the expectations that you've got as an employee are way more elevated than you have if you were a worker. So the difference is between you working, say, permanently for somebody and being a contractor. Okay? There's less expectation if you're a contractor. So the topic today is corporate social responsibility. This is
becoming, and is already, big business. For business students, things like corporate social responsibility are now well embedded in their programs. And anybody who might do either at an undergraduate or postgraduate level or an MBA, they will inevitably come through a discussion of all these things. It's key. Now, why are we going to talk about this? Because this links with how companies interact in a broader social environment. So in the time that we've got left, I'm going to try to explain to you guys what is corporate social responsibility, commonly referred to as CSR, and a little bit of how the law interacts with voluntarism, and a little bit about how the idea of a brand links up with these things. A lot of this discussion comes from literature that developed from the 1970s onwards, stemming from concern as to the behavior of corporations, especially in a global environment. And what we have is the observance of a series of negative outcomes coming from corporate behavior. These negative outcomes are possible even when corporations are staying within the law. And a great deal of what we're doing in a company law module is explaining the legal boundaries of corporate behavior, both external as regards third parties and internal. What are people allowed and not allowed to do? That's why we spend a lot of time talking about the boundaries between the decision discretion of the directors and as owners and the tensions that are created in there. But even if a corporate entity stays within the law, there is wide opportunity for a negative impact. And this is something that we need to think about, because corporations operate in a wider social setting, in the same way that an individual has got impact on the people that he interacts with, a corporate has the same impacts. If you scale this up to an international level, then the impacts can be more severe. If we're talking about multinational corporations that have got significant activities spread across the world, when you've got divergent regulatory requirements and divergent legal provisions, there is the chance that you've got quite a lot of regulatory gaps. So there are areas where corporations have activity, but there is no legal boundary. Or if there is a legal boundary, this legal boundary is not adequately enforced. Because don't forget that having the laws in a book somewhere is not a guarantee of effective enforcement of those rules, and there might be reasons why the administration of justice is problematic. So even if somebody suffers a negative impact and there is a law there that's saying that they shouldn't, they might have difficulty bringing it to get adequately a redress against the corporate. So both at domestic and at international level, there is an ongoing debate as to how corporations behave and how can we ameliorate perhaps any negative impacts out of their behavior. So all this literature comes from the 70s onwards, develops this concern about corporations. And this is one of the more famous, Elkington's book, one of the most famous books in this era that explores this idea of corporates having obligations that go perhaps beyond the strict legal requirements in the jurisdictions where they're operating. What is very famous as well is the idea of a pyramid of obligations that the corporate entity has. This is a formulation created by this guy Carroll, again at some point in the late 70s, and it now has become like a seminal piece in the literature, out of which we understand the idea of corporate social responsibility. But what are we looking at? We're looking at a set of economic, legal, and then beyond that, moral and ethical responsibilities of a corporation. So there is at the corporate level an economic base, for the very simple reason that if a company cannot turn a profit, then the company does not exist anymore. We've already dealt with the issues of insolvency and what happens if a company reaches the end of its life. Like a company is like a zombie, okay? An eternal being. It will not die on its own, no matter what you try and do to it. The only way you can effectively kill it is if it goes insolvent. Then, kaput, okay? Otherwise, there is no set lifetime for a corporation. So the underlying foundation of the company's existence is economic viability. If the company is not profitable, then the company will not exist. If its liabilities exceed its assets, it's dead and there's no coming back from that. So if we set a pyramid of obligations, at the base of this pyramid, supporting everything else that happens, is this economic imperative. Beyond that, we've got legal responsibilities. If a company violates the law, it will get in trouble. So this is a non-negotiable background for company operations. They need to be profitable, A, B, in the rules. They need to respect the law. And we've seen various expressions, as I said, of what this means for the external behavior of the corporation and also what it means for its internal decision-making in an organization. From that point onwards, we go to other stuff that are slightly more aspirational. There are ethical responsibilities, and now you've got a bit of a debate. People will argue that there are ethical responsibilities, that there's an obligation on the company to do what is right and fair and avoid causing harm. This might not necessarily have a legal expression. So I'm not saying that what I'm looking at is, the opportunity to respect the law. Is not harm in the sense that you have violated a criminal law or tort statute or something like this. But we're looking at avoiding harm and avoiding negative impacts beyond what the law is justifying. For instance, the law will say that the university here is under an obligation to provide a safe space. So if you get injured in the context of your employment here, then this is a tort. It could also be a violation of employment law. It can be a violation of health and safety law. It can be a violation of all sorts of rules, and the university as a corporate entity is going to get in trouble. But I'm not talking about this. I'm talking about the university not abusing its staff. You can pay people shitty wages. You can pay your sessional teachers or your lecturers very low. You can provide them with unmanageable workloads that provide for a very stressful life. You can enroll them with shitty terms and conditions in terrible pension funds that are not going to be able to support them in their old age. All of that is horribly nasty, but it is still within the law. So when we reach this level here and we're talking about ethical responsibilities, we're talking about an expectation that the company will address these issues, it will address these concerns, even though this is not a strict legal obligation. Nowhere does it say, you're meant to satisfy minimum wage. Okay, this is a legal obligation. But from that point onwards, it's up to you how much you want to pay people. The university could advertise sessional teaching jobs at £15 an hour. It would be within the law, but it's still a level of pay that people cannot survive on. So I'm trying to hear how you can go beyond the legal and still do stuff that people would expect that you do because it's the nice, fair, just, appropriate thing to do. And on top of that, if you want to go a step further, is philanthropic responsibilities. These are stuff that extend beyond your group of immediate concern. So when we're talking about being a good corporate citizen, most of the time we're talking about an obligation to consider the interests of stakeholders. Who are the stakeholders? Not the people holding the stake. They are the people who are not shareholders. There's a bit of confusion there. Shareholders are the owners of the business. They're the people who own a proportion of the business through their ownership of shares. Stakeholders are the people who have a stake in the business. People who are around. Employees, suppliers, customers, stakeholders in the university in a way. The local community, the environment. So there's a wide range of stakeholders, people affected by a corporation's behavior.
Now, the philanthropic, that is at the top of the pyramid, is concerned about people in general over and above even the stakeholders. So here we're starting. This is about shareholders. You need to return a profit to them. The legal responsibility is also linked to the shareholders. This is about stakeholders. This is above the stakeholders. You know, doing nice stuff for the starving kids. Doing philanthropic stuff is about everybody else. You know, saving the whales on the other side of the world, or you know, even argue that corporations, as an expression of good corporate citizenship, they even need to be concerned about that, even for groups with which they're not in contact. Yeah. How are companies regulated and controlled? One way to regulate a system is to leave it to the demand of those who are negatively affected. So litigation is a way to address those issues. You don't have a bottom-up imposition of rules and standards, but you give the courts the ability to address problems when they come up. This is how the law of tort developed, for instance, right? So somebody opens their ginger beer, they find the snail inside, they're going, what the hell? They go to a court to complain about it, and then the court is making up a rule that says you have an obligation, you owe a duty of care to the people who use your products or use your spaces not to cause them harm, right? A lot of innovation at the beginning of the 20th century developed along those lines. Negative impacts that people went to protest in the courts, and the courts slowly developed a doctrine of precedent that built up a set of rules that imposed restrictions on corporate ability, on corporate behavior and corporate decision making. Now, the disadvantage of doing it, well, there are advantages and disadvantages. The advantage is that this is responsive to actual needs. So you do not need a policymaker to come up with a set of rules for situations that might never come about. So problems, real situations, and you develop your rules on the basis of that. So it keeps costs to the minimum. You could argue that it is a more effective way to develop sets of rules to constrain corporate behavior. On the other hand, the problem with litigation is that some people have already been harmed. So somebody needs to suffer the loss in order for the court to make a rule that says, okay, this is not good, this should not happen again. But you've got an initial set of victims behind every litigation attempt to regulate stuff. It could be that the state takes the view that this is too much. We cannot afford to wait for the first generation of victims to then develop a set of rules that says this is not good in order to ban it and protect future generations. So then the state can choose to regulate top down by parliament enacting legislation that says you are and you're not allowed to do X, Y, Z. And of course, then this regulation, if it is created by parliament or it's created by a policymaker, then it gets refined by the courts, because these rights that are and obligations that are created through legislation that get tested and refined and enhanced when they get to litigation. But the idea is that more costly, because you have a rule that everybody needs to comply with, and it might impose costs and bureaucratic burdens on everybody, but it's trying to prevent a sort of first generation of victims. If you've got problems anyhow, then the courts can help develop this in ways that are more efficient for everybody. The problem is that sometimes neither of these things is sufficient. And if you're looking at Carroll's pyramid that I showed you there, maybe we can cover with this basic legal interests, but we cannot cover everything. Maybe it would be inappropriate to impose burdens of good corporate citizenship as a matter of law on everybody, because maybe it's not relevant across the board, or maybe corporations cannot cope with this because it's going to unduly restrict their operations. Also, there are areas where the law does not. What happens, for instance, how do you navigate institutional boundaries? How do you navigate jurisdictional boundaries? All this discussion about the corporate veil.
the idea of Adams and Cape and all of that stuff. The courts have been very resistant to lifting the corporate veil of disregarding the idea of limited liability and separate corporate personality. It means that if you've got separately incorporated enterprises that are part of a group, yes, but because they're separately incorporated, you've got these boundaries. These boundaries are essential to the way the system is built, but it could be that people can get away with nasty stuff by hiding behind those boundaries. What if these boundaries are actually crossing jurisdictions? What happens if the harm in you've got a multinational enterprise that operates as a group, it doesn't operate as a single entity, you've got separate incorporations. These different jurisdictions have got local rules that they need to comply with. What happens if the local rules are inappropriate or the legal system down there cannot cope in creating or refining those rules? So you could have your attempts at regulation from top down or litigation bottom up, but it works in inconsistent ways across jurisdictional boundaries, and there is nothing you can do about this. Okay, do not be naive, because I mark lots of essays where people go, of course the solution is some global regulation and peace and love, and this ain't the beauty of stupid speeches, this is reality. So yeah, more global cooperation would be nice, but it's not going to happen. I think it's what you do when you don't have the global cooperation. And also there are some stuff built into the system. So you can have initiatives at international level, but international law has its subjects, the states. International rights and obligations on the personal level. So a corporate actor, you can do whatever you want at the level of the UN. If this doesn't filter down into enforceable rights and obligations at national level, a corporate actor can still ignore on that stuff. They've been ignoring human rights and labor standards for years, okay? Because they don't have enforceable expression in national law. This is the only way the system is built. So to say, oh yeah, a lot of people are doing nasty stuff, so they ought to be legislated away. Fine, yeah, okay. But they can be legislated away here, but you still got the problem that the British multinational is doing business through a local entity. If you wait, you can wait for institutional development to catch up with the standards till the cows come home. But, this is not the relevant time frame, is it? So the weakness of filtering down international agreements or international standards into national law and then enforcement level, coupled with weaknesses in decision making and dispute resolution systems and judiciaries in a variety of countries, ends up to a need for some self-discipline in the corporations. So if you cannot force them to behave in more responsible or appropriate ways, then maybe what you can do is try and nudge them into behaving better. You try to influence corporate culture. So corporations do not go around and exploit regulatory gaps and engage in various nasty stuff in order to make, but they will themselves choose not to do this, even though they forego an opportunity for profit. And this is not just them being nice for the sake of being nice, or because they've been convinced to self-regulate because it's good for the soul. It actually does have a link with profitability, and the link with profitability comes by perceptions on the brand. This is easier to understand for companies that are retail focused. Have you ever been involved in like a consumer boycott or something along those lines? Did you ever try to avoid going to a particular place to shop because you disapprove of them? Shop at Primark because they think that Primark is offering products at too low a price, so they abuse some poor kid somewhere in Bangladesh that's making the clothes. So they prefer to buy the same clothes at the more expensive shop made by exactly the same kids. But that's something else. So you can understand the idea of a consumer boycott or the pressure it can put on a brand if people think that you're doing something nasty. So if a corporation, if Nike comes around and says, you know what, we'll drop our wonderful shoes, we'll drop the price by 20% because we're opening this new factory built entirely of kids.
And they work 24/7 because they have murdered all their parents, so they've got no homes to go to. So they live in the factory and with their little fingers make the shoes, and when they drop dead, we just get another batch, right? Because there's lots of homeless little kids around. And that enables us to pass the benefit down to the consumers by a 20% discount. Some of you would queue at the Nike shop. Some others would think, hang on a second, this is not good corporate citizenship. It's not very appropriate to take advantage of a nasty situation like this, so you might choose not to buy. Now, all this, especially retail, but not only in retail, you see, everybody talks about miner, right? Mining, nasty business. Environmental impacts very bad. The workers who work there tend to die all the time. Local communities are messed up. Usually when the workers or the local community starts to complain, then you ring up your friend at the army and then they send the soldiers and shoot everybody. Nasty business. But even these people have gotten now, they need to pretend to be better. So there is an attempt to engage with these ideas even for companies that are not retail focused, like petrochemical companies, okay? Or other stuff, who brings in your gas or electricity. This is not like shopping at Primark or shopping at the Nike shop. You perhaps got less choice. But everybody now is responsive to this because they've understood that there's a link between the idea of brand and the perception of that brand and an avenue that links the obligatory litigation or legislation with corporate behavior. We understand the link is legal. Some types of other kind of self-regulation and behaving nicer, the link is not legal, but it can come from a business pressure. The business pressure comes from people thinking that these people are not nice, therefore they don't engage with them and they don't shop there. So everybody tries to be better. You remember that the logo of Google used to be "Don't be evil"? Yeah. Their motto used to be "Don't be evil." And now you say, what is it? Is it Alexa, the Google thing? Alexa, should I be evil? And it replies, would you like a voucher discount on your on your basket? So you see Apple, you remember that was the old sign of Apple? You guys are doing this. That's what they used to look like. So, Apple is committed, highest standards, we love everybody. And corporate reputation is important. And it's both there's both a passive element, it's like what people think about a corporation, but there's also an active element. How does a corporation try to promote an idea of a brand as being valuable? And you think if you switch the stuff around, you switch the logos or you switch the color, it immediately you can feel that there's an impression. You thought, the thing that kind of looks like our proud British flag, that thing has a good connotation. The thing that looks like a bad connotation, right? You switch them around, you begin to think about how the brand is supposed to communicate. So all of that stuff can be influenced quite severely by people's perception as to whether a place is good or not. So people will perhaps get upset. You know what? People will get pissed off, the general public, about this stuff here. If a corporation says, yeah, those kids down there, we're making a great product. We don't care if they die as a consequence. People are going to treat this badly. So we discussed already who the stakeholders are. Is there a link between all this idea that you promote a more positive brand and you try to sort of elevate yourself in this pyramid of obligations? Is there a legal expression of this? Well, yes, it is, and we've seen this already. We were talking about directors' duties. We did see section 172. This is the expression in English law, the recognition that this stuff is important. So the concept of stakeholder and the treatment of stakeholder as a legal obligation is now incorporated into the Companies Act in section 172. Remember that this is not a hard obligation, meaning that the directors are not obligated to do nice stuff. What they're obligated to do is consider the interest of stakeholders. There needs to be no consequence, but at least they need to say that they've considered it. So if you're addressing a question on corporate social responsibility, you need to say that there is an increased effort to make a link in the legal structures between the voluntary, that is all the CSR stuff, and the obligatory, that are the normal legal obligations. But this link cannot be too hard. Don't be tempted to
to say, oh yeah, well, CSR is all like all this self-help stuff and the voluntary stuff is not going to work anyway because people are inherently nasty. We should just legislate everything and make them do it. This is missing the point. If you could make them do it by legislating, you would have done it already. The reason why we're talking about voluntarism is because we're trying to reach in areas where legal regulation cannot go. Yeah? So do not be naive about the propensity of legal regulation on an international setting to achieve outcomes. Also, don't be naive about CSR either. We're talking about a gradual effort to improve corporate culture. Most of them are doing it just for show. So most that we know are totally nasty, but they put out CSR statements and they do CSR reporting to pretend that they care. Okay? But this is the best of both worlds is what can lead to better outcomes. And I think I started off when I started teaching on these things many years ago, I was very skeptical. I thought this is bullshit. Because, we spend so much time talking about the law, we're thinking the solution to everything is to legislate it away. But it isn't, because if you look at the regulatory gaps and cross-border problems, the law cannot reach. So maybe this is not bullshit. Maybe it starts as bullshit. But then after a while, everybody does it, everybody has to engage with it, there's enough consumer pressure by everybody to start talking about it, and the more people talk about it, the more it becomes normal. And the more it becomes normal, the more an expectation is that you actually take it seriously. So gradually, all this has a positive impact in changing corporate behavior. And I think this is real. I don't think we're imagining stuff. I mean, there's quite a lot of studies showing that more engagement, even if it started at a rhetorical level, now is beginning to have real outcomes. So engaging with it and trying to do it, even though you accept that it's not an all-around solution for everything, I think is a positive thing overall. This is our second class, so we're going to talk about financial markets. So this is the first thing. Let's think a little bit about types of people who are involved in financial markets. I'm guessing having a look at who the players are in these markets and what everybody is supposed to get out of it, the types of products that you've got circulating is a good place to start. People need to raise money. Now, why do people need to raise money? Because if you get the money from somebody quickly, then you can invest it and and produce something that then increases your capacity, increases your outputs much, much quicker than generating that money on your own. So if you want to start from companies, for instance, why is it necessary? I mean, you could argue that it's not necessary to borrow money. You can just retain profits, and out of the profits that you make, then get something, right? So if a company is trading successfully, there's profit accumulating. That profit at the end of the year could be reinvested by getting better equipment, hiring more employees, getting larger premises, or expanding into new markets, or investing in IT, or any of these things. But you're going to have to wait quite a long time till you've gathered all that money to buy something. I don't know, how do you guys buy stuff? You can kind of save and then buy that iPhone 3 years down the line, or you get your dad to buy it, but that's not really borrowing, yeah? Or you can get it with your credit card right now and then pay in installments. So there might be some interest involved or might not be. I mean, some shops were offering interest-free repayments. Or you get a car, for instance. How do you buy a car? You can either save or you can get the car with the financing. It might have some interest or not. I mean, I got my car with a 0% finance. No, put some money up front and then the rest I was repaying, and the total cost at the end was exactly the same. So why not? Instead of waiting for another year or two or I don't know, a few months to get the money, then I did it that way, so I had the car faster. So the whole idea is that you don't have to borrow in order to do stuff, but borrowing accelerates the process. A company that borrows the money will be able to engage in all this investment, and if it goes well, it's going to be way more profitable at the end of the year. What the financial analyst would help you to do in this case is to find the right balance
between how much money you're borrowing, how much you're repaying, and what is the sort of profit expectation that you've got. So if you're borrowing that money for to reinvest in the business, this is going to increase your profitability. It needs to increase it enough to allow you to repay the loan with the interest attached and leave you in a better position than you would have been if you were doing it organically or very slowly by saving the money. Because of course, if you are to borrow and then not make any additional profits, then it leaves you worse off. It could also happen that if the rate of interest is very high, then it will leave you worse off. So the rate at which you're borrowing is very important. It is linked, apart from the numbers, it is linked very crucially to the plan, to the business plan that you have. Because this is not based on vague assumptions that, oh, we're going to make a better website. So you need to think about how a better website would help you increase the client base and then have a projection as to how many more things you're going to sell, and then it makes sense. So that's how you can work it out. But it is complex, and this is not the job of the lawyer. This should be the job of the financial analysts or the accountants to do these projections for you, and then the lawyers will find the language to express this into the contract appropriately. Because also the way in which you repay will be important. A company can borrow money and then you could repay schedule that is monthly or annual or whatever. You could repay just the interest for a period and then repay the interest and the amount that you got. You could be repaying the amount and the interest from the beginning or the other way around. Think about a mortgage or something like this. There are multiple ways in which you can get money to buy a house, and then the repayments are structured in different ways according to your ability. So one thing to know is that the longer it takes for the repayments and the smaller if the amounts are smaller and they go on for longer, the interest and the overall cost is going to be higher. And actually these costs, if you look at mortgages for home, the total calculation is insane, right? Because you're borrowing the house that you're getting is say 500,000, 600,000 pounds. And if you look at the total cost of the product with all charges and all the interest included over the 25 years that you can have to repay, in the end the amount is over $1 million. So you end up paying double, but of course, I mean, it is very expensive, but it's still affordable, could be affordable for you because what you're interested in is the monthly repayments. You're not going to think, why am I buying something for 600 and then I'm repaying $1 million? You're going to think, I'm never going to be able to raise 600. So the only way to do it is this. Yeah. So similar stuff could happen. Okay, corporate loans for investment are not that expensive, of course, okay? But these are the sort of calculations that one will go through. And it's not only corporate, it's also the state, right? The state in its various expressions. I mean, the government, the central government, but also local authorities and municipalities and so on, they borrow. Yes, why would the state need to borrow money? It could be that they are planning some big infrastructure project, like a government could borrow money because they want to do something. So they've got a plan of government, it costs money. So they either give it as concession to companies to build and then operate and it works like that, or if they want to build it themselves, they will borrow the money, engage in the investment and then hope to repay it in the future somehow. But the crucial reason why governments borrow is not that, it's because they run a deficit. They just cannot keep going. So the majority of governments are running a budget deficit, which means that the amount that they bring in taxes and duties and tariffs and customs on a monthly basis are not enough to cover their expenditure. So this creates an ongoing need to borrow in order to be able to balance the books, which of course increases state debt that then needs to be serviced somehow. Even governments that have a balanced budget, they still need to borrow money because they're still paying off all their debts. So that's why you can have a primary surplus, as they say, that your balance is budget. So your budget is balanced. So whatever you take in from taxes and stuff is enough for you to make your payments. But if you calculate interest on former loans, you're in the red. So you need to borrow money to be able to make those repayments. So that's an ongoing thing, which is normal, okay? I mean, nobody There's no country in the world, and no kind of municipality in the world that doesn't need to borrow money for a variety of reasons. However, this creates a demand, and it's got all these people. You've got corporate entities, you've got state entities in national and local level that need to find the money. They're trying to borrow money all. There are other people, you can have international development banks, international institutions, aid institutions that also need to generate money or need to borrow it from somewhere in order to put it to use according to what they're now. How do you actually borrow that money? Now, this depends on who you are, really. A company can raise money in two ways. One of it is get loans from another institution, from a bank, or even if it is a bank, then from another banking institution. One idea is to get loans. Another idea is to sell shares. Right? So one of the primary methods in which companies get money is by selling to the public. Listed in a stock market. Normally you've got public companies listed in the stock market, all the banking institutions operate like that, and then you raise the money through the public and then you put it to use. So you can either issue shares or you can borrow money from somebody, but you can also issue debt. So you can sell debt. And the way this is done is that you create, it's a way to get loans from other people. You have a piece of paper that says, you give me the money now, I give you your money back in a year. So if you're making a savings investment in the form of a bond or a fixed term product, this is what happens, right? You lock your money. You give your money to the bank holds it for a period of time, then it returns it to you with interest. So this is another form of borrowing. This can be done by banks, but it can be done by corporates as well. Corporates very frequently issue debt. So you can go buy a bond from one of the auto manufacturers, you can buy it from wherever you want. So these are all mechanisms that you can actually get the money in. The states, they don't issue shares obviously, but they issue bonds, right? The treasury bills, as they call them in the States. Here you can buy, they're called national savings bonds, what are they called? But it's called national savings, and you can buy them at the post office. That's the main difference between private institutions like a company, for instance, and a state. A state will operate in the bond markets with various types of debt that they issue. A corporate has the capacity to both issue debt and to sell shares, so it's a bit more flexible, obviously. Now, shares themselves have got particular legal connotations, and there are some stuff that you can follow up as the courts have discussed the idea of a share and what it means as a property interest, and this is why you've got this case reference there in case you're interested. The thing about the share is that it's got both contract and property connotations. So the idea of a share transaction is both a creature in contract, but it's also a proprietary interest, and that has created a little bit of tension in the way that the law interprets it and what it means. It expresses itself in the occasional lawsuit. We had some interesting ones in emerging out of the financial crisis. For instance, Hank Greenberg. Hank was the boss of AIG, the insurance company. It spectacularly collapsed during the crisis in 2008. Right? It was one of the big collapses, at the time after Lehman Brothers, that financial institutions were dropping like flies. One of them that kind of went kaput was AIG, which had tremendous connotations because it was a very big financial institution in the US. It got bailed out by the government, but it got bailed out in takeover by the government. And then Hank, who is shameless, went and sued them, saying that the valuation of the shares, the amount of money that the government purchased those shares in order to save the company, right, to take it over, it was incorrect. So he was arguing that they got expropriated, which is really rich considering that the institution had collapsed, so they shouldn't be having any value at all. So instead of saying thank you for the government buying their shares at any price, he was complaining about the valuation. But this is one of these ways in which it's about the nature of shares and the understanding of shares from a legal point of view are emerging, and it's not just at the beginning of that process like 100 years ago. You've also got ongoing cases that bring these issues forward. All right, but let's think a little bit about the markets themselves. Why do you need a market? You can always transact on a bilateral basis. In fact, many of the transactions in the markets are on a bilateral basis. So why does it need to happen in a market? The important thing about a market is that it makes things easier. So themselves could be done on a bilateral basis outside an exchange of some description. The problem is, if transactions are taking place outside a market, they're not very transparent, so you don't know about the volume of trading, and you don't know about any stresses that are developing in the system. This has been demonstrated during the crisis. Again, things that were going through exchanges and markets, they were monitored. Things that were not, like over-the-counter derivatives, for instance, nobody knew about them. And when the system started experiencing stress, people could tell on the traded products where the problem was and how the prices were changing, but people could not anticipate how the derivative products that were not going through the exchange were going to behave. And it was the derivative products that blew up and caused massive liabilities that then the banks found themselves insolvent. One of the key issues of a marketplace is transparency of the transactions and security, but very crucially is the meeting place for sellers and buyers. You could do your shopping by going to individual providers, right? You could ride up to the farm and get some fruit, and you could ride up to the other guy and get some meat, and then you can ride up to somebody else and get some whatever. But if all of them come on a Saturday morning in the city square and they're all there, it makes your shopping a lot easier. Because what is important is that you've got multiple providers, that then you can compare prices between the multiple providers. So it's not only ease of access by having a variety of products and a variety of options from a variety of providers at the same place, the same systems, but also you've got a lot of people selling the same stuff, so then it helps with price competition. So the whole point about the market is that it makes it easier to transact, it makes it easier to discover prices, and it is easier for the buyers. So that you add the security elements, that if everything is more transparent, then it is more obvious when the risk is developing in the system in case something goes wrong. And in some exchanges guarantee the transactions. So they guarantee the passing of the money from one person to the other. So they ensure that there's enough liquidity in the market in order to be able to meet the trades. So this doesn't necessarily always happen, but certain types of markets also offer this capacity. But if you're thinking about forex markets, about currency exchanges, or you're thinking about stock markets, then it is very obvious how it works. Right? You've got a centralized system that will handle the transaction. So the money passes from you to the exchange, then from the buyer to the exchange, then to the seller. The product then makes its way across, so you run less risk of sending the money over and not getting the product in the end, or not purchasing. Everything is automated within secure systems, so all that makes life a lot easier. So there are significant advantages into having markets where all these things can happen. We can talk a little bit more about banks and what the banks are supposed to be doing. Now, we've got different types of banks. What is the main function of a bank? The main function of a bank is taking deposits and then making loans, right? Could we manage without banks? No, we cannot manage without banks. I mean, a modern economy cannot manage without banks. And not only that, it's an issue of credit availability and liquidity. And the crucial function of a bank is the fact that the bank creates money. The bank is not a simple depositor of money. It's not like a vault. This is the idea behind fractional reserve banking. You've got £10 in your pocket and you go deposit them in the bank. The bank loans, but the bank doesn't make loans just on the £10. It can make more. And what happens is that the bank has to navigate money and time. So the bank has to make these projections. It's taking money in, it's giving money out, but this is not happening simultaneously. It took the money from you now, so it's got it. It's giving the money to somebody else, but it's also receiving money from other people who are making back payments. So it's a dynamic system that's very complex. So what has happened very early on in the history of banking is that the banks started giving out more than they actually had. And this is perfectly normal, because this increases the money supply. But of course, this needs to be controlled, because after a point, it's not very safe. There are mechanisms that tell the banks how much money you need to keep as immediately accessible, right, in case somebody comes back and asks for the money. How much money do you need to have in general in a variety of investments, and then out of that money, how much can you make out as loans? And it is not a one-on-one. It's not like you need to have £1 in the vault in order to make £1 as a loan. It is multiples of that. And it's, if you allow more of it, so if they can make £10 in loans for every pound that they've got in the vault, then it increases the availability of money. Because it could be that you came in and we gave them £10. And 10 of us have gone there and they got a loan of £10 every day. So the money created in the system, starting from your £10, has then created £100 that's out there circulating. That is real money, right? Now, this is an essential component of credit availability and liquidity in the economy. It is essential in allowing the, as we described previously, to have access to that money so they can expand their business. This could not happen without the banks. There's a lot of discussion about these things because we don't understand them. And to be fair, these are not easy to understand. It's not like you kind of wake up one morning and you read a paragraph about how the banking system operates and you get it. I mean, I've been looking at that to understand what's going on. Now, it takes a while because the functions of a private banking system are very different from what the central bank can do. Yes, the central bank can create liquidity, but in the fact, well, I mean, they can print money, but there's a limitation to that because after a point it causes inflation. So there are ways in which you can create that the central bank, so a state mechanism, can create money and expand the money supply, but there are natural limitations to this. So the two systems work together. So on the one hand, you've got the central bank controlling the availability of liquidity in the market, and then you've got the private banking system that also generates liquidity and credit. So the different types of banks, you've got a part of the banking system that is focused on the consumer deal, which is the loans and the deposits, right? The places where you go, you've got your current account, you have perhaps a savings account, then you get a loan, buy a car, to buy a house, and all the rest of it. This is the kind of bread and butter of banking. Commercial banking is this on a larger scale, is where the companies get the money so they can finance their activities. It's a sort of situation that you go with your business plan and your projections and you ask the bank for a loan and then they help you proceed with what you do. Now, another side of this is the investment banking. So on the one hand, you've got your consumer and commercial banking, which are the people who deal with the real stuff, so this is like the real economy, things that are actually happening out there that have got a productive element to them or a productive purpose. However, all of that, one aspect of the economic landscape, the money and the management of the money itself. So this is not productive, not necessarily productive, right? So quite a lot of effort and quite a lot of the banking system is devoted to churning the money around and making sure that the money is invested in a variety of ways, but this will not always have a productive. So some of it is a little bit kind of virtual money if you want, but it's not something that you're going to see invested productively. If the main business of the bank is to buy government bonds, they could be making a good living out of this, or they buy government bonds, or they buy corporate bonds. This activity finances an economy further down the line, but the actual activity doesn't really do anything in the real world. But all of those are essential components of an economy. And the city, a good proportion of the work of the city, the bigger part of the work of the city, is playing the money. It's not so much the commercial banking aspect, that they were a center of global finance, and it's mostly that. It's a place where people get together in order to manage money. Now, investment banks, what the investment banks do, they advise other actors in the financial markets as to how to do this. So they've got the know-how, and they've got the experience, and they've got the technology to understand how these things work, so they help people do it effectively. So you want to bring your company in the stock market because you would like to raise money from the public. How are you going to do it? So there's a lot of paperwork, a lot of bureaucracy that you need to go through, and crucially, there's a lot of financial information that you need to go through. All in order to do this properly, then you need to hire an investment bank to help you through the process. How much are you going to sell your shares for? You have to think very, very carefully about the company you are, what people are willing to pay, how well you're perceived, how much money you're trying to raise, for which purpose you're raising it, and all the rest of it. So this is something that you cannot do on your own. If we're talking about a significant company with a significant valuation, then you need to go through an investment bank to help you do it. So this is what, all these really rich guys in really expensive suits and really big buildings with nice carpets, that's what they do. It looks that it's not particularly socially useful. However, what happens in there at the higher bits of finance is what makes the money go around and finances the rest of the economy. Now, the argument is that these people are getting paid too much. It depends how a society values things. So if a society thinks that the teacher at the school who takes care of the kids all day is worth 20,000, but the guy who sits and looks at the spreadsheet and presses buttons is worth 20 million a year, this is a societal decision. Okay? So we can argue about this if you want. We can talk about whether the compensation that is, and the fees and the costs of these services are actually socially useful or relevant, or maybe they should be structured in different ways. We can talk about that. But I think to take dissatisfaction about that and come to a conclusion that we don't need them, or that they're useless, or that they're dangerous and we should get rid of them, I think this is the wrong conclusion. So we can talk about the costs and the compensation that comes in financial services, but we still need them. I mean, our economy and modern economy cannot operate without them. You can pay, or if you think that other people are paid not adequately in relation to these guys who make so much, when you can pay the other people more. So we talked about the role of the investment banks, and this is called underwriting. Okay, so the process of helping somebody either enter a bond market or enter a stock market. This is described as underwriting. The problem with all of that is that all of this is a little dangerous, because there's so much money involved in such big proportions that when something goes wrong, it can have real negative consequences on the world around it. And there's a difference between valuations that could be fictional money and the actual problems that come when somebody goes bust. Tesla, right? Who thinks that Tesla is overvalued? Everybody. Share price goes down $100. So they say $6 billion has been wiped off the value of Tesla. And tomorrow Musk announces that he's shooting his boat up in space, and everybody's very impressed. So the share goes $100 again, everybody goes, 10 billion added to the price of the company. People read that stuff what is the conclusion? It means nothing. How is it possible that a company that was worth X today is worth Y tomorrow and is worth Z the next day? Nothing has actually happened. They didn't discover anything. They didn't do anything. They are continuing business as usual. It's just perception, right? Trump says, I'm having a bad day, I'm going to put tariffs on somebody, everybody panics, and the stock markets fall, so X amount of billions wiped off the valuations. What is that? This doesn't mean anything, right? So these valuations in the stock market are, so long as they're not transacted on, they are perceptions of value. They're not real value. Real value means when you actually sell the shares and the money reaches your bank account, then is the real money. Okay? So the fact that the price it fluctuates wildly on a small number of transactions. Yeah. So the shares don't change hands, so the money is not exchanged, so nothing really happens. Nobody becomes rich or poor. If a bank goes bust and you go to the ATM and nothing comes out, this has real consequences. But one can infect the other, you see. Because when people panicked in 2008 and all the grandparents were queuing at Northern Rock because the bank shut, that was a problem. Okay? When in Greece they imposed capital controls, so 3 o'clock in the morning everybody was queuing at the ATM to get out as much cash as they could. This is not good. This can create real life issues. Yeah. So if the people who had their money in Icelandic savings accounts when the banks collapsed and then it took them years to get it back, and they were lucky because they could have lost it all, that's real consequences. It's your life savings. This ain't funny. I mean, we look at it from a distance because we assume that our money is safe. If they told you that your money isn't safe and your bank might shut tomorrow and you spend a lifetime putting 30,000 away and poof, it's gone, that's not funny. You would go out and try and smash something. The state has an obligation to create some barriers. So these processes that are so essential to the economy are actually maintained in the safe. Because we want the banking system and the financial system to be there to support the economy, but we don't want it to come off the rails, so then it causes significant issues. And how do we know that the whole thing can go? That's how we know, because this is what happened in the 30s. This wasn't good at all. So in 29 they had the stock market crash. After that they had a banking crisis. After that everything just collapsed. And one of the arguments there is that the consequences of the financial collapse were what led to the war afterwards. That the dislocation created by the collapse of the financial system at the end of the 1920s then created a dynamic that fueled this aggression and dissatisfaction that led aggressive regimes to take power and then implement aggressive agendas like the fascist. That's what happens. Things go seriously bad, people are seriously dislocated, they're seriously frustrated. In Europe, there was also the legacy of the First World War and other unresolved problems from there, and you end up in these situations. So the obvious conclusion to draw from this is that the state has an obligation to ensure that big-time financial collapses do not happen on a regular basis, because this is hugely disruptive. Not to themselves, okay? The politicians and the bankers and the financiers, they always manage to come out of it okay, but it's disruptive for everybody else. One of the things identified at the time was the danger from a problem on one part of the system traveling and infecting other aspects of the system. So you've got your more dynamic financial markets on the investment banking side, and then you've got your kind of more normal consumer commercial focus. The concern is that people in the investment side, if they do things that are too risky, they shouldn't actually infect the other bits that are supposed to be stable. So there's one issue, making wrong investment decisions in stock markets, in bonds and stuff like that, and kind of the fund manager who sits there playing with the spreadsheets loses some money and gets fired. There's a difference between this and actually losing all the money that people have put down as savings and all the money that's supposed to be their working capital for everyday business. That is bad. And one of the things that happened in the 20s and the 30s is that there was no distinct barrier between investment side, the more risky bits of finance, and the everyday run-of-the-mill high street banking. So one of the solutions that was envisaged at the time was the creation of the separation between investment banking and commercial banking, which was expressed in the Glass-Steagall Act in 1933. But of course, this is not. Glass-Steagall is famous. However, it was only one component in a large array of measures that attempted to make banking and finance more secure for the long term. So what happened is that you had this distinction between different parts of the banking system, not to allow speculation to lose the money that was needed for everyday activity, and generally to reduce the size of the financial industry, reduce the dynamism of the financial industry in order to make it safer and less prone to trouble. So this worked. This was implemented in the early 30s. This worked in stabilizing the situation for a very long time. I'm not talking about the economy in general and growth. I'm talking specifically about finance, because what really stabilized the economy was the war. Because then, there was an emphasis on productive activity in order to respond to the needs of the war. But after that, from the 1950s onwards, banking was a relatively controlled business. There were the occasional collapses and crises and so on, but nothing of a systemic nature. Now, after a few decades pass, people started to view all these regulations and restrictions as artificial impediments to making a profit. And because there have been so much time since the crisis, people lost memory of the crisis. And the people engaged in the industry, they were looking all the time thinking, why do we have all these rules? It just prevents us from making money. We're jumping through hoops for absolutely no reason. Because these guys were already rich and quite powerful and quite effective in lobbying. They lobby the governments. The governments like to take money from people so then they can spend it elected. So there was a gradual process of kind of lifting all those restrictions that had been placed. So in the 1980s onwards, you begin taking out those restrictions. And this accelerated in the 90s, the whole idea behind kind of liberalized markets on a variety of fields, including in financial services. So this kept going on and on and on and on, until you had the abolition of all of that stuff, and then you started having some crises. So you had significant instances of collapses in the stock markets at the end of the 90s, in 99, the dot-com bubble and all of that. You had significant imbalances in financial markets. This was not necessarily taken care of, because the deregulatory effort that led all these stresses to develop in the system, it was not adequately addressed, even though they had enough warning signs. But because so many people were making so much money, it was all so cool, and things were progressing well for so long, people didn't see the need of kind of putting the brakes on it till the stresses in the system built up and the whole damn thing collapsed in 2008. Now, what happened after that? People rediscovered the need for some regulation and some brakes and so on in the financial markets. Again, the aim is not to shut them down. The aim is to make some of the riskier aspects of the market more controllable, so they don't cause crises that kind of cross from one part to the other. A good component of all this is the role of the central banks. The central banks attained a much more significant regulatory role over financial markets and financial stability. And what has happened since the crisis in 2008 is that now we've got mechanisms that are focused on systemic stability. Before, we had compartmentalized regulators over different fields that were focused on their particular area of activity, but nobody really was looking at stresses developing across the system and how the different parts of the economy and different parts of finance were infecting each other, causing the capacity for some big time collapse. So now we've got this, primarily the regulatory effort is on the central banks to keep an eye on systemic risks, and the economy ministries of various countries. They work together. Plus, you've got a lot more thorough regulations on things, some of which are here, MiFID, the regulations on financial instruments and so on, and the directives are significant components at EU level of achieving uniform regulation over the financial system in order to dispel those risks to the extent possible. Now, people in the industry hate all that stuff because it is bureaucracy, they say, because it doesn't really change anything. I mean, I've heard this argument a number of times that the paperwork now that is involved in everything and all the licenses and all the things, they're actually looking at the wrong stuff and they're not going to make anything any safer. Fine, but you know, we saw what happened when you didn't have any of those, so you know, let's try something else. They primarily don't like it because they increase the costs. Because before, when you were issuing financial products, there was this tick, now you need the prospectus that is this tick, meaning that you need to employ an army of lawyers for a very long time, and this costs a lot of money. That's why you see so many happy finance lawyers working around, yeah? Because coping with the regulatory requirement now is a very significant, time-consuming, very expensive process. But the hope is that this makes things more secure overall. Now, our friends here in London, those who are not on the commercial consumer side, those who are working the money markets and all of that stuff, because they think that all this is a waste of time, they see a great opportunity in Brexit in allowing Britain to deregulate. The thing is that if they're not covered by the European rules anymore, they can do away with all this bureaucracy and they can become a global center that is more lax, like they used to be, that the money can pass through here and they can do nice deals and stuff like that with much significantly reduced in comparison to the European counterparts that still have to deal with it. It's fine, okay? That I understand. If you're a hedge funder, there are advantages in being able to do this, and you would lobby the government in that direction. So you can build a competitive edge by having lower regulatory burdens and having lower taxes. It's fine, okay? But of course, there aren't that many of those guys, and those guys are already rich. So the question for the government is, why would the government prioritize the interests of a very small number of people on a section of the industry, not even the entire industry? Why go for that as opposed to the interests of the rest of the nation that are completely antithetical to this? Because the consequence of doing this, deregulation and lower taxation, is with Europe on a number of other fields, which is going to have catastrophic consequences on a range of other factors in the economy, including a good section of the banking industry itself. I'm not talking about why people vote for Brexit. I mean, that's something else. I'm talking about why do the sort of industry leaders and the people with the money and the people with the access to the government, why are they not more against it? From the point of view of your studies, what is relevant for you is the EU regulatory framework, either because you're from there or because there's going to be some transition, so this is going to stay till after you've graduated, or simply because from wherever you are in the developing world, you have to do business with Europe, and Europe has to do business on those terms. So this is not going away. If anything, this is going to get tougher. And actually, I'm not a believer that they're going to be able to deregulate here. Reducing the regulatory burden is one thing, but then it means you won't be able to do business with most of the other jurisdictions that actually have higher requirements. So you're going to need to, you just simply won't be allowed. It's going to create barriers in the flow of the money, so it's going to be detrimental here. I mean, you cannot, the Cayman Islands is like 5 people in there, okay? You cannot do this. A big economy cannot be supported just on the activity generated through these types of funds. Everybody who needs to do business with the Americans or the Europeans is still going to have to apply higher standards. So that in itself is not is not sufficient, the volume is not sufficient. Dropping taxes is just not possible because the financial industry here in the City of London is the key contributor to the budget. If they drop taxes significantly, they're going to run out of money at a time that it's going to be more expensive for them to borrow. So it's just the finances don't work for the state for them to deregulate and drop taxation very sharply. You know, supposedly people here are unhappy with austerity. Wait to see what happens if they lose money from the taxation from the city. So today we have the opportunity to talk about the bank-customer relationship in a little bit more detail. So you had all the kind of big theory things about how the regulatory system for banking and finance hangs together in national and international domains, and now you're having a bit more detailed information about practical things, including, you know, what actually means to be a customer of a bank and what is your relationship with the bank in that respect, that we will do today. And then we talk about payment systems, we talk about certain financial products in a bit more detail, and so on and so forth. So today we're going to talk about how do you figure out if you're a bank customer and what that means, the relationship between you and the bank, the duties that you have towards the bank and the duties that the bank has towards you, what happens when things kind of break down in some fashion, and if we got the time or the inclination, we can talk a little bit about fairness in the idea of a banking contract, and is there an obligation that they're fair, or how do we judge that they're fair? What is a bank? You will remember that we had seen a little bit of a discussion about Lord Denning in United Dominions and Kirkwood, that he was trying to come up with a definition of what is a bank, and he found that relatively difficult because banks do a variety of things. Not only now obviously they do a variety of things, but they already did a variety of things in the early 60s and mid 60s that this case is coming from. So Denning was attempting to identify certain key characteristics of a bank, of a banking activity, but also a banker. What are the characteristics of a banker? Wow. Soundness, stability, probity, somebody who maintains a good reputation for the company, the ability to deal as an intelligent commercial person. So all this idea that the banker is somebody that you entrust with your money and is a person of ethical standards and appropriate commercial ethics and behavior. This is what you would want it to be. You don't, the characteristic of a banker is not the kind of random fraudster, but after what happened in the financial crisis and everything that's been going on since, and the various prosecutions left and right for these people doing dodgy stuff, it really sounds funny to describe the banker as somebody character, soundness, stability, and probity. Of course, we would want them to be that way, and the law should imply a standard like this. What is it that the bank is supposed to do? The key function of the bank, as we have seen in the past, is the idea that it collects deposits and then makes loans. So the core of the banking business, the core of the banking is this taking of money and then making it available. And the core characteristics of the banker, these kind of rather ethically or morally linked as to their behavior. It's been present in the law for a very long time that you cannot carry the title of a banking institution or of a bank unless you have passed through a process of authorization by somebody else. So the very title, the functions that come with bank are subject to authorization from the relevant national authorities, and it's not something that you can set up on your own. So you can choose to call yourself a variety of things, but you certainly cannot call your business a banking business unless you have specific authorizations. And if you're caught engaging in the business of banking in the way that it's defined now in the various instruments without having obtained these authorizations, then you get into a lot of trouble. I don't know, is PayPal banking? Are payments facilitators? banking businesses. I mean, this is something that exists now, so it's something that gets fed into the regulatory system and the definitions of these things. You did not have this type of payments facilitators that were working independently in the past, right? But you do have them now because online transactions allow you to do this. So that the types of services that banks provide today, apart from deposit taking and lending, have to do with a lot of things that do facilitate the transactional aspect. So they do a very significant provision in allowing you to use means of payment. So all this business about debit cards, credit cards, and so on, now it is as significant a part of the banking business as the traditional idea of taking deposits and then making out the loans. And also, the banks now are providers of financial advice and a variety of financial products in a variety of marketplaces, including insurance products and things like this. Who would be considered a customer, right? We have a bit of an expanding definition here of who comes in contact with traditional banks and in addition the more modern types of activity in financial markets, so that opportunity to discover who do we consider to be their customer and what are the sort of obligations that are built around this. If you are engaged in what is known as a regulated activity, the regulated activity of accepting deposits, for instance, then you need to comply with certain standards. Now, these standards were industry created and industry based traditionally, but after the financial crisis, there was concern as to how these types of self-regulation are sufficiently robust. So now they have become more integrated into as well. So now we've got what we call a banking and payments conduct regime. This grew out of things like the banking code. You used to have the banking code before the crisis that set out the duties of the bank and the expectations that the customer can have out of a regulated banking activity. So this grew up from the banking code that was run by a banking code standards board. It grew up to the banking and payments conduct regime that is now regulated by the Financial Conduct Authority, right? The Financial Conduct Authority, the previous regime. And all of these things are meant to give information both to the banks as to how they're meant to conduct themselves and deal with the customers, and also to tell the customers what to expect in a way that complies with the regulatory framework, things like payment services regulations, payment services directive. There's a lot of European community law that comes into this thing that informs the nature of this relationship. And under the payment services directive, you've got the Financial Conduct Authority that is responsible for all of these rules and passing them down into the banking system and then checking how the banks are actually operating. So they flow down the requirements, and then they also have a monitoring role as to how the banks are responding to all of this. And you have now something that is called the Banking Conduct Business Source Book. This is the entire this regulates the entire regime of deposit taking, and it comprises of a source book for the banking system, principles of business that are created by the FCA, conduct of business requirements, and specific information about how to electronic money transactions. And this is a source book that applies to everybody that is involved in the traditional banking activity of accepting deposits from banking customers in the UK. Now, these are EU regulations, but they are, of course, implemented at national level, and they're checked by the national regulator. A banking customer is a consumer or a small enterprise or a charity that has an annual income of less than 1 million. These rules that I said, the banking conduct of business source book applies to dealings with consumers. Why is there an emphasis on consumers? because businesses can take care of themselves. The assumption is that that's why there's a micro enterprise will be considered a consumer. Because if I'm on my own or with a couple of other people and we've got a private limited company and we go to the bank to open a bank account, this might be a business bank account for our shop, but in fact we don't know any better than what we know for our personal banking. So a small business that doesn't really have any support behind it will operate in the same way as a traditional consumer. So all these regulations and the directives, they take the same view of a private individual for the private banking and a small banking. And also charities that have a low turnover, again, they don't have the know-how or the legal and accountancy support behind them to do more complicated things. All of these things are to protect the consumer. Why do we not need the protection for the businesses? Because the businesses, if they're bigger, they got lawyers, they got accountants. If they're bigger, they got lawyers, they got accountants, they got financial advisors, they get different types of products that are also coming with a lot more information or different types of information from the banks. So they're in a different position to make up their minds and they don't need this foregrounded protection controlled by the argument to be had as to whether there is such a thing as a sophisticated counterparty, because we have found in the financial crisis that a lot of people who supposedly knew what they were doing, they didn't know what they were doing and they lost a lot of money. So there's a kind of stream of the literature that says that nobody really understands what's going on and the distinction between consumers who don't know and don't care and they cannot be well informed, therefore they need to be protected, as opposed to businesses that do know and they have the interest, is really a false distinction. Because the losses in the financial crisis prove that even the top people that had to figure out and to know, they didn't do the due diligence, they didn't understand what they were doing, which led to massive losses. So if you take this view that there isn't really such a thing as a sophisticated counterparty, then this would lead to an expansion of the protective regulatory framework to everybody beyond consumers. But of course, this is not what's happening at the moment. At the moment, we maintain this distinction between customers, a retail sense, who don't know what they're doing, and businesses who do know what they're doing. It might be a fiction, but it's the basis on which the regulatory system is split. Perhaps the task would be too large or it would be too restrictive if you were trying to adopt the same kind of paternalistic protection standard, standards to businesses as you apply to consumers. But, this is something to debate for the future. So these rules, as I said, they protect, for the time being, consumers, micro enterprises, and charities. They deal primarily with the core business activity, and they also, which is a big problem, because there's the assumption that things that are done face-to-face, physically, the consumer has got the opportunity to understand better the product, but the things that are done on the phone or online, you've got much less opportunity to discover, and there's much more emphasis in you discovering on your own what's happening, which then means that there should be more protection. There is all these instruments. The source book contains guidance on how to communicate with banking customers, how to communicate financial promotions, how do you stay on top of the requirements of the distance marketing directive and e-commerce directive, the information customers, if you're a bank, what counts as appropriate information and what sort of statements of account you need to send them. How you can run a prompt, efficient, and fair service, what happens if accounts are moving, what happens if something goes wrong at some point, what happens if accounts have been lost or are dormant, and how do you need to communicate with people in those cases. What happens if you got unauthorized or incorrectly executed payment? You protect the customer in that case. What do you deal with cancellation, the right to cancel, and the effects of that cancellation? So all of these are contained within the source book, and this is the real stuff that's all the time. And there's a lot of as a consumer as a result, because if they don't do that stuff, then you would complain internally with the bank if you think that they've done something wrong. When you finish an internal process of complaint, then you have access to the ombudsman, the financial services ombudsman, when you go and complain about it. For everything that doesn't go right, then you should go and complain. But what I'm trying to say is, these things are there for a reason. Mistakes will happen, either because you're dealing with somebody who's not nice. Maybe they're not nice and they're just trying to scam people and they don't do their jobs properly, or it is a genuine error. These things, the framework as to how you should deal with these things, and then you should make use of all the tools that you've got available. And in the end, remember this, if the amounts are low, they will always give you what you're asking for, because the more it escalates, the more it increases the costs for them. Because if the ombudsman comes against them, then you're going to take them to court and they're going to have to instruct a lawyer. They instruct a lawyer, they're going to pay £400 an hour. So is it really worth, once you brought it all the way up to the ombudsman, to run the risk of losing and then having to go through all that expense, or giving you what you're asking for? Now, of course, if your claim runs in the thousands and they really think that they have done nothing wrong, then they will pursue it. But 99% settles, even for things that have got no merit. At least my cases all had merit because they had done something wrong. The matter was the calculation, whether they accept my calculation or not. Other cases that I'm aware of, people have got no merit whatsoever. They just harass them, and they will always settle. But you wouldn't be able to do all this if you didn't have the system there in place to give you those tools as a consumer. The vast majority of businesses will rely on the fact that you just can't be bothered, or you don't know about any of these things, so they will just wait. Processes take 2-3 months. Because I make a complaint to my travel insurance. They say, yeah, it's gonna take 40 working days. 40, it can take 400 working days. I'm not going anywhere. Okay? But normally most people will lose interest. By the time or they will have forgotten about it or lost the evidence by the time the response comes. Yeah? Okay, so we've got all these things here. And then we've got the FCA's principles for business, as I said, and these escalate from the consumer to the business, because they're not all these standards and all these expectations of behavior. They're stricter for consumers, but they also reflect on behavior towards businesses. So I don't want to give the impression that the business-to-business side contract is completely uncontrolled and they can do whatever they want. No, there's a reflection of these standards, but with the understanding that businesses are in a better capacity to make their own deals. And then you got the electronic money regulations, which is very significant, because it has to deal with all the payment services and all of that stuff that we're going to see in our next classes. Now, let's go to the relationship between the bank and the customer. Now, the basis, if you needed to locate what is the basis of the relationship? The relationship is effectively a contractual one. Okay, I mean, you are a customer of the bank because you have signed a contract with the bank to arrange certain services to be provided to you. So if you see the decisions in early cases about this, like the Swiss Bank Corporation case, 1921, then the court saw the banker-customer relationship as a single contract. Okay. On the other hand, one of the other judges in there saw it as a relationship of creditor and debtor, not necessarily a contractual one, but as a relationship of creditor and debtor, then it goes beyond what you have in a contract. Now, what is the difference? The difference is that if you view it simply as contractual, limited. The contract says what it says, and then it is a matter of interpreting the provisions of the contract, interpreting the intention of the parties. However, if you focus more on the debtor-creditor relationship, then a lot of additional requirements come from the law of equity and from the law of trusts. So then it becomes a relationship that is uneven, where the customer is reliant upon the bank and the law implies way more things in order to protect the customer and to make this relationship operational, because it is always assumed on the debtor, obviously. Yeah. So we've got this interplay between understanding this as purely contractual or taking the equity trust law implications of this relationship. The modern interpretation of the rules brings the two together. The beginning of your relationship is contractual, but not everything that's meant to happen and will happen is contained within the contract itself. Both because a lot of things are implied into the contract by operation of law through the common law and all the understanding that we've got of the equitable dynamics and also all the regulatory assumptions and implications that are coming in through modern legislation. Are you guys familiar with the distinction, the key distinction between law and equity in English law? So these used to be different systems of law that were operating in parallel. So you have courts of law that were dealing with the traditional common law as developed by the courts, and then you had the courts of equity that were run by the king, where the king had discretion to overturn the decisions of the common law courts in order to achieve more fair outcomes. Because it was recognized that a strict application of the rules sometimes led to unfair outcomes, and it was within the discretion of the crown to lead to different results. So eventually, this led to an entire body of jurisprudence that created its own legal system. So, and you had these working in parallel. You had the courts of law came together at some point in the late 19th century, and from that point onwards, the courts look at both streams of jurisprudence to reach outcomes that are consistent, but also outcomes that are fair. That's why we now talk about, the contract bits are the agreement bits that are the traditional domain of the common law, but also impressions as to fairness, power dynamics, inequality of power relationships, and all of that stuff are helping us understand the contract and interpret it. But these are coming from the equitable bit that had to do with fairness in contracting, not only in contracting but also in the outcomes. Specifying, therefore, what are the duties of the bank. All of you, I imagine, have bank accounts, or you have lots of cash stuffed in your pockets. Now, what are the key obligations of the bank? They've got 4 main duties. It is to comply with the customer's instructions for operating the account. So if you tell them to move money, they're obligated to move the money. To comply with, so if you told them to make a payment before and you change your mind before the payment has taken place, then they're obligated to stop it. So if you want to stop a direct debit, you want to stop a standing order, you want to stop a check that's already been issued, they're obligated to stop this for you. They're meant to exercise reasonable care and skill in operating your account according to your instructions, and they're also obligated to treat the customer's information as confidential. These are the key duties of the bank, and they're specified by looking at the customer's mandate is this obligation to respect the customer's wishes as to what they want to do with the account, and the majority of case law on this has to do with checks, because obviously, all this case law is a bit old, and up till, the mid-2000s, checks were the primary way in which people made payments in and out of accounts. Yeah? So the basic obligation of the bank is to honor a check on presentation. And once they've honored the check, then they take the money out of the customer's account. They're only obligated to honor the payment instruction if there are sufficient funds in the customer's account, or whether the check is guaranteed by some other means. Back in the day, they used to issue you debit cards that said it's a check guarantee card, meaning that if you put the number of the debit card at the back of your check, then the bank will pay out up to the amount that the check guarantee card was good for, usually was £100. So the bank was accepting to honor that check regardless of whether you got money in the account, because you put the debit card number at the back. Yeah. So within those requirements, so either if the check is not guaranteed by something, they will pay it if there is money in your account, if there's available balance. or they will pay it if you've provided some sort of guarantee. It's not up to them to second guess your check. So you write a check to, sex store, and the bank manager receives the check and they go, oh man, Yanis has been to the sex store again. This is really not proper. I don't think we're gonna pay this, right? They don't have the right to do this. So nobody asks them what they think about your transactions. They are under a strict mandate to honor the payment of the check if you've got sufficient money in your account. If they fail to do so, then you got an action against them for breach of contract and what? Defamation. Yes, because if a check bounces, then it affects your business reputation. Next time I walk into the sex shop, they're gonna go, oh, that's the guy that gives us the dodgy checks. Don't give him any of the stuff, right? So it can have very severe consequences. So your responses are breach of contract, to claim back whatever losses you've suffered out of the transaction not working, and an action in defamation. Now the losses could be significant. If you're putting down a deposit for a house, for instance, and the check bounces, then you lose the property, you might lose money. I mean, you have invested quite a lot of money and effort in doing this. If you're at the estate agents and you need to put down a deposit and the check bounces, then you don't get the place, then you don't have anywhere to stay. You need to stay in a hotel for an extra couple of weeks. This is like a significant expense for you. So a claim for breach of contract means that you're going to seek to recoup whatever losses that you got arising out of the bank's action, not illegitimately, not to honor the check that you had money when you had money in your account. Now, also, same stuff goes about the countermand, which is your ability to stop a check that you've issued. So you've issued and you hear on the news that morning that the chain of sex shops where you sent the thing has gone into administration. You think, shit! Because if they get the check, then it goes into the administration liquidation process. I'm never going to get my stuff, and then I'm probably never going to get the money as well. So quickly we got to cancel it. Or probably never going to get the money as well. So quickly we got to cancel it. Or you recognize that you've been scammed. Or you change your mind, right? And then you want to battle it out with the shop that was going to get the check, as opposed to the bank. Okay? But the bank, again, they shouldn't. Before the check has been paid, you got the right, or whatever any payment has been authorized, you got the right to stop it before it's actually paid. Now, within all of this, the banker has a duty of care. Now, this is a wide-ranging obligation to exercise reasonable care and skill in carrying out the part of the contract that belongs to the bank. And this extends over the whole range of banking business, not just paying the checks, but we usually talk about payments of checks because it's the most easy example from the case law. It is implied both at common law and through statute. For instance, we had the Supply of Goods and Services Act of 1982 that implied a duty of care and skill in the provision of services in Section 13. Now, you can still use this, but it is also reflected in the Consumer Rights Act. So any service provider, what is it that prevents me coming in here and talking about the weather? Duty to exercise reasonable care and skill stems from primarily this obligation on all service providers. But we've got a very specific interpretation of this, because the duty to exercise reasonable care and skill could conflict with the duty to comply with the customer's mandate. So if the bank thinks that the customer is getting scammed, should they say that they're not going to honor the transaction because they have a duty to run their business properly and not to facilitate fraud on the customer and so on? Or should they respect the customer's mandate, no questions asked? That's why this has become a problem. Now, the courts had the chance to discuss exactly how this works out in cases like Lipkin Gorman. Is that he had a firm of solicitors and the firm of solicitors was allowed to write checks on behalf of a client. So they had the right to operate the customer's account. Now, slight problem is that one of the lawyers in there had a bit of a gambling problem. So he started writing checks in order to finance his gambling habit. Now, they bring action against the bank. Why against the bank? Because the bank's the one with the money. You don't have any money anyway, so you want to sue somebody that can actually afford to compensate you. So they come after the bank, and the question is, the argument is that the bank failed to fulfill its duty because it was aware that there was something dodgy going on. Now, what the courts will do is look at the circumstances of the case, look at the acts complained of, and ask whether in the circumstances a reasonable banker, knowing this information, would have been put on note that there's something going wrong with the customer's instructions. And if the banker is put on notice, then they have a positive obligation not to carry out the transaction, but to communicate with the customer to verify. So the banker cannot hide if it looks like there's something dodgy going on that they have become aware of. The banker is under an obligation to communicate with the customer not to authorize the transactions. If they do authorize the transactions, then it becomes a problem for the bank. A variety of ways. This is, apart from other types of legislation, this is why the bank will call you if they think that there's been actions on your account that don't look right. So if suddenly there are transactions on your debit card here and in South Korea, and you have a coffee at Starbucks in London in the morning, and then in the afternoon you got the purchase of a computer in Korea, and then you got a TFL charge in London, and then another charge in Korea, then the bank is put on notice that there's something weird going on with your account because you cannot simultaneously be here and in Korea. Sure that the transactions are right. Sometimes this leads to errors, right? Sometimes they will block your card because you've traveled abroad and they just think, oh, there's something weird going on, and then you find yourself with a card that you're not able to operate abroad, and that can be a bit of a hassle. That's why you should have multiple cards when you're going abroad. Sometimes they're just stupid. I sent some money from one bank account to another bank account. Okay? The name is the same because they're both my bank accounts. The money never makes it to the other bank account. Nobody calls me. I call the bank when I realize a week after and say, what the hell happened? I sent £200. It's like, oh yeah, the transaction was flagged as suspicious. So instead of telling you anything or returning the money that it came from, we put it in a secure account. Yes, because it was a small amount, so maybe I would not have noticed, right? And what would happen afterwards? Like the money would come back. But if that money, you know what the problem is? If that money was meant for a payment, because I moved that money for that account, because I used the debit card on that account to pay for something, then if the transaction didn't go through, then I probably would have lost or incurred additional expenses. Then, who would I sue? Well, that's a bit tricky, because they did not comply with my mandate. The receiving bank is going to say we were put on notice of a suspicious transaction, but then they didn't follow through. So I think they breached their duty of care and skill by not communicating with me to ask me what's going on. So what they should have done is return the money or communicate with me. Keeping the money and not saying anything is a violation of their duty. Yeah? But it will become tricky as to who do you go after. You go after the bank that sent it or the bank that received it, and exactly what are the circumstances and what are they going to say. And for them to say that we're put on notice of a suspicious transaction, therefore we don't do anything, that's a problem.
Now, crucially, we also got the banker's duty of confidentiality. In addition to saying that you have an action for defamation against them if they don't respect the customer's mandate, and your checks are bouncing or your card gets declined, and that can cause, this can have effects on your business reputation. Apart from being embarrassing at Tesco's, okay, you try to buy like a cake and the card doesn't work. That ever happened to you? Most of the time it happens because the bank's system is down and then they cannot process. We had a problem with NatWest bank cards and petrol stations. For some reason, the petrol stations wouldn't take, it was which brand, like one particular brand of oil company. The petrol stations could not process the NatWest debit cards. So you fill in, you're going to pay, the card doesn't work. What do you do? You cannot take the fuel out of the car. They won't let you leave because you haven't paid. Yeah. But anyway, for that, so they have a duty of, in addition to you being able to sue them for defamation if they don't respect the mandate, there is a duty of confidentiality. Now, this is very important. The bank is not allowed to say anything about your account, your status with the bank, anything to a third party without your explicit consent. That's why every time that you need to be credit checked, when you're applying for something new, they ask for explicit consent that they're allowed to ask questions about you to appropriate authorities and so on, so they can credit check. The only exceptions that you've got to this are, and this comes from the case of Tournier here, the exceptions are where disclosure is under compulsion by law, so they communicate information to the revenue or to the authorities as they're checking for kind of transactions, money laundering and all of that stuff, where there is a duty to the public to disclose, but that again is subject to specific requirements, where the interests of the bank require disclosure. That is subject to discussion, but it has to do again with them fulfilling the regulatory requirements, or where the disclosure is made by the express or implied consent of the customer, which when, for instance, you accept to be credit checked and then you tell them that they can ask the banks for some basic information about your credit worth. Yeah, an example of how a bank will breach its duty. You call the bank and you say, I've got some checks in my name from this guy who is a business that is registered with your branch. Are you open at 3 o'clock so I can come and cash in those checks? And the person on the phone says, yeah, sure, but in any case, there's no hurry because these guys, their checks are bouncing left and right, so you try and cash them in, you're likely not to get anything. That is a breach of the banker's duty of confidentiality. Okay? You're not allowed to say anything unless you fall within these specific categories that you've got anything about somebody's business transactions, availability of funds, and all that. Now, do you have any duties as a customer? Well, you do have some. The key duty on you is to exercise the reasonable care and skill when executing written orders, for example, when writing checks, for instance, so as not to mislead the bank by your instruction being ambiguous or facilitate fraud or forgery. So when you're writing a check, there's a way that you write a check. You don't put 1 at the beginning of the line, and then you write 1 handwritten underneath, and then you put 1 in the box at the beginning of the box, because somebody else could come in and fill in the zeros. So the 1 has become 1,000 or 1 million. And also your instructions are meant to be specific. Now, there's less opportunity for you to make mistakes here with online banking, because if you don't input the information the way that it's meant to be there, then it won't work and you won't be able to complete the transaction. But if you're trying to send money to a friend of yours because it's their birthday, and you type in the account information wrong and the money goes to the wrong person, then that is your fault. I mean, there will still be a way to retrieve the money, because most likely you've sent it to an account that doesn't exist and it's going to bounce back. But if you're unlucky and you actually hit an account that does exist, then the bank could generally say, well, I'm sorry, but you put in the wrong number. What do you want us to do? Yeah. Or if you're the bank's not going to be able to help you. In exactly the same way that if you call the bank about an unauthorized transaction, they will say, if this is somebody you've done business before, you need to contact them first before you raise an issue with us. So if somebody that you don't know, that you've never done business with you before, puts a charge in your account, then they will assume fraud and block it. They will not complete the transaction, the money stays with you. But if it's somebody, you have given them your credit card or your debit card details because you've done business in the past, or you have a direct debit and they draw the direct debit by mistake, then it's for you to sort it out with them. So it happens with me all the time. All the direct debits that you forgot to, but you've stopped, and they charge by mistake like for another year, even though you told them not to, then you have to convince them to send you back the money. The bank's not going to help you. Or if you make a mistaken order someplace, but you were the one transacting, right? Again, you have to deal with them. So, but you have to be careful with your instructions. If your instructions are unclear, or your instructions are a mistake, or your instructions could facilitate fraud, then you are in violation of your duty towards the bank, and the consequence is that you might suffer the loss that is associated. Now, so that's your key duty, to exercise reasonable care and skill in executing orders. You have another duty to notify the bank of a forged payment as soon as you become aware of it, right? Now, this is more significant now, because now we have better access to our banking stuff, because before online banking and the online and so on, if you were receiving your statements quarterly, you would probably find out months afterwards if something went wrong in your account. But now you have better means of figuring this out. I'm not saying that this is overtly restrictive on the customer. You just need to you need to act once you figure something out. It could be that you figure something out later on because you cannot check your online banking once a month or something at the end of the month, but as soon as you find out, you need to tell them. You cannot figure out that somebody has charged you something, then not say anything for 6 months, and then call the bank and say, oh, that transaction actually now I don't remember having spent £600 at, Covent Garden sex shop. All right, so you need to tell them. The bank is not going to be that difficult, but technically this is still an obligation of yours that you need to fulfill. So basically that's what you need to do, right? Your duty is to take care with your transactions, and the duty is to notify the bank once you notice something going wrong. So you're more limited. The obligations, or you are certainly more limited than the obligations that are the other way around. And we're talking about protections on the retail setting, right? The customers, and that's why the protections are so tight. Now, perhaps the last thing to think about. What do we mean by fairness in banking contracts? You have the general provisions in the law that are all about making sure that the person knows what sort of deal they're getting into. So you have things that were coming from the Unfair Contract Terms Act and the Unfair Terms in Consumer Contracts Regulations. Now, the Unfair Contract Terms Act from 1977 is still in force. The regulations are not, because the regulations have become part of the Consumer Rights Act of 2016. But the information in the Consumer Rights Act is the same as it was in the regulations. So if you're looking at your books and it talks about the regulations, it's the same stuff. Now, there are certain obligations there that primarily have to do with the expectations of the customer.
So fairness in banking contracts means that you're provided with accurate information at the beginning, and there are certain things that the bank is not allowed to do. Key thing is exclusions. So when it comes to exclusions of liability for certain things happening, these are rather tightly controlled. These are not just for banking contracts, these apply generally for all contracts. Meaning you cannot put a clause in your contract that says, I reserve myself the discretion as a supplier to provide the service or not. Okay? You cannot say, I refuse to compensate for loss arising out of these things indiscriminately. So there are opportunities that a bank or any sort of supplier in a contract could limit their liability for various losses. The extent to which this liability is limited will reflect on the nature and price of the product. Things that offer more full protection are going to be more expensive than the things that limit all sorts of things. But the way in which the extent of limitation, the extent of variation from what the client is expecting, this is controlled through these instruments. So you can have a look at the Consumer Rights Act, and you can have a look at the Unfair Contract Terms Act. That will give you that information. In addition, now you've got obligations on clear and understandable language. And this was something that was both present in the consumer regulations before, but now is expressed in various areas, especially for financial services. So my complaint against my travel is going to be that they sold me something that included protection for cancellation, right? And their terms and conditions are not clear because it says compensation for cancellation, A, B, curtailment, subject to the conditions. So the way the various conditions go to the curtailment, not cancellation. And when they sold the product, they said you protect cancellation up to £5,000, all of that business. But when you go to claim, they say, no, cancellation is only medical reasons and death and stuff like that. It's like, that's not what it says. So there's an issue, there's a structure, it's not an issue with limitations of liability, there's an issue with the structure of the contract and complying with the requirements as to clear, understandable language. Yeah? So all of that stuff is informative of what suggests fairness, and this is a kind of post-contract control, if you want. Because, as we said, banking services are regulated at the point of entry, both in the sense of the providers and the type of products. The terms and conditions themselves, if they're not compliant, then after you got trouble, after you get it into the contract, you can use all those tools in the law to try and get away from it. What happens is, if the bank is trying to rely on a clause in the contract to deny you something, and you successfully argue that that clause is ineffective, then the rest of the contract survives, but the bank can no longer link on that clause to prevent you from getting what you wanted. Yeah? So basically what I'm going to try and do with my travel insurance is to say your limitations are for curtailment, not for cancellation. Therefore, you cannot rely on these terms in order to deny me the full extent of my claim. They're going to say no, I'm going to take them to the ombudsman, they're going to think that the cost of it is too much, they're going to pay it. Or I'm going to take them to the court afterwards. I've got no problem taking them to the court. It will be funny. And bad publicity for them, so they're going to say no. We're going to talk about payment systems. This is how you're going to pay for your Black Friday stuff. Now, there is so much discussion about checks because obviously checks were the way to make payments before other types of plastic money and all of these things, and before obviously electronic type transfers. So a lot of the case law and a lot of the legal explanation as to remote payments is based on checks. Now, as to the use of the checks themselves, these had reduced in the UK up till the point that they wanted to stop them. And they issued an announcement that said, because there was a drop in the usage of checks every year and it was going towards zero. So they thought about it and they said in the mid 2010s, that decade, they said, okay, we're going to stop checks altogether, there's no point. And then the use stayed stable. So it stopped dropping. So it seems that there's a core of activity that is done by check that remains static. So the big usage fell off, but then there's a base usage left, so then they decided to keep them. So now they said it's going to stay on. They were about to phase them out, but they're continuing them. And now the bank, if you open a current account, will ask you if you want a checkbook. And you might need a checkbook for what? What's the only thing you need a check for now, really? DVLA. Yeah, they only take payment by check. Okay, good thing they don't take it like gold coins. Yes, if what you want to do is through a paper application, you cannot put the credit card. You cannot pay by credit card. You can only pay by check. So that, and if you're a charity user. So in certain countries, not everywhere, not here, but in certain countries, a bounced check is a criminal offense. And that scares people. So that's why a supplier that is holding a check, they think that they've got more leverage on the customer, because if the customer does not pay, they go file suit. I used to do this when I was doing my training in Athens. I used to go to the court and sue people for bounced checks. They've left the checks. So then you run to the court and you sue them, and then they have to deal with it as a criminal issue. And as we said, nobody enjoys being chased after by the police. Yeah. Now, we understand checks effectively as bills of exchange. Now, what is this idea of a bill of exchange? Bills of exchange comes from, it was the way to make payments over time and to allow different means for these payments other than cash, right? At the time that most of the transaction was done with cash. So you've got the Bills of Exchange Act of 1882. It defines this as an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future a certain sum of money to the order of the bearer. So if you hold this, and the difference between bills of exchange and checks is that the checks need to be made to a particular individual, okay? At least now. The fact that the checks are now crossed means that they are only for the payee. So it is only the name here that can cash in that check. And also UK banks will not give cash. You can only pay in checks into account. So if you're not the account holder, you cannot cash in a check. So you need to go to your bank, give the check, and they will put the money in your account. They will not give you cash, even if you're a customer in the bank, right? They will not give it to you in cash, and they will not exchange a check for somebody who is not a customer, absolutely not. And this is a recent change, and it has caused some issues for tradespeople, that somebody would go and cash in quite a lot of checks, but now they refuse to take them. They need to be on in your name and in a specific account. You cannot do it on behalf of others. Yeah? And it's a security issue because there's a lot of stuff that can happen if you're exchanging these things for cash. However, bills of exchange could be the document on its own upon presentation. So it is the bearer of the document that has the right to exchange it for the stated value. And also it can be transferred, because it's not on a named person, it can be transferred from one person to the other. In other jurisdictions, when you can endorse checks, you could write somebody else's name at the back and give it to them. So when I was working in my grandfather's shop, we had a lot of checks that were like completely random people, yeah? And he would write at the back, he had all sorts of names, because one person would pass the check on to the other. So initially it was in my name, but then I would give it to you. I would write at the back, I am passing this to that person, and then you would write, I'm passing it to that person, and one person would pass it to the other. So this is, of course, a risky business, because you're passing on a liability that belongs to some kind of ultimate person that if you don't know them, you don't know whether they're credit worthy or not. But for a regular between people who were trading with each other regularly, this wasn't a problem. They say, I got a check from that guy. Is it okay for you? They were just passing the checks instead of cash. The various tradespeople. It was just to avoid having to go to the bank to queue to get like a significant amount in cash and then to bring it over and put it in the till. And there were also security issues with that, not having a lot of cash flying around. And back in the day, cash was also kind of bulky. Yeah, my grandfather had a safe that was big like this, and it was stuffed with cash. Because the value of the currency was rather low, so they ran in the thousands. So when they had to make big payments, my grandfather was in there, blah, 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 and he could count them in his fingers. Now we cannot count. We touch a tenner and we cannot even hold it. Okay, but back in the day they were used to this. So he would take like a wad of cash like this and go. I thought that was fascinating. Yeah. So equal to the idea of bearer bonds. You can have a bond that is for a particular individual, meaning that you can cash it in for the value, or you can transfer it if it's a transferable bond. But you also have the idea of bearer bonds. So if you find it somewhere, you can go and cash it in. Which is also when you buy some old house and you take down the wallpaper and you find that at the back of the wallpaper they've got old share certificates or bearer bonds, and then you can run to the bank if the bank still exists. That's why. If you're taking down a wall and you find anything by Goldman Sachs, call me. So there we go. Now, so we've seen what a bill of exchange. Now, the technical meaning of a check is also defined in the Bills of Exchange Act of 1882. A check is a bill of exchange drawn on a banker payable on demand. And then you got the variety of the checks on a bank account. We already talked about the endorsement. Now, what is the clearing process? Now, here we got a bit of an issue. The money needs to make it through from one person to the other. If I'm paying you cash, you get it, then that's it, end of story. There's no intermediary. No chance of hiccups in the process because there is no process. I count the cash in front of you, you count it yourself, they're correct, we take it, that's that. However, the whole idea about bills of exchange and checks is the fact that there's a remote process. What happens if the other bank doesn't send the money? So you deposit your check in one bank, the bank will contact the bank of the other person. If they've got enough money in the account, this is the customer's mandate that we were discussing last week. The bank is obligated to send the money over. So for you to be able to take that money, the bank needs to take the money out of the account of the person who wrote the check, send it over to your bank, and then they need to deposit it into your account. So the remoteness of the transaction means that there's time involved and there is some opportunity for error. So you need systems that both facilitate the transaction, create the avenues of communication between the banks, but also systems that can make this more fluid and more predictable. And what you have now is with checks, perhaps there aren't that many intermediaries, but things have become a lot more complicated when you're looking at transactions with cards. So there are many different types of cards. And you perhaps, I don't know, maybe you got more payment systems than you used to have in the past, but you've also got less in a way. What is the logic of a card? A card allows you from your bank in your bank account to the store with which you're trying to make a transaction. So instead of writing a check, I mean, the initial creation of this was, instead of writing a check and giving it at the shop, you can give something that is recognized and understood by the shop that will have the same function as giving them a check. Initially, the process of paying on a credit card was similar with the checks. You guys are too young to maybe. Did you ever do a card transaction on a paper form at the end of the month or whatever it was? Or, you know, like every few days somebody would take all these slips of paper to the bank, and then the bank would check that this is appropriate and go through the same process as you would have with a check. The arrival of electronic communication systems allows this to happen faster, but you've got different types of cards and different functions within those cards. The key difference is between a debit card that links to an account and operates directly out of the balance of that account, meaning that if you got money, it'll pay, if you don't have money, it will automatically reject at that point. And a credit card, which has a preset balance, you can enter into transactions, and then you settle this by invoice, depending on how you do it. Most of us have a monthly connection between some account and our credit card account, that the money goes to. So, usually the credit cards either they will bill you every month, so they spread out the payments, and then you have to pay some interest on that, or you can settle your entire balance at the end of the month without any interest. But the thing is, this is to facilitate you to it's the availability of credit that you get with a credit card and the ability to pay in the future, which is a service provided to you by the bank, not the shop. Because the shop could also give you the opportunity to pay with installments, which you could do with whatever forms of payment you have. You could go there and give them cash every month. But the credit facility offered by the bank is between the bank and you, is not done by the shop. The shop gets its money right away. Now, how do you deal with the flow of information and the flow of money from one to the other? And this is where things now are getting a little bit more complicated. You need a facilitator, because the bank, your individual bank, does not have the system that communicates with the shops. The bank will will offer you an account, will offer you a card that goes with this account. Perhaps the bank will offer an equal account and the machine to actually do the transactions to the shop, but each individual bank cannot have its own system of communication. This used to happen in the past when you had very few banks that did this type of transaction, and everybody had American Express and so on, because it was the bank that provided you with a card, provided the account to the shop, provided the machine to the shop, and dealt with the whole transaction from one end to the other. But now you've got too many banks in too many places, so you need a facilitating infrastructure. The facilitating infrastructure is offered by MasterCard or Visa or American Express. There aren't that many, right?
Yeah.
So you've got Amex, you've got Visa, you've got MasterCard. But the ones that now we're familiar with in our everyday activity are those. So what do these guys do? These guys, each with the banks, provide the communication system. So you are the customer, you got your bank card from your bank that is participant in this network. The merchant got their bank account and their payment facilities from their own bank that is also participant in this network. And because everybody participates in this network, the transaction can communicate the information and the money can pass from one to the other. However, you now have a problem because you've got a series of people in between. You remember for the checks, the banks were communicating with each other. So to build a system that says you deal with checks in that fashion, which deals with issues of delay, perhaps concerns about insolvency of one of the parties and so on, then you only had the customers and the two banks involved in the business. Now you've got plenty. You've got the customer, you've got the store, you've got two different banks, and you've got the facilitator in the middle. What happens if solvency event or a liquidity problem within this chain? The thing is, the system cannot operate if there is a risk of disruption. What you need with cards that you did not have with checks is the immediacy of the settlement. So systems have been created that allow the instantaneous transaction, and somebody needs to bear the risk of that transaction not completing. That risk cannot be at the end. It cannot be the customer or the store that bears the risk of a breakdown in the chain. So the risk is held by the facilitator. Okay? And that's why, so in situations where you have a central clearinghouse that assumes the risk of failure at some of the component parts of the system, and that's why there's a cost in using these services. Okay? Because
this is only for payment.
the stock markets, yeah.
It's only for payment.
The stock markets, yeah. But this is an important function, and also it allows for the development of communications and electronic systems, allows for the instantaneous connection. And also the systems that buy something. Now that I was in Athens, I went to the supermarket. I've got a basket full of stuff. Right? I put the card, put the PIN number, wrong. Bollocks. I must have punched it wrong. I put the PIN number again, wrong again. I'm thinking, shit. Then I realized I changed card. Right? So you had the new PIN number. I'm thinking, okay, I'm not gonna do this the third time because if I get it wrong again, I'm screwed. So I pay with cash. I have just enough. Yeah, otherwise I will start throwing stuff out of the basket. I go then to another shop. I'm thinking, okay, let's try the card because now it's a different machine. I'm gonna get another 3 attempts. I'm gonna figure it out. Put the card in. It says you're on your last attempt for your PIN number. So you see how responsive the systems are. Not only it communicates in real time with the bank, because this was a debit card, so it communicates in real time with the bank to authorize the balance, but it also communicates security functions that are involved with the PIN numbers and things like this. So luckily, I got it right, so now I've got another 3 attempts to get it wrong. Well, I mean, if you're talking about compatibility of systems, then yes. I mean, they're all made to work together.
Yeah.
But the thing is that this is too big a task and too spread products, providers, jurisdictions, so it needed a central facilitator that is independent of all of this. So that's why you got MasterCard and Visa as the predominant standards that provide the service. But of course there's a cost to the service.
Yeah.
And what I was trying to demonstrate is that the cost is not only the cost of maintaining the infrastructure, it's also risk. A risk of failures in certain parts of the system, and a risk that the bank has communicated the money, to the shop, and then they realize that you didn't have the money in your account, or there's some failure or some cost. You know, you have your credit card, right? Your credit card has a certain limit. You need to settle that balance. If you don't settle that balance, you owe money to the bank might suffer a loss. This is usually the reason why there's a fee in using the credit card, both either in terms of an annual fee or in terms of the interest that they charge if you select to pay with installments, because that is a reflection of the risk of default. But the improvement in the systems means that these now operate, electronic transactions operate in an instantaneous fashion. It is being improved at the request of the regulator. Because one thing is the technology, and the other thing is the desire of the bank. What happens if the transaction is not instantaneous? What happens is the bank holds your money. Okay? And while the bank holds your money, it can do stuff with your money. This money doesn't just kind of sit there, it is an available balance. So when the bank takes 5 days to cash in a check, it doesn't mean that bank A is waiting for bank B for 5 days to send the check. That means it got the money, it's just sitting on it. Yeah? So with electronic transactions, if there were a few days to clear, the bank would be holding on to that money. So effectively, it provides liquidity to a bank as the bank delays the transaction. Once the technology allowed the instantaneous transfer, then the regulator obliges the banks to improve the speed of payments. And that's why up till a couple of years ago, when you were sending payments through your online banking, they would appear next working day or a couple of days after. Now they appear immediately. But what I'm trying to demonstrate is that this is both an issue of infrastructure and technological capability, but it's also a matter of regulatory demand. Because the banks would be perfectly happy to hold on to money for 2 days. Actually, I'm quite shocked that I'm sending money from one account to the other. I log in, send it, log into the other one, like 5 seconds after, and the money is already there. But, yes, on online banking it happens immediately, but be aware of one thing though. The speed of the transaction doesn't mean that there are no additional checks or that the transaction is irreversible. The transaction is always reversible if an error is discovered in the system. Of course, you could always go and withdraw the money in cash. It doesn't mean that if the transaction is reversed, they're going to ask for it back. Imagine you got £7 in your account, you check your online banking, it's £7,000. You run to, actually no, 7,000, you won't be able to withdraw it anyway. It is 7. You run to the ATM and withdraw it. So now you've got £70 in the pocket that you can spend. If the transaction is cancelled because somebody sent you money in error and they ask for it back, the bank is going to ask for it back, but in the meantime you got the money in your pocket. If the bank reverses the transaction, then it will disappear from your account. So again, it's a play between available balance and liquidity and time and all of that stuff. You need to be careful with your banks to be checking on your online banking the available balance. Because headline balance, this is when you kind of make mistakes as well. Headline balance is the money that you should have in your account. Headline balance will not include transactions that you made 5 seconds ago in a shop, even though you go into PC World, you walk out with a new PlayStation, and it will not yet show on your bank account, even though they've been paid. This ensures they've been paid, but it doesn't show on the headline figure. It will show on your available balance, because pending transactions will be removed from your available balance. Also, a check paid will appear immediately on your headline figure, but it will not feature in the available balance until the check has cleared. So what you're always interested in is what it says as available balance. It might include any overdraft that you have agreed with the bank. But you need to be careful with this, not to be caught out. Because I've been caught out by this a couple of times. So I make a payment, and I was thinking that I just looked at what it said at the top, okay? I make a payment for £500. I get a text message from the bank within 5 minutes, says you're £480 withdrawn. And it says if you don't bring it to zero at the end of the day, then there's a charge for you using an overdraft. Because it just said 500, it said 500, it said like more than that. It's like, what the hell happened? What happened is that I was looking at the headline figure, not the available balance. So the available balance was very little, right? Because it was a check waiting. So this you need to think about
the security, the speed of the transactions, the security of outcome for the shop and the customer, but also how the various bits within the system deal with it. What this means for you as your available money, non-available. This means for you as your available money, non-available money, about the reversibility of certain transactions, but also what it means about risks of default within the system and where something happens. Also, for those of you interested in data security and kind of IT issues, there are concerns here now with the stability in terms of IT security, because if there's a failure here, then the whole thing falls apart. And you have it often, right? Lately you've had, yes, a bank having problems, so anybody who holds machines or cards associated with this particular bank, they're having the transactions decline because this does not respond in the system. Or even worse, you can have a failure here. If you have a failure here, it would be a worldwide stopover for that particular facilitator. But of course, the facilitators are more robust than the actual banks, but these are complex processes with many bits and bobs, and as it goes with complex processes, they tend to fail, and the higher the usage and the higher the complexity, you have issues. I mean, I was discussing with some gentleman who works for this. He actually works for the IT systems that support these, that facilitate those transactions, and he told me it's a horrid, you know what, it is always going to be a horrid mess, because you have the incorporation of new technologies and new systems upon older ones. So this is ongoing. So you cannot have a state-of-the-art system that covers the entire chain. Somebody's working on older stuff, somebody's working with newer stuff because the newer stuff is coming in. Somebody's working with newer stuff because the newer stuff is coming incrementally. So the system is always inherently unstable because it incorporates these different things that are not necessarily very compatible with each other. The thing is, and the job of the regulator in involvement in this is to making sure that overall the system can withstand stress and doesn't totally fail. So you will have the occasional bank that from one time to the next is not going to work properly. Advice to retail customers is to have accounts with more than one bank, so you've got like an alternate card that you can use if in need, okay, or to carry some cash around. It's less fun when you get mugged. The job of everybody is to ensure that any failures are not long lasting. So a bank can suffer a failure for a day or two, or their own online banking not working. It's unpleasant. The bank might be obligated to compensate people who suffer losses, because if they cannot fulfill the customer's mandate due to an IT problem, that's their problem. Yeah. So people who could not make transactions, lost deposit for houses, lost payments, they had to suffer charges and penalties for missed payments, they get compensated by the bank. But the systemic failure across the system, which means that the facilitator has gone down, this is more severe. And that's why it doesn't really happen. Now, and that's why it doesn't really happen. Now, and also the expression of these in the law is that you got stuff like the settlement finality directive, which deals exactly with these mechanisms, so the mechanisms of ensuring that the end of the chain is protected in the final thing that we can talk about. And now we've got other types of payment facilitators as well, things like Apple Pay, Google Pay,
Samsung Pay,
and all these things, PayPal. Now, these offer similar services with your traditional bank services, but they don't operate on the basis of a card in the traditional sense. Right? But now again, you could argue that it's the same as the card, because the technology now turns your electronic device into a bank card by having the ability to communicate. It's just that your facilitator in that case is not Visa or MasterCard, but is Apple Pay. So this is, again, the infrastructure. So where you had MasterCard at the top of the building before, now you've got Apple Pay or PayPal. Their process is the same.
and the regulation and functioning ought to be the same. In a way, I've been told that using your, if you got the NFC on your phone, so you can use your phone for contactless transactions, it's actually more secure than using the bank card, because there is a representation of your card on the phone, meaning that that cannot be replicated. So if I steal the information from your card, I can make a dummy card with this information, but I cannot make a dummy card out of the token. Consumption is a regressive tax, because, and it's called like that because it hits everybody indiscriminately of their ability to pay. So if you're a rich person or if you're a poor person, VAT doesn't care. VAT is going to be the same level all the time. So obviously, if I'm a rich person, I don't care that my pasta costs £1 or 80p. But if I'm a poor person, the 20p that is the difference between one and the other,
It's progressive.
theoretically, the more income you have, the more you pay in tax. Now, apart from the fact that if you make a lot of income, then you've also got very clever accountants that can present it like you don't have any. That's how big corporations and big kind of high street names, and ranging from Amazon to Starbucks and so on, there's always complaints that their tax exposure is very limited because their income exposure is very limited because their income tax bills are very low. And you're thinking, how the hell these turnovers and their income tax is very little? How come, seemingly very, very rich people end up paying very little tax when, anybody who's just a payee gets like huge chunks taken out of their paycheck every month? But anyway, that's a discussion for a different day. The importance is that income tax will take more money out of you the more wealthy you are. VAT will not. Would it be an alternative or a component of the tax system to impose a tax on the transactions themselves, meaning that the people who move more money pay more in tax because there is a small chunk taken out of about every movement of money that represents this tax. So we're not talking about tremendous amounts. I mean, the financial transaction tax is meant to be like a fund. I don't think it could work instead of all the other taxes. It could be in addition to all the other taxes. So it kind of perhaps reduces some of the taxation burden someplace else, so they can use that money in order to give it back to somebody else or to spend it on something wonderful like Brexit. So a financial transaction tax will hit the people who move more money, because if I'm moving £1, I pay. So if I'm moving £1 and I pay 1p, okay, it's not a lot of money. But if I'm moving like £1 million and I pay 1p for every £1 in that million, then there's a lot of pennies there. Yeah. So obviously, the higher the volume of the transaction and the higher the frequency of the transaction, the higher the burden of this. There's a big debate as to whether this is something that we should do or not. Obviously, the industry does not like it. The financial industry is not in favor. It might require countermeasures, meaning that you need to reduce availability of cash, because if you impose financial transaction tax at high levels, we might start having people moving suitcases around. Because I might be thinking, if I give you my money in a suitcase, if I give you £1 million in a suitcase, I save myself like £100 in that tax instead of sending it via the bank. So it might engender a return into a cash economy, which you do not want, because cash is difficult to control and facilitates criminality and money laundering. But cash now is very strictly controlled. But anyway, this is something to debate. Other people are saying that this is progressive, so some countries, I mean, this now chart is perhaps a year old, but some countries are in favor of it, some countries are not. Each one of these things that sounds lovely, but it's never going to happen. So I think the impact of this is going to be severe for the banks and the industry, but on a personal level is going to be quite small. So if the government came around and said, we drop VAT 1%, it won't. You know what? If I told you that, if I said you give me £100 in cash, or you send me £100, I will receive in my account 99.9. Now, why am I talking about multinationals specifically? Because multinationals is a very significant component of what companies are like in reality. because we've dealt with things that go kind of up and down the size of corporates. Some of the stuff that we do, of course, apply to everything regardless of size. But the bigger you get, then you start to have slightly differential treatment. I mean, I know that in this country everything is dealt through a single statute. In some other countries, you've got the split between the smaller companies of the private nature and the bigger companies, whether they're public and listed in the stock market and so on. Here, we don't have this distinction. But even if it is not a legal distinction, it's a de facto distinction. And when you're going through the bigger stuff and you start to talk about multinationals, you begin to come across issues that are not really contained within the treatment of national company law as we've seen it, neither are they fully captured by the rules of the stock markets and all those requirements that we've been discussing. So there are some issues about how are multinational corporations distinct from your standard type of enterprise, and how are they regulated at national and international level? How is it possible to hold these corporate groups into account when they engage in behaviors that are unwelcome, let's put it that way. And there are some significant issues with tax that we need to discuss, both because taxation is an important part of the corporate world and corporate organization. Very often, I mean, we've been looking at stuff from a company law perspective, but in reality, a lot of the decisions about choosing business structures have to do with tax exposure. So we need to say a couple of things about the tax implications of organizing businesses in particular ways. And it's also a rather hot topic internationally, because a lot of companies are accused of not contributing in tax as much as they should be. What do I mean when I say corporate groups? Nothing that you see around you that is a big structure. Corporate groups are how multinational corporations are organized. You don't have like a single enterprise that operates across borders under a single registration. And that's why this links up very nicely with the things that we've done at the beginning of the module, corporate personality and limited liability. So a lot of the stuff that are problematic today can be traced back back to the days of Solomon and this seminal decision that caused like an unending number of consequences in the organization of. So what you see now as big multinationals, they are groups of companies that contain loads of subsidiary companies incorporated in different places that they all work together in looser or more tight formations. And what is also interesting is that the brands that you are familiar with, retail environment, might not actually belong to a company by the same name, because these brands change hands all the time as well, or they might represent different corporate interests put together in different ways. So who's heard of Alphabet, for instance? Did you know that Alphabet is the thing that owns Google? Yeah. Because Google reorganized its corporate structure a few years ago, not that long ago, a few years ago, and they created a new umbrella company that is the head of the group. It is now one of the multinationals in the world, okay? And under the Alphabet company are the various subsidiary structures that are the various aspects of Google. So the Google that you know is just one of those. It's the thing that does the search engine, and then you got YouTube, and you got all the other companies here. But there's lots of other things that have to do with research and development, that have got to do with infrastructure, that have got to do with financing of various things. So it's a very, very large corporate group. And some of the other stuff that you're familiar with, again, they operate in a variety of jurisdictions and contain a lot of stuff. Yeah, I started getting people writing their dissertations, for instance, and talking about things like Mondelez and so on. And it is, again, big relative corporate structure that has purchased a great deal of brand names. Now, the brand name is not equivalent to the corporation. I mean, a corporation can operate a series of different brands. It's not necessary that the brand is also the corporate name, or that there's a very distinct connection. But it gives you an impression of how the stuff that you see around you are coming under different corporate umbrellas. And the brands might change and go from one to the next. What this implies is that you've got very complicated corporate networks that are very, very extensive and contain a series of subsidiary companies both within and without jurisdictions. This is of interest to us because most of the time the head of the corporate structure is based either here or in the US. Right? So it is an issue for English law if a big multinational corporate group is headquartered in London. This does not mean, of course, that all the operations are running out of London or all the subsidiaries are English law registered. Talking about when we're saying regulating multinationals. First of all, why would you want to regulate multinationals? Because you're regulating, every company is regulated at the place of registration. This is how company law is organized on a global level. At the point that an entity is incorporated, it is the national law of that place that deals with issues of regulation of that corporate structure. So if you're incorporated here, you're regulated by English law. If you're incorporated in Paris, you're regulated by French law, and that's about it. That should sort things out. The problem is it kind of doesn't when we're talking about multinational corporations, because the head of the group might be someplace, right? And not necessary, but it's possible that it's actually quoted in a stock market in that place of registration. So you could have a company that's got its headquarters in London, so it is incorporated under English law, and it is listed in the London Stock Exchange, but its operations are not going to be here. Its operations are going to be all over the world, and they're going to be run under subsidiary companies that are perhaps owned or partly owned or fully owned by this corporate parent. And this is how it's through the ownership that the system is built. You've got somebody at the top, and then they perhaps own all the shares in a subsidiary company that operates and is registered in another country, that operates itself, has all the shares of different subsidiaries in other places. So it is through shareholding that this control is exercised, right? The parent is the shareholder in the subsidiary company. But of course, as you will know, the consequence of the separate personality and limited liability is that the company that is someplace else, even if it is fully owned, that all the shares are owned by the corporate parent based here in London, it is a separate company. And if something goes wrong with that company, then you cannot go after, that's the whole idea behind limited liability, you cannot go after the parent. So even if you know that, BP, the petrol company, has got a fully owned subsidiary in Nigeria, and something blows up down there and kills a bunch of people, you won't be able to say, it is the fault of the British company, just on account of the British company being the sole shareholder. You need additional things. We've explored this when we were looking at Adams and Cape and the problems that they had in lifting the corporate veil in getting the parent who was here in England to compensate the people who suffered the consequences of the subsidiaries' actions abroad, right? Now, why do we want, so this is how they're structured, and this is why you've got these jurisdictional gaps between one and the other. But why do we regulate them? Well, we want to regulate them because we want to minimize these negative impacts. Do we care that there are any negative impacts? This is also, or maybe we don't, on a personal level, but on a national level, there's been a decision by the legislator that we should be concerned. And perhaps it is a matter of, there's a political consensus, and in fact, to be fair, there is a political consensus that there should be some attention paid to the behaviors of British multinationals abroad. So you will not find many people within any of the parties that takes the view that we should just let them do what make money, and that's good. So even if they engage in horrible violations, we're okay with it because they're profitable and that brings money back home. Nobody's going to say this. Even if they think it, it's actually not very nice to say. So you will not find a lot of people who publicly go around saying stuff like that. They will normally hide behind something that says, yes, okay, this is a bit nasty, but if we come down on them too hard and we penalize them, then people are just going to do business with the French. That's what they usually say, which is code for saying we appreciate the extra profits that they're making and bringing back home, and we don't particularly care how they make their money. But there is a cross-party support for the idea that we should find ways to influence British multinationals to behave in better ways abroad. And the same exists in the United States as well. The crucial question is how to do it. Because as I told you at the beginning, at the place of registration. So if it is incorporated in the UK, it's incorporated under English law. If the Nigerian subsidiary that's incorporated under Nigerian law does stuff, then it's a matter for Nigerian law. So how can you get to them? Crucial in understanding how to get to them is understanding and appreciating the divide between national and international law. Now, international law has as its subjects the states, not individuals, not corporate entities, not private parties in any event. So even if you have a national treaty that says this thing is bad and it is banned and it's prohibited, this does not create directly enforceable obligations on individuals. You cannot go and prosecute somebody because there's an international law that says you're not allowed to sell this. Yeah? This international instrument or agreement or whatever it is needs to be reflected in national law, and it is only national law that creates rights and obligations. And also there is a public-private divide. Some stuff are meant for states and state actors, some stuff are meant for private parties. So you should be very careful not to confuse these jurisdictional divides, not to confuse something that is international and public with something that is national and private. Since we're talking about multinational enterprises, we're talking about private enterprises, so if you need to get them to do or refrain from doing something, you need to do this through national law with national enforcement mechanisms. Which of course presents then this issue. What is the sort of thing we're talking about? Look, if we take the example of corruption and bribery, right? You've got the OECD. The OECD is the Organization for Economic Cooperation and Development. It's a kind of multilateral organization. And they have got a convention on combating bribery. There's also a UN convention against corruption. Both of those are instruments of international law. This is of a more binding nature. This is of a lesser binding nature. But these are for states, right? So if states have signed on to those, it means that they will try to operationalize what you find in those conventions, what you find in those instruments. But you cannot go and prosecute somebody on the basis of the UN Convention. You need this to be reflected in national law. How do states do this in order to catch multinationals and kind of grab all there is in various places? Well, one way to do it is to convince everybody who has signed on to the convention to have appropriate regulation and enforcement of that regulation at national level. But it's not gonna happen. The reason why you've got extensive abuses and horrible stuff in developing countries is because they lack the institutional capacity either to pass this legislation or to enforce legislation once you've got it in place. Okay? So, you know, there are horrible things happening in Syria. It would be idiotic to say that if Assad changes the law, then this is going to have any impact. The man doesn't even have control of the whole of the Syrian territory. Okay? You can say this about a whole bunch of states that do not even have physical security control over their territory. You know, you can pass laws about, Sudan or something. The government, or Afghanistan for that matter, the government controls the capital city and a couple of villages outside. So you can pass all laws you want. A factory, or you got a mine operating in an area that is either lawless or under control of rebels or whatever it is, and the business has some sort of arrangement with the people over there, how are you going to enforce any laws that are passed by a national administration? You cannot. So you need something else. So you need to find a way to overcome both the international-national divide, but also to overcome enforcement and jurisdictional issues within the states themselves, even when they pass the law. So one solution is to use national law at the home country, where the multinational is coming from, in order to discipline their behavior abroad. So expressions of this are the US Foreign Corrupt Practices Act and the Bribery Act here in the UK. So the purpose of these pieces of legislation is to criminalize behavior that takes place abroad at the instigation or for the benefit of a company that is based here in the UK. Still, you get into trouble because the companies are going to try and hide behind the local subsidiary. So, Siemens gets prosecuted for corruption, artists or somebody like this, they say it ain't us, it was the local subsidiary, we know nothing about this. So, we have standards and procedures and so on, but look, the local managers in, country X, they went around bribing all the doctors in order to get the drugs, in order to increase their sales figures. This is really totally horrible, it wasn't us. So you still get into trouble. However, having these statutes on the books does give the prosecuting authorities here some leverage and some power to chase after companies for inappropriate behaviors that are happening abroad. And if you've got this, you can overcome a little bit the problems of the corporate veil. So you can structure legislation in a way that says, we don't care through which kind of corporate subgrouping the harm has taken place. If it is part of a corporate group, we will hold responsible by default. And we don't care actually how it happened through which corporate structure. It is possible, okay? But it requires legislative will and then enforcement powers and the will to enforce these things in the jurisdiction. It's not always there. Because sometimes you pass these things, but enforcement then can be very problematic because the prosecutors either do not have the time or the desire to devote attention and resources to prosecuting these things. But that's one way of bridging these divides, public, private, national, international. And you said you want to do this, you want to regulate them because it is possible that the behavior of multinationals has got very negative impacts. They could be engaged in gross human rights violations. You've got a corporation that engages in human rights violations. You've got like one of the petrol companies, they're extracting oil in Nigeria, and when the local community complains about pollution, they kind of pay the generals there to go and shoot everybody. So these are all behaviors and attitudes that there might be an interest in trying to prevent from here. Now, the way to do it, and this is a mistake that usually students make, they think that there's like one solution to it all, and if you just pick the solution and do it aggressively enough, it's going to solve stuff. No, it cannot. Because this is a multi-factor problem that involves both legal considerations and economic considerations and things like CSR that we were discussing last week. So these avenues to change corporate behavior in general, right? So to push them towards better ways to react. And you need these three things to work at the same time in a coordinated fashion. So the attitude that says, oh, well, if we want something done, then we should change the law, it is naive because it ignores jurisdictional barriers. The attitude that says they should all be nice, because it's a kind of ethical imperative, is also naive because not all of them want to be nice, and also, this doesn't work in the same way in all contexts. Relying on economics and consumer pressure and all of that stuff also works only because not everybody is subject to the same consumer pressures in the same way. So what you want is an effort on all three sides. You want the law to change, you want both cooperation at the international level, and then you want whatever agreements are being reached to reflect themselves into national legislation and to be some attempt at enforcement. You want the extraterritorial application of one's own laws and standards if these are better to the extent that this is achievable. You want that. So you want a hard law that then you can use the prosecution to go after people. At the same time, you want the pressure from economics, and you want the pressure from consumers, and you want the idea that all companies internalize the fact that a positive brand can only be built if they show engagement with stakeholder interests and all these things. And at the core of this, what bridges all these together is the idea of CSR, which means that you have corporate culture. So some pressure from the law, some pressure from economics, but also an internal dynamic, an internal desire to be more engaged with stakeholder interests. And if all these three elements are present at the same time, then it can lead to an improvement in standards on an international level, starting from the behavior of multinationals that we can get our hands on, the ones here, but then you can move on. If something becomes the global standard, then everybody tries to emulate that standard, right? So it causes a shift in perception overall. And this, in fact, there's good evidence that the discussion about CSR has become embedded now in everything. 20 years back, it was a novel concept that people didn't take particularly seriously, or they used it only as a marketing exercise. There's evidence now that this is leading to change in corporate cultures, in reality, right? Fine, let's talk about taxation. What about multinationals and taxation? The basic idea behind taxation is that you are taxed at the point that you've got, at the place where you've got your activities and at the place where you generate your income. You will know for your personal incomes that you pay tax on what you earn at the place where you earn it. The issue with multinationals is that they are spread across a variety of jurisdictions. So obviously, they will try to minimize their tax exposure by building their group in a way that is the most tax efficient. Now, there's nothing wrong with that. In exactly the same way that if you're not tax resident here, because you're here for study for a few months, and if you open a bank account and you would like to receive the interest, these days there's no interest, but if there was interest and you wanted to receive the interest without, you would send a letter to the bank saying, I'm not a resident here, I'm a resident in France, so they would not deduct the tax from your interest, right? So you can choose depending on your circumstances, sometimes you can choose where you're tax resident and you're taxed over there. If you had more beneficial tax allowances in another jurisdiction, maybe you want to be resident there. Multinationals, because they've got a presence in a variety of jurisdictions, it is easy for them to choose whether they're tax resident, and they will pick the jurisdiction where they've got the less exposure. And compete on this. And this is the link with Brexit, okay? If the UK is outside the EU, then it's got more leeway in offering corporates tax and regulatory incentives. Because they're not part of the EU, they'll be able to say, if you come and settle with us, you can pay less tax in a variety of things that European countries cannot offer you because they're all obligated to do the same thing. Or, we will lessen the regulation or something in one place or another that the Europeans are not able to do because they've already agreed to do stuff in a specific way. So it offers more options. Now, how does the multinational actually take advantage of this? Say that this company is based in London, right? So the parent is in London. But operations are in a variety of places. So they generate income in a variety of places. If you can shift the income on the place that has got the lowest level of tax, then you will pay a much less amount of tax. So if you have a choice between, say, 3 jurisdictions, and one's going to tax you at 20%, this is 10%, this one is not going to tax you at all, then obviously you would like out of your group structure to show that, oh, here you're not making that much money, oh, here you're not making any money at all, you've got a loss, but here you got all your income, and as luck would have it, that's the place where you don't pay any tax. So that way you can get it all in. Now, how can a corporate group arrange a way, manufacture a way that shifts the profits from one location to the next?
They do this by internal transfer price, by pricing. It's called transfer pricing. So they will trade between the subsidiaries. They will arrange their prices for the trade between them in such a way that generates excess profits on one end and losses on the other. So if this were a coffee chain, because there's a lot of debate about Starbucks and so on, okay? So if this was a coffee chain, and this is the highest, this is the middle, and this is the low tax jurisdiction. Obviously, this is the rich country where people come and buy your coffees for £3 or £4 pop. And all the income is, all the money is generated here. How can you show the money is generated here? How can you show these guys as a loss? One, you get them to buy their coffee from this one, and you make the coffee very expensive. So, even though these guys are having all the turnover, it shows that they're purchasing their inputs from these guys and these guys. They're paying out a very significant amount of money to the other subsidiaries. So, in the end, these poor people, even though they've got a high turnover, they're actually making a loss because they're paying so much money for their inputs. But these guys here are making a killing because they source the coffee really cheap and they sell it for a fortune to these guys. So if turnover, all the customers are here, the income has been shifted to the low tax jurisdiction. And that's how they all do it. Right, so Amazon, that's a big logistics company, can shift around the costs by this internal pricing. So they can demonstrate that in the places where they've got lots of turnover, all the customers are in Western Europe, actually they're not making a lot of money. All the money is getting made by the company that provides, like, the software infrastructure that's somewhere in the Caymans. So all these internal transfer pricing mechanisms result in the ability of a corporate group to shift things really nicely and show that the money is earned someplace else, so they pay money someplace else. Obviously, the revenue here isn't happy about this because they shouldn't be. I don't know if they are, because it's not like the government has done anything about it. But other tax collectors in other countries are not very happy with this. And they're thinking, hang on, here this is a scam. How is it possible that the companies or multinational groups that have got so much activity and are making so much money in our country actually have paid no tax at all? So, all of you here are paying tax on your earnings, right? I'm paying quite a lot of tax. In fact, tax and national insurance contributions and all of that stuff. How come we're making all this effort and the likes of Amazon and Starbucks and all the rest of it don't pay any tax in the UK? What the hell is that? And then you have to go and convince them to pay something, and they kind of go, yeah, okay, we'll give you a few million. No. If all your business is here and all your turnover is here, you should pay proper. Now, how do you do this though? That is something that requires a degree of coordination. And after the financial kind of big summits and big statements about how they're all going to get together and deal with the problem of tax havens, bah ha 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 ha, and they didn't do anything about it. Because of course it's their own money, they're not idiots, okay? So out of the stuff, have you heard about the Panama Papers and all of these things? They came out, out of hacks and things. Who has the money where? And it turns out that all the politicians, all the industrialists, everybody who supports them, anybody with money really, has got the money in those places. Right, pretty bad this. But that requires, so on one level, some international cooperation to shut these things down. Some countries are responsive. Switzerland, for instance, Luxembourg have changed dramatically their legal structures to address concerns about the transparency of the money, to deal with issues of tax evasion, to deal with criminally procured funds and so on. They've changed this very significantly over the years, and now they're fully compliant. So it can be done, but also you can change the way that you actually arrange the taxes internally. There's now a big effort to start taxing people for their turnover, so that you're actually taxed when you're generating the economic activity, as opposed to where you can manufacture the appearance of a profit. So these things are complicated, but there are the mechanisms to do it, and tax systems are evolving in that direction to address this issue. Now, why is there a link between this and Brexit? And that's where we're going to finish. The problem with Brexit is that, so if you're pursuing a policy that is obviously bad for the nation and is going to seriously harm everybody, including the corporations that are operating in this nation, how do you sell it to them? How do you get them to stay? Why shouldn't people say, well, okay, this is going to harm us, we're going to lose money, therefore we're going to go someplace else. So what do you tell these people to keep them going? The only thing you can tell them is that you're going to compensate them somehow for the losses. And the only way that a state can compensate people for the losses is either by giving them state aid or reducing the regulatory burden, meaning that they don't have to spend so much money in compliance, or you reduce the tax. So the problem is, as regards taxation, if you're talking about entities that are mobile and can go anywhere in the world, if, of course, there's some cost in moving operations left and right in restructuring, but if the benefit or the avoidance of a much more significant cost is the issue, then they're going to leave. Unilever just left. So they were headquartered here in London and they went to the Netherlands. And the reason is not only Brexit, it's like a whole variety of issues, but Brexit is not making any better. Now, in order to keep them, you're going to have to give them some incentives. In order to give them incentives, unfortunately, the only things you can offer go against all efforts in improving the regulation of multinationals, both in terms of behavior in general, upping regulatory standards or creating incentives here to get them to behave abroad. This goes out the window. Additionally, any attempt at improving tax collection goes out the window, or to making them stop these transfer pricing schemes and so on. So the bizarre situation is that the only way the government can convince companies to stay, despite the loss of business that they're going to have and the hassle they're going to have because of Brexit, the only thing they can offer them is kickbacks, primarily of the taxation type, and perversely, this is the one thing that the Europeans will not accept, because that would be bad for them. So they're not going to go for it, which creates an impossible conundrum. So the government, in order to sweeten the Brexit pill, needs to kind of stop the effort that has been happening all these years in these areas to improve those standards, including improving taxation issues. But if they actually do this in order to hold the corporations, they're not going to get any deal out of the Europeans, which ensures that then the outcome is going to be so bad that all the corporations are going to leave anyway. So if you go ahead with it as it is, you're going to lose quite a lot of them. If you try and give them incentives to stay, you're going to lose all of them. But this is how this situation all links together, ladies and gentlemen. And this is stuff that is relevant for company law, both because of the good links it's got with our discussions on CSR and our previous discussions on separate corporate personality and limited liability, but it's also good for you to know as informed citizens of the world, that Teresa tells us is a bad thing, but if you're going out for job interviews and stuff, they're not going to ask you what your favorite color is. They might ask you something about substance of what's happening in the world. So being able to give some sorts might improve your chances of employment down the line.